must, but
so when I speak, I don't need fantastic, because I took this with me.
Yes, because that's why there are
Ką jūs
people who
paleistėte
will
visiškai dabar žiūrėk, kamera nusukta į salę, ne? Tai mes lengvų rangų bet toks modelis gali būti.
Dabar jau prasidėjo transliacija. Nes čia tik pradžią
Tai viskas čia dabar. Ką mes dar galim padaryti, mes galim padaryti biurį ir pradėti jau rekordų dėką. Viskas dabar jau viskas.
Šito lango negalima turėti, ne?
Galima. Tiesiog čia yra nuoroda, kuriai turėtumėte įsidėti, sudėti nuorodą, jeigu paštą savo pasidėsti. Šiaip visi, kas registruoti universiteto paskyrą, jie mato, ne?
Ten panas sakė, kad nėra mūsų subscribers ar
Kokia lačia paštas yra? Ne tavo vakarykštis? Tu bandai prisijungti.
Kyla abejonių man. Čia mes nečia.
O negalima tada atsiųsti man tiesiog? Bus paprašau.
Pasirašyk.
Jo, man sorry.
Kontroliuoti sudėti. Nuorodą pakarėti.
Because there are actually tendencies that in particular in countries service providers who speaking for law has been and now the service providers
Viskas, galima uždaryti milšį.
Tai dabar šitą full screen. Dabar speakeris
Mikrofonas. Čia visą laiką turi būti šitas įjungtas ir kažkas vienas iš tenais. Nepamiršk čia paspausti admitą.
O kaip yra žmonių prisijungusių? Zoom'ą turime.
Find a solution for that.
and the same for example somebody saying okay very narrow thematic expertise and so on. But everything else like research or documentation gathering. This is not
So you mean that it would be split?
So what we are doing is you give there are this and there are service providers who want to provide for much cheaper price. And they are going to see that there are 5 functions that some workers in the middle function. Because you pay for very expensive for some functions which are really not worthwhile and paying so much money. So there are all kinds of issues.
So we want to see a lot.
Yes, and we're also talking a lot about the digital integration next week. This is very challenging topic that we are developing in this university. but also on legal technologies. So next week we are going to have conference on legal technologies. And the legal community is very, very conservative.
Yes,
Yeah.
I know. I mean, I was working in the field of combating trafficking in human beings and I worked with more or less with judges and prosecutors in Turkey at that time. And of course, my role from human was to protect the victim. And with the technology, I got much more and better solutions. Not to be in the same room. I mean, from that angle, but of course, that would be a challenge for everybody. It's also good things we want.
So, like in the courts, for example, they're really advanced here. Many criminal cases, they do not allow distance hearings, for example, in our cases. It's going on, and we have not really stopped. So, the problem is just the system is somehow
Yes.
Like traditionally, technology is only doing the current time. Yes, I think we have to do some more time.
Like again, when the test was actually showing like have you been
Not in Würzburg, I think last year it was another building. Right? Last year it was another building.
Yes, it was in our laboratory building, but there we have about 70 up to 100. But right now, the current capacity according to the device is much lower. And then we don't have to go the record. We don't have microphones. So basically, you have to send it every time.
Yes.
Like, this is good enough. That's why we decided to use this home. So, you know, and explain the spaces.
And then it made you cancer.
Yes, now, that means that you can see the document. So we make sure that this kind of institution, we want to become one of us. This is considered according to the requirements. That's why we use the bigger room, we would become empty. But it's much better
Yeah,
make sure that people feel comfortable.
there's no risk in taking chances, you never know.
Exactly, and as I said, big organizations.
Yeah.
You know, one single case and.
Exactly. Yeah, back home in Norway, there's 2 universities that are pretty hard to get where we have over 100 students.
So they started not online, but.
They also have some hybrids, but I think it was on some social events arranged by the students where you have a big cluster.
People are more
Yes, exactly.
you know, things so much. Yeah, because in our colleagues from the university, law schools don't do not start they start immediately online with students, and we don't have people, we have people apparently possibility to use.
Yes.
Many students now. This is just used to be like a so the pathway of lawyers now we have quite a small.
From the council ministers.
From the university here to Kohan.
Hi, nice to see you too.
So actually, good. And our in July, I will want to do it because we enjoy to learn once a week online. Then we switch to online.
So we request for online.
Yes, many of them will try. Before I really like it because we didn't know we was starting the day because before we had very developed systems in Moodle and how and so on. So it was a challenge of the actually. Somehow students feel like and we didn't feel very well. So then we switch. For foreign students, we do everything online. Except those we prefer to come here and so but there are actually one. But otherwise, we do here for broadcast. Then of course we can join online and what's online. But of course, as well, we won't be able to continue online because we have also not online. Yes, there is a percentage that you have. So we expect that's why now we are doing more as much as we can. And also we hope that.
So it ended up.
But nobody wants to do people
Could you go back? But you want to fly?
There's also a way for one reason we are trying to do our best. I think that before that will use some of the professors to do online lectures. I need somebody to make me up for me. Or you know, with some creative so fast. No, because everyone will make like if you continue to whatever it is, the students will then you will I think we have to be a lot of more or less precisely as the time has
I think I saw you on TV in some interviews at the phone you were saying that.
outside and all everybody.
I didn't have a question.
Because it's not there. And I spoke about really different. Research on impact Maybe Or you can make it and we usually issue because it's a long conference, or we can, yes. Just to mark and
Nice to meet you.
okay, let's see on the Oh, yes. Sure. So she was,
I think you know, this is what we do. We don't do it. Yes. Choose the same.
He promised.
Could be,
Tu lyrą užba turi.
Kaip?
Mūsų baraką turi?
Ne. O tu siuntėjai savo?
Nesinčiu, aš noriu.
Ai, aš tai neturiu, nežinau.
Good morning, dear colleagues, dear guests. On behalf of Mykolas Riomeris Law School, I would like to welcome you to this already traditional, because it's a second conference on business and human rights in this university. We are trying to establish the tradition in a way, because I think some also on. Okay, I will try to speak calmly, because okay, I hope it's much better now. So we are trying to establish tradition in this university. Okay, let me try again. So as we are also broadcasting our conference, so I need to speak, and all of us who are going to speak, we need to speak to microphones to enable also those colleagues who are online to hear us and what we're saying. We're trying to establish a tradition in this university to address the issues related to business and human rights, because we carry research. We do have researchers who are interested. We do organize various events where we discuss most relevant issues related to this topic, and we also cooperate quite a lot with Lithuanian organizations on this particular topic. Now, our conference is taking place in a very challenging time. I don't need to repeat it, but what I want to say that the topic that we are analyzing is also very challenging topic. And it is challenging natural because of that we as businesses, they don't want the state to interfere into anything, and that's best for businesses when the state does not interfere, allows them to operate and so on. On the other hand, states do have the obligations under international law. Businesses do not directly have obligations under international human rights treaties. So the states, the governments are facing a challenge how to implement those human rights obligations if businesses is not involved, because business is also one of the very important actors that has impact, either positive or sometimes negative, on the human rights protection. So it is a big challenge for the states to engage businesses in human rights issues, and that's why we think it's really important to explore this topic. Now, again, we might say if there are no obligations for businesses on the basis of international human rights treaties, why should businesses care about it? But we, at the same time, we see that there are raising expectations in the global markets,
and be it a Lithuanian company that is operating outside Lithuania or even inside Lithuania only, still it deals with global supply chain, it deals with access to investment capital and so on, where the requirements are really raising. And this is natural because there are all kinds of risks related, but also opportunities related to human rights. So businesses, I think, cannot say right now that we don't really care. It's not an issue for us because the expectations are raising. And even though we talk about expectations, we see that those expectations are also turning into legal requirements. So it is important to see how these expectations will transform in the legal requirements that will be mandatory for business. And yesterday I was listening to the EU Commissioner for Justice, Didier Reynders, and he was very confident. He was doing a keynote speech for the European Law Institute, one of the most prestigious organizations, legal organizations in Europe. And he was very determined, and he was saying, for sure, we are going to include mandatory issues for businesses. For next year, they are going to launch, the European Commission is going to propose measures on mandatory due diligence for much broader, on much broader scale, because right now it's applicable to certain sectors, but the Commissioner was really very, very determined when he was speaking about engaging businesses in human rights and also assessing their impacts, be it positive or negative. So we are pretty sure that this topic is not a one-day topic, that it's going to continue, and there is a value of discussing. Using this opportunity, I would like also to say that this year and a little bit previous years, we had the privilege as university, as researchers, to be involved also in the development of the Lithuanian policy on business and human rights, and in the development of a new, which is a second national action plan on business and human rights. So we are very grateful to the Ministry of Foreign Affairs for this engagement, because if in all fields we would have academicians coming with scientific proof, with scientific evidence, with scientific commentaries of many issues, then I believe the policy decisions would be also much more well-grounded. So we have this privilege. Thank you very much. And again, using this opportunity, I would like to express gratitude to our partners, as I mentioned, Ministry of Foreign Affairs, to co-organize this conference, and the Nordic Council of Ministers office here in Lithuania. So thank you very much to our partners. Thank you very much for everybody who has come either in presence to this discussion, and also those of you who are online with us. So I will stop here, and I will invite the main organizer, Arnas Liauksminas from Mykolas Romeris University, who is also the main researcher on business and human rights in this university, to tell also some practical aspects concerning the conference, but also to invite our guests and for welcome address. So all the best in the conference, and I wish you very, very interesting and useful discussions. And I need to do this for the next speaker.
So good morning, everyone. It's really nice to see all of you here, despite all the problems, all the difficulties, because when we started to organize Business and Human Rights Conference last year, we started it only in spring. We had only a few months, and I thought, like, okay, but we did okay, but we did it happy. We were happy for the first time. And this year we had very ambitious. We started in January with the first talks with Lina Janušauskienė from Nordic Council of Ministers. We started talk with Professor Lyra Jakulevič, and also with the Minister of Foreign Affairs. And then in February, we got the COVID virus, and we still thought they were like, okay, it's far away, it's in China, okay, probably Northern Italy. we should not be touched. However, all the things changed rapidly, and we had to change the conference for a few times. The days were moved from May to June, and later we thought maybe we should postpone it for 1 year. But finally, we did it this year, and we're really happy. And my way to business and human rights started with a few main people. It's one of the former MEP, Leonid Donskis, who once wrote in his report on human rights around the world. He wrote that there is a thing about human rights in the world. I thought, okay, that's quite interesting. And then he came to Professor Leroy Klash and said, yeah, that's quite an interesting topic, and you should to work on this more. And I started to analyze and think and research more and find more people. Started to go to United Nations Conference on Human Rights in Geneva, and I've gathered many ideas, and I thought, like, okay, that's time to do it here in Lithuania. So I do not want to take too much time, and I would like to invite Helen Nilsson, the director of the Nordic Council of Ministers Office in Lithuania, to share a few points about this conference. And yeah, floor is yours.
Thank you very much. And we need to put some energy into the microphone. I will do the same for the next speaker. So yes, I am Helene Nilsson. I am the director of the Nordic Council of Ministers office here in Lithuania. So also from me, good morning and warm welcome everybody to this interesting event on business and human rights, and more specifically the national action plans on the implementation of the UN guiding principles on business and human rights. Nordic Council of Ministers, if you didn't know that from before, is the official body for intergovernmental cooperation for Denmark, Finland, Iceland, Norway, Sweden, as well as Greenland, the Faroe Islands, and Åland Islands. Development and growth in the Baltic region accounts for a large proportion of our international work. And cooperation with the Baltic countries focuses on issues such as strengthening welfare and democracy, digitalization, environmental and climate issues, Agenda 2030, of course. But I also would like to mention human rights development, corporate social responsibilities, women's rights, peace and security, children's rights, climate change, renewable energy, cybersecurity, and open government. And I think you will find the same wording in the, so to say, background information about the national action plans. Denmark, Finland, as well as Norway and Sweden and Lithuania have adopted the national action plans on the implementation of UN guiding principles. And we will learn more about that today, listening to experts, among others, Denmark, Norway, Finland, and in the last panel also have representatives from Sweden and ENACT that I know very well from before, and glad to see you in this event. I will not, of course, go into details, but let me give you a few examples to emphasize the Nordic engagement into this important work. All 4 countries with the action plans have been highlighting them in the voluntary national reviews in each country's report to the UN on the implementation of Agenda 2030. This has been presented at the UN High-Level Political Forum on Sustainable Development. The Danish Institute on Human Rights has developed a business and human rights country guide to Denmark. The Institute has also developed a toolkit to provide guidance on developments on the action plan and to support a number of states to implement their action plans. On July 17th this year, 2020, the United Nations
Human Rights Council adopted a resolution by consensus aimed to increase the focus on the implementation of the already mentioned guiding principles on business and human rights. And the negotiation process leading up to the resolution was headed by Norway. All the Nordic national action plans has a regional focus, but they also have an extensive international focus. The international focus entails both recognition of how international organizations and standards push for greater respect of human rights, and also gain to ensure that the businesses respect human rights, not just, so to say, at home, domestically, but also abroad. I and my organizations want to be part to build Nordic-Baltic movements for meaningful and inclusive co-creation and dialogue in the field of business and human rights also in the future. I hope you feel it. And we are happy to support development and promotion of new partnerships in the Baltic Sea region through our activities and projects. And before we start our today's event, I also would like to thank our partner, the Ministry of Foreign Affairs of the Republic of Lithuania, as well as Mykolos Remeris University, as well as our speakers, the experts, the moderators, moderator. And at the same time, wish all of us, wherever we are seated, a very fruitful conference. Thank you. And more energy.
Thank you, Helen, for great introduction to our conference, and we're really happy to see you here. And before starting the conference, I would like to share the greetings from our Vice Minister, Nerijus Gediminas, who really wanted to come to the conference, but due to all the engagements, he couldn't come. So I will try to do it with the help of our... Whether service has certain technical issues, you will hear an echo, but I hope that you will understand the main message. So,
Participants, ladies and gentlemen, I want to request today on behalf of the Ministry of Foreign Affairs. Under international human rights law, states have an obligation to protect legal rights and human rights. UN guiding principles for business and human rights and protect respect and equity provide a roadmap for a global economy human rights, comprehensive respect and and just, peaceful, sustainable future. Other important OECD grants for international enterprises must provide non-binding principles and responsible business and development. Since business and human rights issues are becoming a global priority, more and more companies are recognizing their corporate responsibility to respect human rights and implementing human rights due diligence. Also, let us not forget the 2030 Agenda for Sustainable Development, which is grounded on social justice and human rights. Lithuania, being part of the international business community, cannot stay outside of the global process and should also make improvements. We encourage ministries and other state institutions who are more actively engaged promoting business respect for human rights on national level. Cooperation in this area is beneficial for business, as well as trade unions, since meeting international standards is crucial. The first business and human rights plan adopted in 2014 was aiming to address those issues, however, needs to be updated since situations have changed greatly, not to mention latest pandemic development. We expect that new ideas will be addressed in this second national business and human rights plan that currently is being developed and will be discussed in the course of this conference. I would like also conclude wishing participants of this conference constructive dialogue and fruitful discussion on the just way and solution for protecting human rights in business. I cannot reiterate enough the crucial cooperation between state institutions, business, trade union, as well as academia. This is essential since only just action, joint action, can bring beneficial results for all stakeholders. Working together, we can make those ambitious commitment achievements. Thank you for your attention.
Thank you, Vice Minister. And we will try to solve the problems with sound in 1 minute. Yes, so we will try to solve the problems in a few minutes. Just do not have any echo via Zoom platform. Just to be sure. So the next speaker, we invited Professor Karen Bouman from Copenhagen Business School. And we've met her last year, I think so, in the United Forum on Business and Human Rights. And just before we talked, we changed a few emails, and she invited me to join the Business and Human Rights Initiative, an academic or interdisciplinary platform that joins professionals who work in the business and human rights area. And it was after the meeting with her in Geneva, I just realized that it would be very nice to see her here in Vilnius. And actually, we expected until last Friday that she will come, but unfortunately, situation in Denmark is is not very good with the COVID virus in Lithuania too, and she had to cancel her flight. But we're very happy that she is able to join our conference and give the plenary speech about the current developments in business and human rights area. And Karen, do you hear us? And can you present yourself once again and share the screen with your slides?
Anas, and thank you for the invitation to be part of this. Share my screen. So I get a message that the host has disabled participant screen sharing.
Yeah. You're sharing. Yeah. Okay, Karen, we can see you. And do you want to share the slides?
Yes, I just told you that I get a message that the host has disabled screen sharing.
Yes, it looks like we are on 2.
Okay, and now my computer screen just went black, so I'm going to have to shut it down, and I'll probably need to rejoin in a second.
Good. I finally managed to enter into Zoom, this conference, and it seemed that they were a bit delayed, so I managed to listen to Helen's introductory remarks that I wanted to, so that was good. I'm a bit worried.
But you
Karen, just to avoid any problems, I will download your slides and I will show it from my screen, and you just say when I have to change the slides. It will take one other moment. Okay, Karen, so now we see your slides and you can start your presentation, and I will just I will change the slides when it will be needed.
So I'm back.
Yeah, so Karen, nice to see you. So let's work that way. I uploaded your slides on our computer. Everyone can see it. So you can talk. Everyone will see a smaller screen with your face. And then you'll need to change the slides. Just tell me and I will do it from my computer. Okay. I hope so it will work better.
So, okay, everybody, thank you. Well, everybody, good morning, and to the host, thank you very much for enabling and allowing me to share some of my thoughts of this conference. As Anders already mentioned, we met last year in Geneva at the Business and Human Rights Forum, and we met in the context of the Rights Initiative for teaching and research on human rights in an interdisciplinary perspective. And I was very pleased to welcome Anders into this initiative. So this is already an interesting opportunity to proceed with talking about a research topic that can also have implications for research, for teaching on business and human rights, but obviously also for practical aspects of implementation of business and human rights in the future. What I will be talking about is some different issues, benefits, challenges, and balances to ponder, with a view to ensuring improved access to remedy for victims, and in general the situation for victims, as we are looking at the increasing expansion of mandatory human rights due diligence. So I will not be talking about human rights actions plans per se, but I will be talking about an issue that connects with the actions that several governments are already undertaking. And I will be talking about an issue that also is currently high on the EU agenda for business and human rights, which means that it would connect, or it connects also directly to the actions plans of several member states. Next slide, please. So I cannot see whether you've actually changed to the next slide. So can you let me know?
Yes. Yeah, so we change the next slide.
Yes, please change to the next slide. Yes. So I'm not able to see what slide is actually on right now.
Yeah, so now you should talk about the business human rights regime, due diligence, and human rights.
Can you please move the camera up so I can see what slides you've actually got on? Okay. Okay, so the previous slide, please. It looks really, I'm sorry, it looks really weird. So can you take the first slide after the introduction slide, please?
So
that one, yes. No, not that one. Go to the very first one.
Okay, this one. Sure.
Yes, I want to make an overview. See, the thing is that I cannot, it's a very poor connection, so I really cannot see on the slide what it says. So I have to change to my own screen in order to be able to follow that. You may want to think about for the audience that I think it's very difficult for the audience maybe also to watch the slides. So maybe if there is an opportunity to focus the camera would be good. Okay, so a very brief overview of what I want to cover in this lecture. First of all, I want to give a bit of a background to due diligence, focusing it into the business and human rights regime in general, and also the connection between due diligence and remedy mechanisms. Then I want to talk a bit more about what is risk-based due diligence and what is different from transactional due diligence. Then some trends in mandatory due diligence. Then I want to move on to getting us to think about what due diligence and mandatory due diligence is intended to achieve when we adopt the risk-based due diligence approach. Then I want to get us to think about the interests at stake from victims and other stakeholders, so in particular companies. Next, some issues on what happens to due diligence when we redefine due diligence. What are some implications for corporate conduct and accountability and victims' access to remedy? And finally, some concluding observations on issues and implications to ponder. Next slide, please. So first, some on the background concept and trends. Next, please. So first of all, let's just recall where we are in terms of the business and human rights regime. Being at the stage where we can talk about mandatory due diligence is the result of a very, very fast development, and it's obviously a tremendous achievement to be able to put this on the legislative agenda for a major regional organization that is committed to human rights and business and human rights and business, like the EU, to now be considering and having announced to proceed to legislation on mandatory due diligence. When we think back to the fact that only about 20 years ago, the so-called draft UN norms were in the process of being drafted. This was an initiative that was taken by a subcommittee under the then or subcommission under the then UN Human Rights Commission, a group of experts who, based on the emerging recognition in the late 90s that there were considerable problems in terms of governance gaps that allowed business enterprises to take advantage of substandard production facilities in several countries in supply chains to exploit the human rights of workers and local communities, and in that process to cause harm throughout the supply chain. As you probably know, the draft UN norms, they never proceeded beyond the stage of being draft because the UN Commission for Human Rights never adopted them. But then, after having some second thoughts, the states present and represented in the commission decided that there was actually a really good point to having normative guidance for businesses and maybe even go beyond that. And this resulted then in the establishment of 2 mandates, 2 3-year mandates that were charged on Professor John Ruggie, with a background at Columbia University in New York and now at Harvard, who had also been involved in developing the UN Global Compact. So this meant that John Ruggie had also already some experience in moving the agenda on a somewhat conflicted topic, the idea of human rights not just being state obligations, but also something that companies should think about. So this led through a series of multi-stakeholder meetings and negotiations and a number of expert reports, as well as some reports drafted by or written by Professor Ruggie and his multidisciplinary team, to the so-called UN Framework Report. And I always like to mention this because the UN framework was followed then by the UN Guiding Principles that operationalized the UN framework. But the UN Guiding Principles are an operationalization of the framework, which means that if we skip the framework, we often miss out on some of the key reasoning for the substance of the UN Guiding Principles. So I always recommend to students and to others in my audience to read the UN framework if you haven't already done so, and to reread it if it's been a while since you read it. So what the UN framework does is it provides a multidisciplinary reasoning, an overview of the problems of business and human rights, and an argument for the state duty to protect human rights against third-party infringements, so business infringements, an argument for the corporate responsibility to respect human rights in their interactions, so throughout or for infringements that or human rights abuse that businesses may cause or contribute by their own activities, but also activity or abuse in which they may be involved through their business relations. And so we have these 3 pillars: the state duty to protect, the corporate responsibility to respect, and access to remedy. Due diligence is a key part of the corporate responsibility to respect. It cuts across the 3 pillars, but is particularly prominent in the second pillar. Remedy is the 3rd pillar, and remedy is something that both states and companies should address. States through state-based judicial remedy institutions, so courts and similar, and also non-judicial remedy institutions. And here we have one in particular that I'm going to mention several times in here, that those are the NCPs, the national contact points set up under the OECD guidelines for multinational enterprises, because these NCPs are very unique and having extraterritorial powers. And actually they're highlighted in the UN Framework Report as an existing non-judicial remedy institution with unique powers that for many practical purposes can step right in and serve as a remedy institution for business and human rights, saving the problem of being lost in years of negotiations to develop a new system because the system was actually already there. Then we can say that definitely it's not perfect, but it did something and it can do something. Then we've got operational level grievance mechanisms as well on the part of companies. So all this then related into the UN guiding principles, which operationalize again these key issues introduced in the UN framework. From 2014, we've had negotiations on a treaty, a so-called binding instrument on business and human rights. And from 2019 and onwards, we've seen initiatives from with the EU towards EU law and due diligence. And given now we have this rich legacy, but also very, very fast forward movement, what I want to look at here is then some implications for victims and what legislators and scholars may think about as we move towards turning due diligence from a voluntary action into a mandatory action. And the point is here that, of course, it is a tremendous achievement to be where we can talk about having mandatory due diligence. But as always, when law institutionalizes something that has been existing on a softer manner, there are important points to think about as part of this institutionalization process to make sure that the institutionalization delivers on all the good intentions and think about some of the challenges in the meantime or on the road to adequately address those. And in this case, again, for the rights of victims to be realized. Next slide, please. So when we talk about due diligence in the business and human rights context, it's very important to pay attention to the fact that the UN framework introduced a new concept of due diligence, which is then elaborated in the UN guiding principles. This is a concept that we also sometimes refer to as risk-based due diligence, because the OECD guidelines for multinational enterprises has adopted the due diligence concept from the UN framework, but applies it not just to human rights, but also to labor issues, to environment, and some other issues under the name of risk-based due diligence. And the idea, which is reflected both in the UN guiding principles, guiding principle 15, as well as the OECD guidelines, is that this due diligence is a process to identify, prevent, mitigate, and account for how businesses address the impacts on human rights. So the direction of this risk orientation is risk caused by the company directed at society. This is a novel approach in due diligence terminology. It's known from other contexts as an approach, but it's fundamentally different. And I really want to highlight this also to an audience comprising lawyers. It's fundamentally different from transactional due diligence, which focuses on the risk caused by society to the company. For example, this is a due diligence approach that lawyers, corporate lawyers, look at in the process of mergers and acquisitions, and it's the due diligence approach that accountants and financial advisors adopt to protect the company against harm. So there's crucial differences there, but unfortunately it's often not very well explicated. For example, in the EU Directive on Non-Financial Reporting, there is a requirement that companies that have processes or policies in place for due diligence report on those, but unfortunately it's not clear that the intention here from the drafters was to get companies to report on their risk-based due diligence. And obviously this can easily cause confusion with lawyers and accountants who are used to thinking about transactional due diligence, because they will think, well, this is what you already do. There is no need to change anything here. But there is an expectation that companies do change their due diligence focus when we talk about human rights and societal risks in general, from the risk to them to risk that they cause to society. Next slide, please. Obviously, if a company conducts its risk-based due diligence well, it will also be able to protect itself against harm from society. So the title of this next slide should be Trends in Mandatory Risk-Based Due Diligence. What we have here is a mixture between a thematic focus and a general focus, as well as some previous experiences or related legislation. So we've seen this thematic focus with introduction of mandatory due diligence or activities that are the same, that entail the same, even if they do not necessarily use that terminology. with the UK Modern Slavery Act and the Australian Modern Slavery Act, as well as the Dutch law on due diligence in regard to child labor. If we look at legislative acts with a more general focus, we've got the French Loi Vigilance that was introduced in 2017. And we've got, again, in the EU Directive on Non-Financial Reporting, the obligation to report on due diligence processes and policies, no obligation to introduce them, but if they have them, companies should report on them. It's interesting to keep in mind also that we actually have, in some ways, a relatively rich legacy of what we may refer to as risk-based due diligence. Or if we look to the US, the terminology is generally due care. We've got the EU Timber Regulation, which also applies the term due diligence with the societal risk-based focus, although the steps it establishes are not consistent with the UN guiding principles, although the regulation was adopted after the guiding principles were known, and the due diligence of the UN framework was definitely highlighted. Then we've got an old US act on plant and timber import, which was amended in 2008 to introduce due care, which really approximates due diligence. We've got from 2010, the US Dodd-Frank Act, Section 1502 on conflict minerals, which also introduces a due diligence approach to the import and manufacturing of conflict minerals. And then, of course, we've got also in the EU context, the conflict minerals regulation that will soon enter into force, which applies to the risk-based due diligence approach and is coordinated with the OECD Multinational Enterprises Guidelines and its guidance for conflict minerals. So we've got actually a relatively rich body already. Next slide, please. Which will then, we will then be proceeding to what mandatory due diligence or risk-based due diligence in general is intended to achieve. So according to the UN framework and UN guiding principles, next slide, please. The due diligence is an activity that companies should undertake to discharge their corporate responsibility to respect human rights. In other words, this requires acting with due diligence. So due diligence, according to the UN framework, is the steps the company must take to become aware of, prevent, and address adverse human rights impacts. So we've got the entire range of activities or steps that a company action or process will undertake here, transformed into a process to also identify and manage human rights impacts. So in the guiding principles, human rights due diligence, as I already mentioned, is absolutely central to Pillar 2, the corporate responsibility to respect. If we look at guiding principle 17, it says that human rights due diligence should be undertaken in order to identify, prevent, mitigate, and account for how companies address their adverse human rights impacts. So this is another way of explaining what the framework report talks about companies becoming aware of, preventing, and addressing adverse human rights impacts. Also, according to the guiding principles, the process should include assessing actual and potential human rights impacts. So in other words, actual impact and risk. Also integrating, acting upon these findings. So this is obviously a management process. Tracking responses, making sure that responses are there and that they're effective and they're adjusted if necessary. And then communicating how impacts are addressed. Importantly also, and this is also different from conventional transactional due diligence, this process should address and cover adverse human rights impacts that a business enterprise may cause or contribute to through its own activities, or which may be directly linked to its operations, products, or services by business relationships. So here we have, for the latter context, we have something that's actually quite complicated, and it's already been the subject of some of the leading cases from these national contact points that can be expected to be an issue both for legislating due diligence into a mandatory task for companies, as well as considering the remedy implications. Moreover, the guiding principles recognize that due diligence may vary in complexity depending on the size of the business, the risk of severe human rights harm, and the nature of context of its operations. So the guiding principles recognize contextuality in a number of ways here that we'll also be looking at when we talk about mandatory due diligence and the process to get there. And moreover, risk-based due diligence should be ongoing. So this recognizes that human rights issues are dynamic, and also human rights risks may change over time. And implicit in this is also recognition that the due diligence might have overlooked some risks from the outset, or some perception from affected stakeholders, potential actual victims, that mean that the risk actually occurs where it might not have looked as if it would occur, or might not have occurred in another context where human rights risks and issues might be perceived in a different way. So again, here we have this very, very high focus on context. Next slide, please. So when we look at, next slide, please. When we look at due diligence, it's interesting to note also that in the literature, there's been a debate in the European Journal of International Law in 2017 between Professors McCorquodale and Bonnichar and Professor Ruggie and John Sherman III, who was a legal counselor to, there's one missing, I think it should be not the third, who was a legal counselor to the John Ruggie and his team. And what's interesting here to highlight at this stage is that due diligence is already a well-known concept. I already highlighted that in the business context, it's known by business lawyers and accountants in the context of mergers and acquisitions. But in the international law, of course, also due diligence is a well-known concept. And in this context, it applies to states. So what Bonnichar and McCorquodale do is they address this fact, the fact that due diligence actually is applied in different ways. They say that they argue that the UN guiding principles invoke two different concepts of due diligence. First, as a process to manage business risk, which is the due diligence approach within companies, which is probably more relevantly addressed under other terminologies, but at least the idea is a process within a company to manage business risks. But the second is a standard of conduct required to discharge an obligation. This is very much the way that due diligence is approached in international law. I think we can fairly say that this is only part of the picture, and due diligence is used also in other ways than this. But the key point of Bonnichar and McCorquodale's argument is that this creates a confusion and uncertainty again about the extent of business responsibility. They indicate that human rights lawyers indicate due diligence as standard of conduct, and this is a key point. Lawyers will typically understand due diligence as a standard of conduct. I think this point goes far beyond Bonnichar and McCorquodale's article, because it ties in with the considerations that we should keep in mind as we look at the process to make due diligence mandatory and at the same time to increase access to remedy for victims. And so Ruggie and Sherman III, they refute this. They refute a number of the arguments, including an argument that Bonnichar and McCorquodale make that due diligence is actually only relevant in contexts where the business has not caused or contributed to the harm, but been involved through the activities of third parties. They say that due diligence applies sort of across the board. So whether a company causes or contributes to the harm through its own activities or is involved through business relations, it is irrelevant. They also say that this context has no implications for the obligations of the company to be involved in remedy responsibilities. And we can take that further to say when we look at mandatory due diligence, which by implication would raise expectations also of access to state-based remedy. This also means that for states also, for state-based remedy, there should be no difference depending on whether the company has caused or contributed to or been involved through a business relationship in the harm. And then Ruggie and Sherman III highlight that the very purpose of conducting human rights due diligence is to understand the specific impacts on specific people. So here again, we have this contextuality. This is very much about specific human rights impacts at any particular time in any particular context with specific victims. not merely to manage commercial risk to the company itself. So this is the key point. Next slide, please. And so this takes us on then to ask, what is mandatory due diligence intended to deliver? It's important in this context to recall and recognize the implications of the point of departure in the guiding principles and the OECD guidelines, that risk-based due diligence is about protecting society against risks caused by business activities and to ensure remedy when there is a failure to prevent harm. Now, this actually entails two stages that may be considered and maybe even prioritized into a stage application or an introduction of mandatory due diligence. We have the aim to advance due diligence processes towards prevention, like an ex-ante approach, with the idea to hopefully fully prevent harm from occurring, or at least limiting it to the extent possible. And then an ex-post aspect, which is to advance access to remedy. When harm occurs or is experienced or perceived to occur, then those who are victims or perceive themselves to be victims have a right then to access to remedy. But it's also important to recognize that there is a divergence of interests. The interests of potential victims or actual victims are not the same as the interests of companies. And this is probably going to be a major issue, and it is going to be a major issue in the coming slides also, to keep in mind in this process of turning due diligence from a voluntary action into a mandatory action within an EU context to advance access to remedy for victims and the legal certainty for victims. Because these are two of the key points. Studies indicate that voluntary measures are inadequate to prevent abuse and ensure remedy, whether procedural or substantive. And so there is a key point of legal certainty here for victims. For companies, there's also a legal certainty issue. Companies are interested in having a level playing field where the same rules apply to everyone, no matter where they operate. And also companies are interested in having a uniform standard of conduct to be held up against. And this raises issues that we will need to consider. And then also we need to, in this context, recognize the difference and the complementarity of dogmatic and social legal approaches. So from the dogmatic approach, we're concerned with what is the law and what is the current applicable law. Like, for example, is there a specific standard of conduct for a company? The sociology of law then looks at how to get where we want to be and what to consider to achieve this. So this difference of approach also uncovers a number of stumbling blocks on the way to realizing the objectives of mandatory due diligence in order to help it deliver on both increased prevention of harm and increased access to remedy. Next slide, please. And then moving on to the interest at stake in more detail. Next slide. So if first we look at the interest of victims, the assumption from the dogmatic perspective is that mandatory due diligence will ensure a higher degree of business activities for implementing the corporate responsibility to respect, so in other words, a higher degree of due diligence to be exercised. And that if due diligence is not adequate and harm occurs, then or is perceived to occur, then there is access to mandatory due diligence based on the idea of alleged non-compliance, so a conventional dogmatic approach to the law. This is at least what can be assumed. Now, the social legal perspective then uncovers a number of issues and challenges in this context. For example, as we already saw, in the UN framework, in the guiding principles, and in the explanation by Ruggie and Sherman III, risk-based due diligence is very contextualized, and it recognizes context. And the reason here is that human rights risks are very contingent on local conditions, institutional challenges, and culture and perception. So the question to ask here is whether a formal requirement for businesses to conduct and document due diligence processes is actually adequate to ensure relevant handling, and what should be taken into account in a legislative process to ensure that the due diligence concept that such a law would institutionalize would be adequate to address these very contextualized issues. And also, it is necessary to consider the situation for victims if a company complies with the requirement, but harm nevertheless occurs or is perceived to occur. because then the company has done what it should do, but harm nevertheless occurs. How to deal with that? And then also we need to consider the difference between procedural and substantive remedy. And I want to ask the question also on whether we should invest more in thinking about whether main remedy is actually meaningful. Can we talk about meaningful remedy, just like we talk about in the guiding principles in the OECD guidelines, meaningful stakeholder involvement? So mandatory is mandatory due diligence an avenue for access to remedy perceived by these victims to be meaningful? Whether we talk about procedural remedy, so the mere access to remedy, and whether when we talk about business and human rights, remedy for business and human rights harm, is procedural remedy enough, or is it necessary to think very carefully about substantive remedy? When I think it's very important to think about substantive remedy due to the extent of harm often caused by human rights harm. But of course, procedural remedy, having access to remedy is important in its own right, also from a human rights perspective. When we think about the human rights perspective, it's very important to think about also about the principle of equality of arms established by the European Court of Human Rights. The fact that the parties in front of the court should have equal opportunities to reach to the court, to present their arguments, and to have equal opportunities in front of the court. And when you think then of two parties, a company, maybe even a very large company with a home base in the global north, access to the best lawyers in London or New York or Paris or Amsterdam or Frankfurt or Copenhagen or Vilnius, and then you think about victims in maybe Indonesia, maybe Colombia, a village in the Democratic Republic of Congo. How are those victims going to be able to present their case in front of a court in Europe within a European legal context in a way that ensures the equality of arms? And the problem is complicated by the fact that the legal rules will not, at least the way they currently are, the procedural rules within Europe will not necessarily allow NGOs to represent these victims. And even if they do allow NGOs to represent these victims, think about just the balance in resources, the ease of the rich company or any company, maybe even to buy the best lawyers versus an NGO that doesn't have much of an income, may not have any income, just has voluntary resources to achieve the same type of the best and most qualified and most experienced legal counsel. If we look at substantive remedy, quite apart from the fact that business-related human rights harm is often simply impossible to repair. Think of the Rana Plaza building collapse. Think of the many women who lost their lives. No matter how much the compensation to their families, their mothers and wives will never be brought back. Or for the people who survived, no matter how much the monetary compensation, their lost arms and legs or broken backs will never be brought back to the way they were before. And if we look also at the experience from agreements under the Alien Torts Claims Act, while it was still in use before the final or the most recent Kirby ruling by the US Supreme Court, and we can also ask questions about the substantive reparation and results. How effective was that really for victims? And then another important issue is if we look at mandatory due diligence as an issue of EU legislation, what types of companies will be covered? One of the experience we have here is that when the EU developed the Directive on Non-Financial Reporting, due to the influence of some organizations, in particular business organizations, the original focus was reduced dramatically so that there is much more limited coverage than the intended objective was from the EU Commission. And also this illustrates power disparity between certain organizations, and especially again here we have business organizations fairly strong, and those who represent victims, typically NGOs, not very strong by comparison for a number of reasons, mainly resources. Next slide, please. So if we look at the legal certainty issue as an underlying assumption and interest from the company perspective, from the dogmatic perspective, we immediately see that there are a number of other issues also indicating the advantages actually to companies. There will be a clearly defined requirement. There will be a possibility for them to document compliance with this requirement. They will be able to work with well-known remedy institutions and well-known processes, so courts or other judicial institutions. There will be for them access to a well-known system for company lawyers and other legal advisors that can be obtained for fees. If an EU law requirement on mandatory due diligence is implemented, there would be similar requirements across all member states, so there will be a level playing field. And to the extent that this has extraterritorial implications for supply chains, the level playing field will get close to global for EU-based companies. So this will be actually a huge advantage, both from the organizational management and the legal perspective. If human rights due diligence as a standard of conduct is adopted, then this raises, I believe, a number of issues that go back also to the dispute between Bonnechar and McCorquodale and Ruggie and Sherman III, not just to that dispute, but actually is well illustrated by that dispute. Because if you think about human rights due diligence as a standard of conduct, if companies have a documented process, does this mean there is no liability? This is also an issue that we also already see arising in regard to the French loi vigilance. Now, if we adopt the social legal perspective, there are a number of issues to ask here in terms of fleshing out mandatory due diligence. I do believe that mandatory due diligence entails really, really important opportunities for victims. But I also do believe that it's really, really important to think very carefully about how to achieve those possibilities for victims in the most comprehensive way. So, for example, some issues to think about is, should businesses have just like a responsibility but not accountability for business relations? How to deal with that, also in view of the fact that extraterritorial legislation might look attractive for the EU perspective, but imagine what the situation will look like in Bangladesh or Indonesia from their governments if the EU starts to regulate issues within those countries. We turn it around, imagine how happy we would be in Vilnius or Copenhagen or Brussels if Indonesia, or if the government of Indonesia or Bangladesh would start to regulate issues within our countries. Moreover, cases may involve legal systems and jurisprudence outside of the EU. For example, one of my colleagues in another context a few days ago mentioned the situation where we might have tort law, not just in the host countries, but we might also have Japanese tort law. So this really makes it complicated because we would have a diversity of applicable law, and some of this might be more attractive to companies, some might be more attractive to the victim. Then there is, as always, when we have a judicial process where, because it's focused on a winner and a loser, there is a risk of conflict escalation. And the implications here are not just for the victims, but also for the company's relations. If a company is a company that's really serious about due diligence and trying to do right by business and human rights, but nevertheless was involved in harm, a court case might, because of the focus on a winner and a loser and getting the lawyers into the room, might result in a conflict escalation that might actually be detrimental for the company's longer term relations to the local community and to the different partners, stakeholders who were somehow involved in this harm. And so this is another issue to consider also when you redefine this concept. And then there is another issue also important for companies, which is the impact on their social license to operate, not the legal license to operate. They might get acquitted, but the social license to operate, if there is a general feeling that that harm occurred, even if the company can say, but we had our process in place, we can document it, so we are not liable, but there might be a popular sensation that the company still caused the harm that can really affect their social license to operate. So there are a number of issues in here, not least, of course, also the implications for human rights due diligence as a management process also, if it becomes construed as a standard of conduct. And because here we actually also see a potential conflict between operationalizing this into the way companies act, and then trying to develop a standard of conduct where many companies might be more interested in being able to get acquitted than to actually fully address and see harm from the victim's perspective. Now, moving on to then gradually summing up on these aspects of juridification. Next slide, please. Sorry, I forgot to mention this one. So this was what I just covered. Next slide, please. And next slide, please. Okay, so this is where we are now. So how to approach due diligence in legislation and mandatory due diligence? Of course, there are obvious experience also here from already existing due diligence legislation in the UK, in Australia, in the Netherlands and in France. But some of the key issues to consider are then, should it be like a standard of conduct or having a process in place, or should it focus on the outcome to identify and manage risk and harm, and how to marry these? Because ideally we would probably need to have both in place. For remedy, what sort of institutions and outcome? Should this again be as the idea of a standard, or should it be a focus on an outcome? So if the focus is on a standard, and then non-compliance would lead to access to remedy, but would the remedial institution really look at the outcome, which would be the situation of victims, and not whether the company was able to document a process that maybe was inadequate? This is, I believe, a major issue to be considered. And then, of course, the complexity of introducing EU-based remedy for harm occurring extraterritorially and in very different contexts, how to deal with that in a way that is adequate to the perception of the victims and the meaningfulness for the victim. We can also consider the fact that remedy institutions act with extraterritorial powers already exist. These are the OECD national contact points, and also some national human rights institutions have similar activities. And this could, in principle, present the opportunity to start by introducing due diligence as an activity for companies to be undertaken on a mandatory basis. So in other ways, legislating and juridifying the ex-ante perspective, and then because the judicial issues of introducing access to remedy legal to judicial institutions might be very, very complicated. So this could be introduced maybe in a second step. This could also correspond well with the UNGP's focus on prevention and a process that is ongoing and responding to dynamics. It would also give time to learn on how to implement mandatory due diligence in a way that works with victims and companies in regard to their not necessarily aligned interests, or they're actually sometimes very conflicting interests. And so on this basis, let's move on to the next slide, please. Looking more at challenges in regard to judicial remedy. So here the obvious conflict is, of course, that we are working both with home states and host states, and both of those might want to insist on sovereignty and existing principles of extraterritorial legislation being a rarity. There is nothing in principle that means that countries cannot introduce extraterritorial legislation also in regard to business and human rights, but there are obvious reasons, obvious challenges to consider when we think about the fact that it actually hasn't happened very much. Some of these challenges could be, if we look at the EU, there is here a combination between civil law countries and foreign and common law countries. Would this mean that civil law countries would need to adopt principles that are born out of and practiced in common law countries, like the forum necessitatis or forum non-convenience, or even look at jurisprudence from common law courts, because some of those, especially in the UK, but also other common law countries, have been actively engaged with business and human rights cases already. Then there is a focus on torts or economic compensation. Is this really adequate to provide redress? Because human rights harms often cannot be repaired, because an economic compensation may be inadequate or inappropriate to address the harm. And then this raises questions of courts' powers to demand that businesses provide non-economic substantive remedy. The guiding principles recognize definitely non-economic remedy as relevant, but how could courts, what types of non-substantive remedy can courts order? This is another issue. Then an issue if we have a remedy in front of courts. The courts are normally limited from investigating damages and impacts in countries and contexts that differ from the court case. It's usually not the objective of the court to investigate, but just to listen to the views of the parties. And this then takes us back to the reality of victims' access to courts in foreign countries, and victims' own ability to actually document what happened. If we look at the often very limited resources in terms of money, in terms of time, in terms of language, in terms of practice with courts or victims in business-related human rights cases. Equality of arms, some nicely sums up this. And it also takes us to look at the division of roles, because non-judicial remedy institutions like the OECD NCPs actually have some powers, at least some of them do, they're organized in different countries, to already investigate issues and assist victims in presenting their cases. So we might look at the division of roles of the complementarity of judicial remedy institutions and non-judicial state-based remedy institutions, retaining the role maybe of non-judicial remedy institutions as a step that could assist in delivering equality of arms in front of judicial remedy institutions. Next slide, please. Very, very briefly on some of these non-judicial state-based remedy institutions, the NCPs. So, as I mentioned, the UN framework recognizes them also, and recognize 5 typologies of state-based non-judicial remedy institutions. The OECD NCPs are actually highlighted for their extraterritorial competence. The legal basis for NCPs is in the OECD guidelines from 1976, revised several times, most recently in 2011, when the NCPs that were given a remedial function in the year 2000, in that revision, were updated in terms of procedural guidance aligned with the UN guiding principles, and also the guidelines introduced risk-based due diligence. So NCPs are in principle a strong organization, but there are also several challenges. Because they're state-based, states have flexibility in how to organize them. And this means that there are at least also 5 types of organizations, some more independent than others, some much more resourced than others. And the issues around this in terms of access to the remedy for victims and effective remedy have been highlighted several times, both by the UN framework report and by several OECD studies, also with the Office of the High Commissioner. Some of the strengths, if we want to look at that, is that the NCPs can introduce their good officers. So in other ways, they can help through mediation or conciliation to the parties resolve the issue. So that means that they take an active role. And given that many of these human rights issues involve some already existing relationship between the parties, it also means that it can now actually help de-escalate the conflict and result in win-win solutions, as we know from the social legal literature in general from mediatory approaches. And this has generally been highlighted as one of the strengths. It is not something that always works very effectively with NCPs in different countries, but there are interesting cases showing that it actually does work and can even result in the company paying an economic compensation in a context when this was considered to be relevant. Moreover, NCPs can, apart from the fact that they also have powers to do their own part to investigate the case, they can issue a final statement in which they're empowered to include criticism of a company's conduct and or recommendations for future action. So obviously, this is a very important role in shaping company conduct. Just like we can expect from court cases, this could also shape company conduct in the future. There is, however, quite considerable application or diversity in the NCP application of final statement competences. It's mainly the NCPs in the Nordic area and the Netherlands, the UK, that use these powers. So there's definitely also room for improvement for NCPs to step into these powers and use them more effectively to provide effective remedy, both in an ex post and ex ante perspective. Next slide, please. So just looking a little bit at the case law capacity of NCPs, there are a series of cases that we could consider as leading cases because they have assisted in clarifying what we expect of due diligence. For example, in the transport sector, the case Raid versus Dasair from the UK NCP. There is a case with POSCO and the Norwegian bank clarifying that minority investors do have an obligation to exercise due diligence in regard to their investments and the human rights impacts. There is another case also involving the Norwegian NCP and the Swedish NCP, clarifying that even if there is no actual violation, there is here a recommendation for company to ensure that it involves and considers the principles of ILO Convention 169 and free, prior, and informed consent. Free, prior, and informed. What's the C? I forgot the C. FP in relevant contexts. Consent in relevant contexts. And then there is the Heineken-Bralima case with the Netherlands NCP that involved a lot of negotiations on location in Eastern Africa and led to compensation for employees that had been fired by the Bralima brewery. So NCPs can actually make a difference in this way. Next slide, please. Now, if we then look at the potential intermediate or maybe even permanent role of NCPs as remedy institutions as complementary to judicial remedy. First of all, if we consider a stage introduction of mandatory due diligence, where first of all, it would be an obligation for companies to conduct effective due diligence, and the second step could then be judicial remedy. Under the first step, NCPs could retain their current role as state-based remedy institutions for human rights due diligence because it actually exists. But it would also be very important then to consider how to increase the effective operations of NCPs across the board, because as I mentioned, some are more effective than others, and some are better staffed, some are better resourced, or some are better resourced, some are better organized. So there's a lot of learning here for NCPs to work on. The capacity for NCPs to address due diligence under EU law might require specific legal basis. This might be obtained through national legislation or maybe an amendment of the OECD guidelines, another revision. The benefit would be, mean that NCPs could retain the potential use of good officers, except for the cases of gross violations where it's usually not very useful. So this could retain the option of win-win solutions and ensure try to prevent a de-escalation of conflicts. We would retain the option that the remedy institution could help investigate overseas actions on location, or in particular in a way that addresses the potential but huge gaps in equality of arms between victims and companies. And they would there would also be the potential that NCPs could recommend that if they find that a violation of the guidelines or inadequate due diligence has taken place, then they could recommend that the case could be reviewed by a court at no cost to the complainant, to the victim. And this could then enable the court to then, for example, compel the company to pay out economic compensation, or maybe even, if relevant, non-monetary reparation. Now, if we look at the next step, when judicial remedy for due diligence might be introduced, the question is then, would these NCPs be abolished? And this would hardly be the case, because they will remain relevant and in place for other issues under the OECD guidelines. So they will probably, they will remain in place. And the question then is, could they still play a role? Could they still be complementary to deliver effective remedy? The question here, one is to consider whether they could still play a role in providing for equality of arms through the powers they already enjoy. Whether there would be the benefit to victims in particular to retain NCPs as an optional remedy opportunity with their current powers for parties if the parties so wish. Obviously, courts might also be equipped to try to help the victims reach a conciliatory approach. But in this case, there could be some benefits in looking at the experiences of NCPs, what works well, what works perhaps less well. Could there be access to courts if mediation was unsuccessful? That could be another way of using that complementarity to start out with mediation if it's unsuccessful, as in many cases it is, or companies just don't want to be part of it. Then the next step would be access to courts. And then NCPs, through their powers to be to their extraterritorial powers in various ways, could maybe also assist in establishing a well-informed basis for an enforceable court decision that would again consider this meaningfulness of substantive remedy in the context of victims. So, so the bottom line is there's a need to also carefully think about ways to combine the strength of the non-judicial as well as the judicial state-based remedy mechanism. Next slide, please. So final concluding observations, implications on issues to ponder. So again, moving to looking at mandatory due diligence is a huge step that we've got there really, really fast. Maybe there is a good opportunity now to slow down a little bit and say, think about the implications and the implications of fulfilling, from the state perspective, the state duty to protect by ensuring observance towards the aim, which is protection against human rights harm caused by third parties and ensure access to remedy. That so far the states have not been too involved in this, and maybe now it's time for them to think about the a clever social legal approach to a dogmatic juridification of mandatory due diligence, to ensure that due diligence is not limited to a formal process, but retains the ongoing process focus, that it retains the strong focus on preventing harm, to also consider in terms of remedy, the necessity of providing adequate and effective remedy, because there's several studies and civil society organizations also highlight that at least some NCPs do not deliver on their promise to victims. The fact that companies want a level playing field, they want uniform due diligence requirements. There is a strong legal certainty argument here. Legal certainty applies to all, but the differences between the interests and implementation steps for victims vary very much from those of companies, because a level playing field is not necessarily what would translate into effective access to remedy and prevention of harm, also through the due diligence process for victims. If we move to effective remedy, again, remember to think about the effective implementation of equality of arms, how to ensure that, to also prevent victims to be double victimized by not having adequate access to remedy, not just in terms of formalities, but also reality. And then finally, to consider the complementarity of strengths of state-based judicial and non-judicial remedy institutions. Are we looking at an outcome, how to deliver ideally a win-win situation, rather than having a winner and a loser? Because the loser might just be the company, the loser could also be the victims, and then again, it would be far from the situation that is the reason for the background for due diligence, of course, presuming that there was an actual abuse of human rights. The necessity to consider cultural differences that affect procedural and substantive remedy, not just in terms of legal culture, but also social cultures, and the necessity to consider also cultural bias, for example, from the Western perspective. Financial compensation is usually what we work with, but there are cases and experience that it may be contextually adequate, and insisting on a fairly largeable or large, contextually large financial compensation may end up in cultural context in a double victimization of the victims that was obviously unintended. So thank you very much for your attention. Any comments that you have, you're more than welcome to send me by email. And I will look forward to onward conversation as well as the rest of this conference and the other presentations and debates in the conference. Thank you very much for the opportunity to present.
Thank you so much, Karen, for a wonderful presentation and in-depth analysis of this question. I do believe that it gives us a lot of food for thought for further discussions. And as we have like a lack of time, I would suggest to continue to the next session, and afterwards, if we will have some time, we will make a discussion. And the next session is closely related to Karen's presentation. We will talk about the tendencies in the business and human rights area. We will have two panelists here. It's Andrius Bambalas and Indra Vareikytė, and also Christopher Pass and Bate from Norway. So I will ask Christopher, I already saw that you are connected to the conference. I will, as we have some technical issues, I will put on my computer your slide, and you'll be able to discuss the main issues that you're interested in. So Christopher is the member of European Corporate, is a member of European
Coalition.
Justice Coalition.
Yeah.
Thank you, Christopher. And they are one of the experts, the leading experts, who analyzes the tendencies in the business and human rights area, also analyze the questions related to national action plans. And I asked Christopher to share his ideas about the legislative trends on mandatory human rights diligence in the European Union. So Christopher, floor is yours.
Thank you very much, Arnas. And thank you very much, I'd like to say, first of all, Karen, for such a fantastic presentation. It's really refreshing to see such a comprehensive and contextualized...
Could you try to share the screen from your computer first?
I can do that for sure. Yes, I will do that when I need the map.
Okay.
At that stage. Thanks. Just to say that it's very good to have this contextualized approach and to not just be focusing, as we sometimes do, on a particular issue, be it remedy or due diligence or reporting in a silo, but to have this sort of bird's eye view and to go in and to begin to explore how these different developments in different areas in the legislature, in administrative or non-judicial, can all start to relate together. That's exactly the type of thinking, I think, which we need to pursue more often. It's sometimes difficult within the restraints of legal design of laws, that lawmakers are restricted in their competences or mandates. But it's precisely this type of thinking of using the whole UNGP context to guide our work and how these developments can work together. So thank you, Karen, and we look forward to hearing more. I'd just like to go through a little bit, as Anna said, to look at legislative developments for human rights and environmental, as we say now, due diligence legislation in the European Union. So first of all, by way of introduction, the ECCJ, or the European Coalition for Corporate Justice, is a European coalition of civil society organizations, roughly 450 NGOs, consumer organizations, trade unions. And we are present in almost all EU countries, but also in Switzerland and the UK. And basically what all of our members pursue are either cases against companies to achieve remedy for overseas and European victims of business human rights violations or corporate abuse, and also the legalization. So what we will look at in this session is where laws have been successfully achieved in the different member states and where they're also proposed, Switzerland being the other case within Europe. And then I wanted to give you all a bit of an update on the European Union proposal for a directive on mandatory human rights and environmental due diligence. So a quick word on the need for legalization. Karen touched on it as well, I think, but just to know from a recent European Commission study on due diligence and an empirical analysis of its uptake by companies, we know that it's around about 20% of European companies are currently undertaking any form of human rights and environmental due diligence. As we can all see, we're in 2020, the UNGPs were passed 9 years ago. The OECD guidance really explaining in more detail and elaborating what is due diligence only came out a couple of years ago. But nonetheless, it's very clear also in the Commission's view and in our view, of course, that it's time for legislation. It's time to ensure that companies are learning and doing due diligence. And just to recap there was also a study, a monitoring study by the German government, which concluded that even less of German companies were doing this. So that is the impetus for a potential German law on due diligence sometime in the near future as well. So I will just share my screen now in order for you to be able to host disabled participant screen sharing, it says. Arnes, if you could either put the map up on your screen or I'll try again. It doesn't seem to be working with the screen sharing on my side. Great. Okay, so it's up on the screen on your side, and I will share this map with you also by email. Anybody who's interested, it's also on our website. So basically, if you can see the map, you can see that there's been legislation passed in 2 jurisdictions so far in the European Union. The first being France with the devoir de vigilance, and the second being the Netherlands. We also have had the German proposal, which I mentioned, which is currently being debated in the German coalition cabinet. We also have a legal proposal in Norway, and we also have this legal proposal which will go to national referendum in Switzerland, so outside the EU. And just a quick summary of the different laws which we have so far. The French law has a civil liability provision. So it's a company law obligation, but it gives victims the right to sue in French courts for abuses happening outside France in the supply chain of the largest French companies. It also gives civil society the right to do preventative actions. So that is asking the judge to compel the company to take measures to develop its so-called vigilance plan. So there's this participation mechanism for civil society, both on the level of remedy and also on the level of prevention. When we look at the Dutch due diligence law, which has been passed as a sector or issue-specific law on child labor, we see that there is no clear civil liability or remedy provisions in there. However, the current government is in the process of reviewing that law to make it a more horizontal proposal a la the French law. So not just applying to the issue of child labor, but covering other issues and the whole spectrum of human rights and environmental impacts. We will have to see what the proposal proposes in terms of liability or remedy mechanisms. There is quite an interesting debate going there. It may involve private international law amendments, or it may not involve any civil liability, but rather administrative liability mechanisms there. And I think there it's really interesting to pay attention to what Karen was speaking about the different potential roles of national contact points and judiciaries and how they could work together, seen in a scheme of complementarity. So ideas there are very useful. The German proposal does have civil liability provisions foreseen. That is a very contentious political topic in Germany right now. And the Norwegian proposal, as we understand, is a consumer law proposal and wouldn't have sort of remedy provisions at the moment, but it's rather at the beginning of that political process. So one point to take out of all of this is that you have divergent approaches to due diligence legislation amongst the member states. And of course, this makes it the optimal scenario or argument for EU harmonization, particularly from a business, as it so happens, point of view. To be having divergent standards amongst the member states as to what a company is required to do to fulfill its legal duties, as well as different exposure to civil or administrative or criminal liability in different jurisdictions, is, to be fair, a nightmare for European business. Therefore, from the civil society point of view, it's obviously clear and incumbent on us to make the strong case that this has to be, at the European level, a golden standard. So it has to be, if it's going to apply everywhere, a standard which is properly reflective of the duties we find in the UNGPs and OECD, that it's properly enforceable. And that is the task at the moment, in light of the Commissioner for Justice, Didier Reynder's announcement earlier this year in April, that the European Commission will in fact be bringing a proposal for an EU-wide directive on due diligence legislation. So I just wanted to share a few words on that process and where we're up to. Essentially, this due diligence law would not be a regulation. It does not seem so at the moment. So it would not be a pure harmonization instrument going straight into the laws of the member states. It would have to be transposed, is the current thinking, which would allow different member states to sort of tinker it according to the particularities of their own administrative or judicial systems. So it may not be fully harmonized. It is different from all previous due diligence legislation at the EU level, namely the timber regulation on the import of illegal timber into the EU, and the conflict minerals regulation, which Karen also mentioned. These two instruments can be conceived of as trade-based enforcement instruments. So really using trade powers as a way to enforce the way that companies, whether or not they're able to import certain goods into the EU. Whereas what we're talking about now with the current EU due diligence legislative proposal is a horizontal company law approach to due diligence. So really putting the duty of due diligence into the DNA of what a corporation or a company is, that it's a legal duty. It's something then which is fantastic that business students would then learn in business school, because it's part of the definition of what a business is. To do business is to do human rights and environmental due diligence. So we're looking at a company law dossier, which therefore places it under the jurisdiction or the mandate of the Legal Affairs Committee in the European Parliament, rather than the Trade Committee, as has previously been the case with other due diligence instruments. It's worthwhile to mention as well the non-financial reporting directive here as well, which in the past has imposed a duty on European companies, or some of the largest thereof, to to explain in their annual reports what their due diligence processes are and the outcomes that they have reached. This is under reform at the moment. So it will be the task of the Commission and the Parliament and the Council to ensure that the review of the non-financial reporting directive, so the know and show part of this scheme, is aligned and compatible with the incoming duty to do due diligence, which will be in the directive in company law. I should add that there will be big discussions about civil liability in this file. This is something, of course, which civil society has been pushing for an extremely long time. And it's worth there talking or recalling some of the access to remedy issues which Karen raised. First of all, that the national contact points of the OECD have had an abysmal track record in achieving remedy for victims of overseas violations. OECD Watch has several reports empirically comparing which have actually obtained remedy. From memory, I think really it's the Dutch national contact point which has only really been viable in that regard. So what we really need is enhancements in judicial remedy mechanisms, both in the substantive and in the procedural law reform. The extent to which we can expect this in the current company law due diligence directive is still open. We obviously will insist on that. We have other precedents of company law directives which do introduce civil liability provisions, such as on insolvency or other labor law directives, such as on the posting of seasonal workers within the EU, which put new obligations on EU companies, but which also then provide for civil liability provisions. But this is a very complex area, and there are issues of competence, not only between the committees in the Parliament, but also the member states and the EU itself. But just to make the point on barriers to justice and access to remedy for victims, we really need to address this issue of parent company liability and control and extending liability along the supply chain. Currently, the doctrine of separate legal personality has been such a hindrance to achieving remedy, even in cases where it doesn't factually make sense, even in cases where you have a European parent company that is obviously controlling and running a foreign subsidiary, and they cannot be held liable simply because it's incorporated in a different jurisdiction and is legally speaking a separate legal entity. Of course, many people in this webinar would know that in the UK, we have already developments in the common law towards recognizing that liability should start extending along the supply chain under certain circumstances. So that's really something that we hope, together with the French law and other proposals, will be able to make the case for the necessity of judicial developments on remedy. And I would just make a point there that this would really, in our view, enhance the functioning of the national contact points, as Karen sort of alluded to. If the national contact points and companies in particular know that they could be taken to court, then they're bound to use these national contact points in better faith. That is to say, it would be on equal footing, and it wouldn't result always in litigation. This is a very common criticism of judicial advancements in this area towards extending supply chain liability, is that it will result in a flood of litigation and the courts will be overwhelmed and there will be abusive litigation. That's not the case. The case is that as a result, you will have more negotiated settlements. There will be more, because it's not in the interests of victims either to bring court cases. They're incredibly expensive, time expensive as well. A quick and efficient remedy, if it's backed up by the threat of judicial litigation, can of course be achieved by national contact points, and that's something to look forward to as well. So I notice I have just a few moments left, so I would conclude by giving an update on the current process in Brussels, and that is that we're currently awaiting the report of the rapporteur in the Legal Affairs Committee on this file, Lara Wolters, who is a social democrat from the Netherlands. She will table her report in the Legal Affairs Committee on what the Parliament thinks a due diligence EU law should look like sometime in the next 2 weeks. It will then be discussed in the Legal Affairs Committee in the Parliament, and they're open hearings. One can follow those online, and I would encourage you all to do so. And on the Commission side, they're saying that they will release the consultation ahead of the actual legal proposal. The consultation, which is open to business and civil society, so I would encourage you all to contribute to that consultation sometime in the coming weeks, months, if not weeks. And you can find that information on the DG Justice website, or just follow the ECCJ Twitter account as well, and we regularly post updates about how the Brussels machinery is functioning in this regard to try and make it as open and public as possible. And finally, on the side of the European Council, so that is representatives of all the EU member state governments, it has been the commitment of the German government, which currently holds the presidency of the European Council, to write and conclude council conclusions, so a type of communication from the council on business and human rights. So that's a political process which is currently underway. We would encourage you all to make sure that the Latvian government is supportive of strong business and human rights conclusions. I think the last business and human rights conclusions we had from the European Council, that is to say all of the member state governments in concert, was in 2016. So it's around about time for new ones. And we would encourage you all, as said, as civil society and as experts, to really please get behind your government ministers and bureaucrats, public servants, to encourage them to really make the best of this important opportunity at the moment. Thanks once again, and I'm sorry I will have to leave during the day, but I'm really looking forward to the recording, and also I will hope to be in and out. So I apologize in advance for not staying the whole time, and thanks again very much for the invitation.
Thank you, Christopher, for your nice presentation. It's really good to see you, at least virtually, but let's hope that next year we will be able to join together in another conference on business and human rights, which will be not virtual, but the real one. So as we still have a certain shortage of time, I would like to invite Ms. Indra Vaidikite. When we talked about the possibility to participate in this conference, Indra said like, oh yes, business and human rights, that's a good topic. This one is inexhaustive and it's possible to find the final solution. And she will discuss a few issues related to modern working forms. And Indra Vaidikite is a member of the European Social and Economic Committee. So floor is yours. Some power.
So meanwhile, technology is not helping us, and I will speak about technology not helping us in this modern world. So this is very in line. I would like to introduce myself, and firstly maybe to say
Thank you very much for organizing this conference and for speaking every single year, if I understood correctly, about business and human rights. Because this topic is under-discussed, not only in national levels, but also in EU level. And I really encourage you not to stop with the borders of Lithuania and to push European Union to speak more about that. What should I press when I want? Okay. So who I am? I am Indra Vareikytė. I will be a different perspective today in your conference because I am representative of European Economic and Social Committee, Lithuanian delegate for 10 years. I'm finishing my term. I'm coming back to Lithuania. Who we are? We are representatives of social partners and civil society organizations. Employers, trade unions, and NGOs from all Europe, 355 members, are advising Parliament, Council, and Commission on EU legislation. And what's very important that we were created actually to be the voice of employers, trade unions, and civil society organizations for politicians not to forget important interests of citizens. And today I would like to speak about a really important topic, which is, according to me, we are very late to speak about that, but it's very important. And if we will still delay solutions to these problems, we will really have serious consequences, which we for sure don't want. No doubt, our labor market is changing significantly. It's not tomorrow. It's not next year. It happened, and it will come so fast, and we are totally unprepared for that. In the European Union, technological revolution is causing significant changes, and some jobs are at risk to be lost to machines. Others are being transformed. New ones are being created. What is very important, that skills we need in labor market changing significantly. I speak about us, and I speak about nowadays students also. And at the same time, new forms of employment are on the rise. Occupational structures are shifting, often leading to polarization in employment and wages, which in turn can increase inequality. Jobs which didn't exist 10 years ago. I am sure if someone would tell that 10 years ago that influencer can be a job, you would laugh. But today it's a really well-paid job for some people. And we can see, I think, that the best word to speak about our labor market today is unpredictable. We don't know what will happen in the future. We don't know what kind of jobs will be after 5 years, after 10 years. We can change significantly. And we don't know what new forms of work will emerge. So unpredictable is actually what leads us every single day now. New technologies will reshape millions of jobs in the EU, and they are already reshaping, and they are already changing labor landscape. The jobs that are most exposed to automation appear to be those that require a relatively low level of formal education, those that do not involve relatively complex social interaction, and those that involve routine manual tasks. But meanwhile, new jobs related to the development, maintenance, and upgrading of artificial intelligence technologies and big data infrastructures are among those expected to grow. The kinds of jobs that are predicted to grow the most by 2030 in European Union appear to be those that require higher education, intensive use of social and interpretive skills, and at least a basic knowledge of ICT. Digital technologies do not simply create and destroy jobs, they also change the environment and the way we are acting and performing our duties. In future, it is likely that a moderate level of digital skills combined with strong non-cognitive skills will be great demand, and the growing importance of both digital and non-cognitive skills is reflected in increasing wage differences between workers who are equipped with these skills and those who are not. And we already can see now, even in Lithuanian labor market, that if you have ICT skills, you can get 5, 6, and even more times higher salary than all other workers in labor market. 1/3 of the EU labor force has no or almost no digital skills. So this is a very good sign to understand how we are prepared for these changes in the labor markets. Employers in the EU report that a large number of workers are not ready to respond to the rising demand of digital skills. And this may lead to huge social and societal crisis, because we will just leave enormous amount of citizens out of labor market because we are not equipped by necessary skills. But most importantly, the fast evolving world requires change in the way that skills are provided. Europeans will need to learn throughout their entire life, both inside and outside formal education, because as you may see, I mentioned before, skills we require, we get in our everyday work, leadership, not formal education becomes more and more relevant and important. And meanwhile, the share of low-paid jobs in some peripheral regions is around twice as large as in core EU regions, and they are most vulnerable to be lost. You see a slide, I copied what occupations expected to be least affected and most affected to automation, and least affected are those actually, as you may see, teaching professionals, administrative commercial managers, chief executives, senior officials, and legislators, health professionals. Actually, those who are which are most affected is those, as I mentioned, lower education, those which are repeated, both, if I can say very simply, those who are very easily be replaced by machine. So when we come to how should protecting human rights change in this changing labor market world, it's very important to see that when the draft of Universal Declaration of Human Rights was developed, actually the world had only just begun to move from the second industrial revolution to the third. And the second revolution in the early 20th century involved an explosion of innovations such as cars, new communication technologies, and assembly lines that facilitated mass production and standardization. The one which now can easily disappear, actually, where human can easily disappear. The third revolution in the late 20th century was driven by computers and digital technologies. Today, new technologies are emerging the physical, digital, and biological worlds. This fourth revolution affects all disciplines, countries, sectors. Inventions such as self-driving cars, smart robots, gene editing are challenging us to define what we really mean when we talk about qualities previously associated with humans, such as intelligence or individuality. Updating human rights for the challenges of our era is the key to building a better society. Otherwise, we will leave a huge part of population outside, and we need a new social contract centered on human dignity, social justice, and where societal progress does not fall behind economic development. Universities, research centers, individual scientists must join forces to develop and harmonize the theoretical and legal model underpinning the updated concept of human rights. And I speak about global digital human rights, which it seemed for me as opportunities for everyone from birth through access to the digital benefits of civilization. They should be ensured to be consolidation in the system of forms of international law and national law. And there are elements for your discussion and for your maybe some food for thought for your future discussions can include, for example, the right to exercise personal, social, economic, political, and cultural rights based on new technologies without barriers built on the basis of new technologies. A global ban on the production and use of these new technologies for warfare and human rights violations, including AI, big data, biotechnologies, and other digital technologies. A ban on the use of these technologies for total supervision and control, including technologies such as the Internet of Things and face recognition, which if you follow, for example, USA events, you can see that already we have misuse of these technologies related to human rights. The right to personal data protection, including the protection of genetic information and health data in the context of the rapid advances in biotechnology, bioengineering, telemedicine, and some points more. The priority of human beings and their interests, integrity and quality of life in the context of the creation, use, introduction, and development of artificial intelligence, equal access to the opportunities offered by these technologies, including access to education, labor, healthcare, and basic social services based on new technologies, the right to take part in the management of social processes at the global, regional, and national levels through digital technologies, and the right of access to the global internet for everyone. Mechanisms for monitoring and enforcement will need to draw on new technologies to be effective. An effective digital society with human rights at its center will need functioning media and civil society that informs people of these rights and holds governments and institutions to account. We need to decide how we want these technologies to be deployed, how we want to interact with them as humans, and how we want to live our lives in the context of such rapid change. And I say this, it's not a coincidence that I say this. For example, in some countries, even in Germany, we had really active discussions about should artificial intelligence, human be responsible for artificial intelligence, or artificial intelligence should be responsible for itself. So this is discussions which are held today about the limits of ethics and the limitations of technology. To ensure that the tools of the fourth industrial revolution may not turn into instruments of oppression and destruction rather than progress and development, because technology should help us. It should not become the tool, as I said, of oppression and destruction. So now I would like to show you some case studies and to show that how it works and why it's important to speak. So facial recognition, for example, is accurate if you are a white guy. There are many surveys which shows that if you are not white guy, you will have more possibility to be mistaken. What I'd like to say is that if you sometimes think that it's just technology and I don't use this and I will not need this, it's not true, because this machine learning and artificial intelligence technologies are changing the process of hiring, firing, entering university, entering any possible other institution. It already financial institutions are applying to us with robots, not human. We are replacing humans actively. So this is everyday life. It can be even that you are sometimes interacting with the machine without even knowing. What does that mean? If you don't know that you are interacting with the machine and you answering questions, for example, as machine doesn't understand your way of answering or manner of answering, you will be, you can be even not selected to university or workplace because you will not answer understandable to the machine. But this is not only problem. The biggest problem is that our ICT and artificial sector is, I can say, maybe made even of absolute majority of men. And that makes algorithms very biased, because you know that algorithms are written to work and to select and to ensure procedure works. So it happens that if you, for example, are a woman, or you have different education, and you will answer not like algorithm expects you to answer, you will be treated as not a proper candidate. And this is a huge problem if you realize how many systems in our life will be replaced by machine answering to us. So this problem becomes really actual, and it can push out of actually out of many spheres, many people who are not prepared to interact with the machines. So I included this facial recognition case study. And it says that when the person is in photo is a white man, the software is right 99%. But if, for example, is a woman with darker skin, is 35% of images it can't recognize. If, for example, such technology is used by the police, and we saw this in USA also, dark-skinned man always become more chances that he is criminal. Algorithm makes suggestions to the police that it can be criminal and it has to be jailed. He has to be jailed. So what I'm telling now is not a possibility to happen. We had these cases already several times, and we see that this mistreatment of technology sometimes puts human rights in really difficult position. And in modern artificial intelligence data rules, artificial intelligence software is only as smart as the data used to train it. And you know that, for example, the artificial intelligence is doing conclusions from the data it can find in internet. So it depends on data it can find on the internet. It can make one or another algorithm. So in internet, he finds only male-related data, white-related data, white people-related data. It will make conclusions accordingly. So I will go to another case study, and I will speak about speech recognition, which is still gender bias. And this also is a problem which affects which has real impact on people's life. If, for example, a few incorrect YouTube captions aren't a matter of life and death, but some of these applications have a lot higher stakes. Example, safety implications of voice recognition in cars, for example, how it treats woman voice and man voice, or medical dictation software. And very practical example, the fact that men enjoy better performance than women with these technologies means that it's harder for women to do their jobs. Even if it only takes a second to correct an error, those seconds add up over the days and weeks to a major time sink. Time male colleagues aren't messing with technology, and women should do this job second time. So where is this imbalance coming from? The problem is not with how women talk, that her voice is different. Women's voices are different from men's voices for sure, though so a system designed around men's voices just won't work as well as for women's, which leads right into bias is coming from unbalanced training sets, because machines mostly are trained by men who are majority of ICT sector. And machine learning works by making computers really good at dealing with things they are already seen a lot. If they get a lot of speech from men, they'll be really good at identifying speech from men. If they don't get a lot of speech from women, they won't be that good at identifying speech from women. And if you compare how many women we have in ICT, artificial intelligence sectors, you will understand how big is the problem. If I'm not mistaken, in Lithuania, we have 15% women in digital sphere. And this is, I would like to make sure that it's not any remark to men, it's just a remark to make these sectors more equal, to ensure that human rights are respected. So I would like to speak a little bit about the ways how hiring algorithms can introduce bias. And how it's done is in shaping the candidate pool, for example, by reinforcing existing societal gender and racial stereotypes, by replicating behavioral patterns of recruiters and applying narrow characteristics in narrowing the selection. For example, candidate performance prediction reflects subjective evaluations and often uses polluted data. Financial offer predictions tools further strengthens pay inequalities. And bending algorithms towards equity is possible only in one way: actively search for latent data bias from the start of development to deployment and application of any tool built on real human data. So one more slide about digitalization and its impact on labor markets. As business embrace technology, there are unwanted side effects beginning to emerge, which we are, as I said, late to solve, but still we need to do that because it's our reality already. There are certain sections of society more at risk from exclusion from our evolving digital society than others. And it's important that business, the government, and the wider public make sure we all embrace on everyone first, digital first strategy when it comes to both access and identification, for example. Firstly, your socio-economic group has a substantial part to play in digital world. When considering people on low incomes, we might not be able to afford a smartphone, and home broadband might be too expensive or impossible for those living in temporary or unstable accommodation. But many services today actually are dependent on these possibilities. Vulnerable groups often remain in digital isolation, which further excludes them from the society and hinders integration, employment, and education. Socio-economic group, as I said, has a substantial part to play, and it pushes people outside the circle, if I can say so. Significant disadvantages for the elderly and disabled because they are not so well connected as we are. 29% of both youth are not online, so they are also pushed off this circle. Digital divides also mirror prevailing economic gaps, amplifying the advantages of children from wealthier backgrounds and failing to deliver opportunities to the poorest and most disadvantaged children. And this is really important topic, speaking about changing society and us going to digital world. Unregulated digital economy can create an increasingly polarized society with deep inequalities between a few winner-takes-all superstars and the masses of losers, which make the future social conditions and inequalities remind those from 18th century, and I'm sure we don't want this. Thus, I really would like to say that it's not criticism or remarks to the nobody situation we have, but my recommendation is that we already are late. Digital technologies already today are making many important decisions, and tomorrow we will do even more decisions on which our lives depend. Thus, creating making necessary decisions and creating a digital society equal for all people is really important. And I hope that this overview of the station helped you to see another perspective. Thank you very much.
Thank you, Indra, for your excellent presentation. And I do believe that we already have few topics that should be discussed in the next year conference. And I'm very sorry, we have a very short time for discussions, and we have to move through our agenda, and we made a small change. I would like to invite to speak Beate Ekulovec-Slidell. Beate, I'm very sorry if I pronounced your surname not correctly. Beate is the a member of the Norwegian National Contact Point, and also she's the policy advisor in Amnesty International Norway. Beate, I would like to ask you if it's possible to make your presentation in 10 minutes. It would be very nice that we could end up in time and maybe even have a very short discussion. Will you present? Oh yeah. Do you have slides, and can you share them?
I think I already sent you my slides.
Yes, but want to try to share it from your computer, or
okay?
Maybe
you could try, but I guess that if I only had 20 minutes, I think I'm not sure whether it's any point of sharing those slides, to be honest.
Okay, not a problem. I can share.
Can you share it?
Yeah, yes.
Because the problem so far is that for the two last persons, we were not able to see their presentations. We could only see the persons themselves. So I don't know whether you can actually see my presentation now on the big screen or not. And if you cannot, I would appreciate if the other participants could give us a notice. So I'll try to run through this as quickly as possible then, because this is almost mission impossible, I guess, to try to compromise it into 10 minutes, but I'll give it a try. First of all, thank you for the invitation, and thank you so much for the previous persons. It was really interesting and engaging to listen to you. I will quickly run through the main findings of a survey that was made by the Norwegian Contact Point, and then a survey that was made by Amnesty International Norway, just to see where we actually have more or less the same findings and where we do not have the same findings. And it was all about trying to identify what's the status up today when it comes to Norwegian corporate actors, knowledge about OECD guidelines, to which extent do they actually do risk assessment and so forth. To have some, solid information to bring forward in our work to try to have an impact on how they actually do their conduct on business and human rights, and also to use it as a kind of arms in our lobbying for a Norwegian human rights due diligence legislation. So very quickly, the main findings in the Norwegian Contact Points survey is the following. We find that there's a very low level of knowledge of the OECD guidelines. There is also an even lower level of knowledge of the National Contact Point. And yes, many of the enterprises do have written guidelines. At least 60% of the big corporate actors having, businesses outside of Norway do have a written guideline, but very, very few of them make any reference whatsoever to the OECD guidelines. And we found that less than 50% of the enterprises do any proper due diligence. And of them, only 40% make this kind of conduct due diligence in their supply chain. I will go very quickly down to this one. Just to, can you actually see my slides now on the big screen?
Yes, Beata, just say which slides I should show. It's
if you now got to the third one, I mean the next one, the one that reads knowledge.
Okay, yeah, knowledge. Yeah.
Okay, sorry that I forgot that you had to do it. Thank you so much for being so helpful. So as you can see here, very few have any knowledge about the OECD guidelines, about the Norwegian National Contact Points, etc. And if we go to the next slide, please. We said something about to which extent the board in the company is involved in the work the company is doing on business and human rights. You will see that many other companies make sure that their board is involved in this kind of work, which is good. And you can see it all the way down when it comes to which extent the more or less the main priority they have is focusing on sustainability. I would say more than human rights, and that's one of the challenges we have as well to make sure that the human rights dimension is being more higher up on the agenda for the companies, not at the cost of sustainability or environment, but to have it in addition to these two elements. And as I mentioned, very few of them actually have any reference to the guidelines, OECD guidelines, in their own internal guidelines. And as you can see, the numbers are, surprisingly low when it comes to both the knowledge of and the way they use the OECD guidelines. It's interesting that to see what areas and ties are covered by the enterprise's risk assessment when it comes to the negative impacts they might have while doing businesses, in particular outside of Norway. As I mentioned already, human rights are not very high on the agenda. So when they make the risk assessment, as you can see, their main priority is to look at environment and climate. But the highest priority is something named other, which usually includes health and security, and this kind of issues. In other words, issues that that doesn't mean that you actually include the areas that you should if you are supposed to follow the OECD guidelines. And of course, this differs a lot when you look at the different kind of industry sectors that's getting the response to this survey. So if you go to the next slide, number 7, where we skip.
Which one is 7?
That's the one which starts with Amnesty's business rating. And I'm so sorry, because I seem not to have forgotten to ask you to go from one slide to another. And I guess that's what's happening when you get
yeah, so previously it was embedment in the enterprise. Now do the enterprise's internal guidelines refer to the OECD guidelines? And then we move further.
Yes, you move now to the slide that reads Amnesty's business rating.
Okay. And now the next slide will be Amnesty business rating.
Mm-hmm. So very quickly then, the purpose, of course, then was to map the extent to which companies in Norway are exposed to risks of violating human rights and how well prepared they are to deal with this risk. And this survey focuses on the largest companies in Norway compared to the survey made by the National Contact Point that focuses on the whole range of companies, including the small and medium sized as well, in addition to the big ones. This one only focuses on the big actors. And we focused on 4 business sectors: energy, oil and gas, shipping, offshore and fishery. So if you go now to the next slide, please, you can see who we are actually focusing on. So it's 4 business sectors: energy, oil and gas, shipping, offshore and fishery, consumption and services, industry and real estate. And we are looking at 5 indicators. To which extent do they actually have a policy on business and human rights? To which extent do they make sure to inform the employees about the policy and do training on the policy? To which extent do they make proper risk assessment? To which extent is the management system involved in this work? And to which extent are they transparent about how they work on business and human rights? The next slide, please. And here you have to not only read Norwegian and Swedish to understand it, but this slide focuses on what are the companies' own perceived or perception of the risk that they might violate human rights. And if you look into these areas, you can see that it's energy, shipping, offshore fishery, consumption, services, industry and property on the top of the scale. And then it reads on the left, it's a very high risk, quite big risk, not so high, no risk at all. And if we look into the line where you see, I cannot point it to you since I'm not sharing the screen with you. I think what's amazing in a very negative sense is that as much as 61% of all the corporate actors in this survey, independent of which industry sectors they belong to, 61% of that says, well, it's not a quite big risk that we might violate human rights. And if you look at the sector, industry and property, 91% of them, almost all of the actors from that sector, says there is very little risk that we violate human rights. And if you go to the sector of energy and oil and gas, 38% of them, close to 40% of them says there's no risk at all that we might violate human rights. Quite incredible how self-confident they are about the control they have of their own businesses. which is very amazing if you look into what they answer when they asked about the experienced problems in the work with human rights. So if you go to the next slides, please. Not surprisingly, you will see that the biggest challenges are experienced when it comes to the control of the supply chain. 48% of the companies says that this is a big challenge. Secondly, 35% of them says that it's a problem to detect violations when they actually occur. 32% of them says it's a challenge to try to obtain correct and complete information. And if we go to the next slide, please. I will not comment on all of this. I will just comment on when it comes to the industry sector, energy, oil and gas. As I said previously, 38% of them says that there's no risk whatsoever of them violating human rights. Well, at the same time, 50% of the same companies admit that they have, 1, problems in controlling the supply chain, 2, problems in catching up when there are human rights violations, 3, problems with obtaining correct and complete information, 4, 25 of the companies state that they have experienced incidents in the last 1 to 2 years. And at the same time, they are saying there's no risk whatsoever of us violating human rights. One can wonder how this actually comes together. Next slide, please. So we had 5 indicators: policy, management system, information and training, risk assessment, and transparency. As you can see from these numbers, and as was confirmed by the findings in the National Contact Points survey as well, yes, the majority of the companies do have a policy on business and human rights. In the Contact Points survey, we found that 60% of the companies actually do have a policy. In Amnesty's survey, we find that all of the companies that we have interviewed do have a policy on human rights and business. When we now stick to the policy bit, what you see is interesting is what is actually the policy all about? Yes, we found that very, very few of them have ever reference to the OSCE guidelines. What we do find in our survey is that many of them have a reference to the Universal Declaration on Human Rights. Many of them have a reference to UN Global Compact. Some of them have reference to the UN Guiding Principles. But in both our findings, too few actors in the corporate sector has any knowledge of or any reference whatsoever to the OECD guidelines or to the UN Guiding Principles, the 2 golden standards, so to say, on this matter. You see that management systems, to which extent the policy and the work they do is embedded at the board, is quite high in the response we got from our actors, where the top number you can get is actually 5. We see that information and training has quite a good score at 3.9. But then we see that 2 of the main important tasks you have to do, seen from our perspective, to try to avoid violating human rights and harm environment, is to do proper risk assessment. And both the National Contact Point and Amnesty has made their respective surveys for many years. We have done it since 2007. And I think this is the 3rd time the National Contact Point is doing their survey. And it's really depressing, to be honest, to see the lack of prioritizing the importance of doing proper risk assessment. And then again, the lack of transparency. These are the 2 main issues that many of us are, find really important. One, to make sure that companies have a good conduct, and to be transparent about it, to make sure that actors like us are able to try to follow up to see what they actually do in practice. if you could go to the next slide, please. I just thought it might be interesting for you to see how companies considers the importance of not violating human rights. And from a scale from 1 to 5, you can see that the company assessment is the following. It's important not to violate human rights because of their customers and potential customers. It's important for potential future employees if you want to recruit the best employees. And it's quite important when it comes to investors. So in other words, on the one hand, there's no doubt that companies considers respect for human rights to be important, but there's a missing link between having this as a so-called prioritized area and to do what you need to do in practice to be able to live up to your own high standards of saying that we respect human rights. And then very quickly to just have a last point, if you can go to the next slide, please, that reads human rights due diligence legislation. I promised to touch upon the development in Norway. Christopher, you said that the law in Norway that's now being on the table is only a consumer law, which is not accurate actually, because the human rights draft law that's on being discussed in the ministries now requires businesses to disclose information about production sites used in manufacturing, the supply chain management. But in addition, this draft law requires companies to do proper due diligence assessments as well. This draft law was up on a hearing this spring, is now back at the ministry, and we expect to see the law proposal presented by the government by the end of this year or early next year. And we have established a coalition in Norway, the Coalition for Responsible Businesses. And we have now more than 60 members already, including 6 of the biggest companies in Norway, trade unions, banks, investors, etc. And we have a joint call that says that a human rights due diligence law that requires companies to assess the risk of violating human rights and do harm to environment, that requires them to mitigate and prevent this risk, and requires them to be transparent about how and what they do to live up to this requirement. And if you could go to the final slide, please. In our survey, we actually asked the companies whether they support a corporate human rights due diligence legislation. And good news to us and everyone who's working hard to have this kind of legislation in place on the national level, but also at the international level, is that 60% of all of them actually supports this kind of due diligence legislation, which is a great effort for us to bring on board. So then, just to sum up, the national contact points and Amnesty's 2 surveys conclude by the following, and that is too few companies refer to the OECD guidelines, and I would say also the UNDP. Too few of them actually conduct proper risk assessment, no doubt about it. And too many of them are too self-confident that there is little or non-risk whatsoever that they violate human rights. And in that sense, both our surveys is important tools that we use back home now to raise the awareness among the corporate actors, among politicians, the governments and so forth, that they still have a long way to go to be where they should be. And we also use it as a tool to have a Norwegian human rights due diligence legislation. Thank you.
Dear Beata, thank you for a wonderful presentation. And as I said, we have a small change in our schedule. Andrius Bambalas will present his presentation in the next session. And as one of the speakers, Martins Bingelis from Latvia will not be able to join the conference because of the certain issues in the parliament in Latvia. We will have half an hour for discussion, just to discuss the first part of the day. So now we're having a lunch break, which is served in the professorum in the second floor. So I will just put a slide here, and afterwards we're meeting in this room again. Oh yeah, on the time which is indicated in the agenda, we have to be concise in the second session too, at 12:30. O tu įsikėlei? Aš užrakinsiu auditoriją, tai galima palikti jo. Aha. Ne.
Mano jau iš pirmos temos pranešimų yra bendriausias. Iš antro, jau ne tik ryšio, tai yra klausimas, bet dar ir ten ir trečias klausimas, aš kas atrodo, kad nėra trečias iš ministerijos ar sutartis, kurio net jo yra čia, taip sakant, pareiga daryti, kad nufotografuotų ministerijos lygmenių paskleis informaciją apie MTC dalyvavimą tarptautinėje konferencijoje. Esam dagasinių, aš tam žiūrėskau, mane išleis, kitą atleis, nors generolas yra tik tai stabilizuoja. Man nuotrauka, kad atrodyčiau, kad esu gražiai. Ne tai, kad žiūri dangų. Jo, gerai, esame žiūrė. Tai pasidaryti nuotrauką. Ne, tai aš. Mes kitus gyventojas tau paskambinti, prekia, atleidinėja, spausdina. il microfono non bene proprio così il mio vero vado a uscire.
Ah, sharing.
Ci dovrò andare a
No, can't break the
Yes, sir. Don't take the one that shows very nice. So,
Okay, dear all, it's nice to see you in our second part of the conference after our lunch break. And in our second part, we will discuss a few other issues, and mostly we will focus about the implementation of UN guiding principles and human rights in Nordic and Baltic countries. As I said previously, we have a small change. Our colleague Martin Virgels will not be able to join the conference. So we still have Andres, who didn't make a presentation, so he will. We will put his presentation instead of Andres, and afterwards we will try to conclude and make a discussion on all topics which were covered during the conference. Definitely, we lost a few speakers who could not stay the whole conference and couldn't participate online too, but I do believe that it's still possible to have a fruitful discussion. So in our second session of this conference, we will discuss with Dirk Hoffman, who will give an overview of national action plans around the world. Also, this session will be joined by Kent Vilskant, who is working in the Finnish Minister of Foreign Affairs, and he will share some experience from the Finnish side. And afterwards we will hear Andres, who will in some ways come back to another issue which is very closely related to the business and human rights. It's national contact points and the experience. So we're giving floor to Dirk Hoffman, who is Senior Advisor at Danish Institute for Human Rights. Dirk, could you try to share your screen with the slides? If not, I will put it on my screen.
I can certainly try. Can you hear me okay? Can you hear me?
Yes, we can hear you.
Yeah, that is good news. Okay. You should be able to see my screen, but just let me know if it works.
Make them all.
It's working?
Yeah.
Perfect. I hope everyone enjoyed the lunch break. Thank you for inviting me to the conference. My name is Dirk Hoffman. I work for the Danish Institute for Human Rights, and I have been in the past 10 years working a lot with, on the one hand, companies, but also with national action plan implementation. Our institute has been working on methodology that supports states that want to work on national action plans or conduct a national action plan process. And I've been asked to share a little bit about this topic, kind of from a global perspective. We have developed a website or a resource basically that is publicly available that gathers information on national action plans all around the world, and is continuously updated to hopefully help other countries or stakeholders that are interested in this topic And I will share that research with you also through this presentation, but this is basically what my presentation is about. I'm not going to take half an hour like other speakers. It's going to be much shorter because I want to also leave more room for questions or discussions here afterwards. Let me first say something about my institution. We are a national human rights institute, like exists in many countries. The special thing about the Danish Institute is that it also has a mandate to work internationally. Normally, these bodies only have a mandate to advise their own country's government on human rights issues. But we also have a mandate to work internationally. So that means that we have an international half, and in that half sits our Business and Human Rights Department. We have been working on this topic for 20 years now. So even before the guiding principles came into existence, and of course, especially afterwards, we work in two programs, one dealing with business and human rights at the governmental and civil society level, where we are working, for example, on the topics of national action plans. And then the other half is working directly with companies. So we've worked with like big multinational companies on human rights due diligence and all the kind of steps of the human rights due diligence. So we have many different perspectives on the topic, I think, which is an advantage to in this field. So national action plans on business and human rights, what are they? I'm sure this is a repetition for many of you who may have already heard about this topic, but it's basically a document in which a state defines the actions that it will undertake to implement the UN guiding principles on business and human rights. It's not a novel instrument. It's nothing specific to business and human rights. These kind of action plans are kind of a standard tool for governments to coordinate or prioritize actions around any kind of topic. So there could be a human rights action plan in your country, or there could be action plans on environment or climate change or other kind of topics. And generally what they do is they try to review a country's needs. And sorry for that. I should have turned it off beforehand. And basically coordinate actions around a particular topic and set concrete and achievable targets. It is also an opportunity to promote linkages and coherence within the country, from the perspective of one particular topic. There's very broad support for national action plans on human rights and business internationally. A number of actors that you can see listed here on the slide have come out in support and have encouraged states to develop such national action plans, to review where they are in terms of implementing the guiding principles and set actions for their country context to address the biggest challenges that they're facing. That said, there are not that many action plans out there yet. And you can see on this map here, all the countries in green are the ones that have already published at least one national action plan. Some even have already revised their national action plan. And you can see from this map, it's mostly located in the Northern Hemisphere, and a lot of them in the European region of the Council of Europe members. But in blue, you can see action plans that are currently under development. And orange are other kind of initiatives that are driving towards a national action plan, mostly by civil society, for example, in the form of a study that tries to promote this topic to the government and hopefully eventually leads to the adoption of a national action plan. This map is from our globalnaps.org website, which is the website that I referred to earlier, where we are updating information on action plans around the world. We very much depend on national actors to also make us aware of any new developments that we may not have captured in this. So if there is new developments in your country, feel free to reach out to us and provide us with additional information. A variety of actors have come out with guidance on like what a good national action plan process is supposed to look like to be successful. Like our institute has developed guidance, but also the UN Working Group on Business and Human Rights has developed guidance on national action plans on business and human rights. And Generally, the steps that they have broken this down into are these 5 phases that are listed here. There's the initiation of the process, which basically means that the state should assign responsibility for such the coordination of an action plan process to ideally a ministry or a part of the government that takes charge. And very often it's a Ministry of Justice, but it can also be the Foreign Ministry or the Ministry of Economy that is taking charge of such a process. In the assessment and consultation phase, you would conduct a study of where you currently are in the implementation of the guiding principles so that you have an adequate basis, because you need to know where you are to know where you are actually want to go. Consultation and stakeholder consultation is then a very important aspect of this phase that is supposed to get broad input from actors in society. So that includes civil society organizations, but also businesses that should be heard on what are the biggest challenges from a business human rights perspective in the country and what could be prioritized for action. The government will then usually take charge of drafting the initial NAP themselves after the consultations. Phase 4 would then be the implementation period. Oftentimes these action plans have last for like 2 or 4 years before they are revised again or updated, which is the last phase. This is broadly the steps that the UN working group recommends. And then they give guidance on the process and on the content of such a national action plan process. So really important is that they highlight that there should be government leadership, as I've already mentioned, and ownership. This is unfortunately not always the case, and there should be terms of reference in a timeline, and there should be resources assigned to such process. And that is also not always the case, and it can lead to very long and dragged out processes, sometimes for many years. Stakeholder participation is really, really key. And I would, in that regard, from my experience, say, in many country contexts, the whole process of developing a national action plan is almost as important as the action plan itself, because in countries where awareness of business and human rights issues is low, or where, for example, pre-existing understanding of CSR focuses mostly on philanthropy and doesn't, really look at business human rights from a respect for human rights perspective. This kind of process gives you an opportunity to raise awareness and build the capacity of various stakeholders on the issue. So it's almost as important as the actions that usually come out of that afterwards. Yeah, be transparent about it and conduct a national baseline assessment, the short NBA. So this baseline assessment is a study, as I already mentioned, that is supposed to look at what the current status of implementation of the guiding principles is. And it includes, of course, also the things that are not, that the government undertakes that are not explicitly in support of the UN guiding principles. There may be a lot of things the government is already doing that fall under this, this headline, but may not explicitly be called business and human rights. There should also be a framework for the implementation and for monitoring the effectiveness of these actions that are being proposed in the end, of course. Yeah, I already covered this about the baseline assessment, so I'm going to skip this, but just to say it's a comprehensive analysis. One more thing to add here is very often the government tasks an independent actor with conducting such an assessment. So that can be a civil society organization or a university, and it can also be an institution like ours, so a national human rights institution that is supposed to conduct this kind of independent analysis. And it identifies gaps in the law and also in the implementation of the law, and is supposed to then very often also yield in recommendations towards actions. And it can form a very good basis for pre-identifying kind of topics that are priorities for the country or that are big challenges for the country when it comes to business and human rights, and they can serve a good basis for stakeholder consultation afterwards. Where, of course, they are not supposed to limit the discussion, but can be a good conversation starter and help also build the capacity of the people participating in these consultations on this topic. Because for many people, human rights and business is not self-explanatory, and having examples from the country that speak to people is a good way of building this capacity and getting the conversation started. In terms of the content, like what a national action plan should actually contain, the guidance says that it should look at all of the UN guiding principles, so the full scope of guiding principles, and focus on the territory and the jurisdiction of a government. And it's recommended that it has a focus on, the key topics that come out of these kind of discussions and of the baseline research, and ideally also focus on particularly vulnerable groups from a business and human rights perspective. The actions that are eventually being proposed should be smart, so they should be specific, they should be measurable, they should be achievable and realistic. They should be relevant, and they should be time-bound. And that is actually something that many action plans have not shown. But I will get into that right after this, when I'm talking a little bit about what the status of current action plans is. The UN Working Group also recommends a regulatory mix of soft law measures and potentially also hard law measures. So what do I mean by that? Soft law measures obviously not being like legally binding obligations, but rather recommendations to companies or call to actions and guidance that are trying to achieve better business compliance with respect for human rights. And hard law, of course, then being things like mandatory human rights due diligence, which is being discussed, as we've heard in the first half of the day, in some jurisdictions already. I would say in the trend, at least in Europe, is going towards mandatory human rights due diligence discussions in a national context. I think an interesting example is the German one. The German government had a national action plan in which it basically had a review deadline after 2 years, where it wanted to see if these kind of soft measures that they had taken have led to any more uptake of human rights due diligence by companies. So they had an evaluation study at the halfway mark, so to say, and it basically said explicitly in the national action plan that if it is found that there is a lacking implementation of companies of human rights due diligence at that point, discussion around hard law measures will be taken. And that's currently the discussions that are taking place in Germany. There is a discussion around a mandatory human rights due diligence law. I am not particularly optimistic about it because there are a lot of forces at play here that are trying to water this down. But there are these discussions in the neighboring countries as well, and there's the French due diligence law and the Dutch, as we have already heard. So I think without a doubt, the trend goes into this direction. But I don't think that is necessarily reflective of what is happening in all countries or what is appropriate for all countries, because in some country contexts, you are starting at a much earlier stage of building capacity and understanding on business and human rights. So talking about mandatory human rights due diligence legislation here is very likely not realistic. Some of the benefits and challenges of such action plan processes. Some benefits are definitely that it creates accountability of the government and of duty bearers generally to address or to implement these actions that they are committing to. In an ideal world, it's a participatory process, so it is an opportunity to empower people, vulnerable people, or rights holders to participate in these processes. And it will, in that regard, also be an empowerment for people that are particularly affected. A baseline study ideally also gets to identify root causes of human rights violations, and in that regard helps to formulate better actions that help to address these root causes. It is an opportunity, as I mentioned before. I think it's actually a huge opportunity in many country contexts to build capacity on human rights, and also what is the relevance for businesses. These action plans have been gaining international recognition, although one could argue that there's a little bit of a stagnation at the moment. There are a lot of Northern Hemisphere countries that have action plans, while the Southern Hemisphere countries have been slow in catching up, you could say. You could see, for example, that Africa doesn't have an action plan. There's no African country with a national action plan yet. There has been one in development in Kenya for 4 years now, I think. So that's obviously a very drawn out process for various reasons. Yeah, that's definitely, one could question whether it has enough international recognition. But it does get to support, it does support states also in international negotiations. But there are also a bunch of challenges that are associated with this. And one is that it may actually delay actions by states. It could basically postpone actions on business and human rights until after a plan has been published, which can be very a lengthy process in some contexts. It may also overlap with the existing action plans. So some countries have a human rights action plan, which for example, can be largely unimplemented already, and there will be a kind of a fatigue by civil society or by other actors of adding an additional action plan that will just remain unimplemented. Business and human rights is a very cross-cutting topic, so it will link to a lot of other topics out there, and it may link to existing national action plans. So what we are advocating for is kind of a smart approach to this, and ideally integrating the topic of business and human rights into existing action plans if it makes sense. Yeah, states, and this is one of the reflections on the existing action plans, or the first action plans that came out. States often use these action plans to promote existing efforts rather than coming up with new commitments or new actions. So they just pointed to the things that they were already doing. So in that regard, it was actually less of an action plan and more of a report, you could say. And then there are some issues that are requiring international cooperation, where you are talking about business and human rights issues that are going across boundaries, that talk about the dynamics between industrialized nations and developing countries. And so those are some of the challenges that a national action plan process may not be able to overcome in isolation or by itself. Some of the trends or the positive things, like the glass half full kind of perspective on the initial action plans that have come out. So far we have about 24 action plans. There are a number of studies out there that have evaluated some of these action plans against a number of criteria. And as I mentioned, some of them have already been revised as well, or are in the process of being revised. One positive is that all of them give explicit support to the UN Guiding Principles. They do include soft measures mostly across all 3 pillars. And they have also seen largely cross-governmental involvement. So it's not just one government ministry that is taking charge. The measures are actually including a variety of ministries, which is important. Stakeholder participation has been a challenge in the initial stages. So the initial action plans were just sometimes governments sitting in a dark room somewhere and coming up with an action plan. But now this has also been largely criticized, and there's now increasing stakeholder participation in these processes. Not many countries have actually done a national baseline assessment, but there have been civil society organizations or national human rights institutions that have, for example, conducted shadow baseline assessments, and some governments have done a quasi-baseline exercise to actually ground their action plan in some kind of evidence. And to a degree, we've also seen competitive dynamics, especially in Europe, where the first action plans have then spurred responses by other governments who also came up with national action plans, and that dynamic can also be seen in some of the regions. Some of the challenges here, you can see one of the publications that actually also involved our colleagues from ECCJ, who you have heard this morning, that assessed action plans also revealed some of the challenges. So as I mentioned already, some of them were not particularly action-oriented and were more talking about existing measures. There were not many hard law measures. It was all soft. Most of it was all soft measures to further the implementation of the UN Guiding Principles. Pillar 3 is so access to remedy is a largely neglected topic still. Participation, and particularly in particular participation of at risk or vulnerable groups of rights holders has been lacking in the initial stages. A lot of processes were also not particularly transparent. This also links a little bit to sometimes a missing baseline study. So there was a lack of evidence that actually grounded for, the government's action, or like gave a reason for why the government focused on a particular actions and not others. Resources, there were in lack of resources committed to these type of processes, which very often led to very short or processes not being very participatory. And many of these action plans also didn't really have a follow-up framework or smart actions that were clearly designated towards an actor for implementation and had a time-bound framework or a mechanism for follow-up and review. As I already mentioned, there's quite a lot of guidance out there on national action plan processes. We have the guidance that our institute produced ourselves, but we also have the UN Working Group guidance. The Business and Human Rights Resource Center has a website where they are also gathering information about national action plans. And then I've already mentioned this, there's also an analysis by our institution of national action plans from 2018. That's a bit more recent than the ECCJ one. An ICAR one. And then there's, last but not least, our website where we are gathering not just the information about the action plans, but we also have various entry points into the topic. So for example, if you're interested in what actions have governments undertaken on the topic of children's rights and business, or what measures have been taken that are targeting a particular sector, for example, the extractive sector or the manufacturing industry, then you can easily kind of look at that information across national action plans through that website. So I can highly recommend that you check it out if you're interested in this topic. That concludes my presentation. I'm happy to take any questions that you may have. And thank you for having me.
So thank you, Dirk, for excellent presentation and global overview on national action plans. We still have some time. Does anyone have a short question to Dirk, or we can move to another point of our agenda? If not, let's continue with this discussion on national action plans. And Dirk, thank you once again for your presentation. And we will continue with the presentation of Ken Pilskamp, who's working in the Ministry of Foreign Affairs in Finland. And he will give his perspective for how Finland created their national action plan, what they learned from it, and what are other challenges. So, Kent, I think so. You finally joined our conference. Is the sound okay?
Yes, I just managed to get in after half an hour struggle, so I have not heard anything you have spoken so far.
Sometimes it happens. Would you like to share your slides from your computer?
No, I will have to do without slides.
Oh,
so
okay.
you just have to bear with my face.
Okay, thank you.
Okay, so I mean, we started drafting the National Action Plan in 2013, and it was ready already by fall 2014. And I guess we were actually one of the forerunners. I think it was only 3 national action plans adopted before us in that time, and it made the job kind of difficult because there was not many plans to benchmark ourselves. And actually, when we started our interministerial work, there was only 1 or 2 published. So that was, and all these kind of different guidances and toolkits, they were just kind of started to appear when we were already on our way. So we had to kind of invent things on our own. And the lead was taken by the Ministry of Economic Affairs and Employment. And this was, we had some debate with, I'm from the Foreign Affairs, from Trade Policy Unit, and we thought that maybe this is not the good idea to have this from the Foreign Office, since then some of the other ministries may they go think that, okay, this is some typical Foreign Affairs, United Nations stuff that they don't need to get involved. And so afterwards, I think that was a good decision that the Ministry of Economic Affairs took lead in this. And this was almost kind of this whole of the government approach. There was one key ministry missing, and I still, that was a mistake. I mean, we just couldn't convince them that this would mean something for them, and that was the Ministry of Environment. And now if we think about the discussion on due diligence in Europe, we're talking about human rights and environment, and the Ministry of Environment, they just didn't see this is something relevant for them. And if we one day will revise our national action plan, I think we have to make some more efforts to try to convince them that this is many of the environmental issues are at the same time human rights issues. After that, in the actual implementation phase, I think that we have much worked with the axis of the Ministry of Economy and Employment, who is kind of the main ministry in charge of responsible business conduct, and our ministry. And in our ministry, I'm from the trade policy side, so we are in it. And the political department, their human rights unit, our development policy unit, as well as legal affairs. So this has also, the process has brought us together, not only between ministries, but also in-house. And I would say that this NAP, or the National Action Plan process, as it sometimes is, that the process is actually more important than the end result. And I think that the process kind of laid the foundation for all the work we have done since then. And it, in a way, the process was essential for us raising awareness among ourselves also, that what is all this UN guiding principles and all the thing. And it was a lot of studying at that time, still in 2013 and 14, especially on this the concept of human rights due diligence. And I mean, we had already debate on legislative measures in 2013-14, and the NGO field was, the civil society was campaigning for, they called at that time a CSR law. But at that time, the discussion was not that articulated yet, and there was not enough political support for regulatory measures. So one of the key things that for me personally at least was in the National Action Plan, that we decided that we need this kind of multi-stakeholder sectoral roundtables to discuss more in depth that what does this due diligence mean in practice. And we had the process, then we started to discussing with the grocery trade, biggest Finnish companies, and trade unions, civil society. We had one on textiles and clothing supply chains. And as well as then we have this kind of a more cross-sectoral roundtable. And that was perhaps one of the key takeaways from the actual implementation of the National Action Plan, these processes. And we, with the grocery trade, we were able to find a shared vision with the companies and civil society and the ministries that what does due diligence mean in practice in grocery trade supply chains. And that was a really important work, because all of those issues that we discussed at that time are now also, or will be discussed as part of the kind of legislative process in Finland and at the EU level. And something this process also showed us that it's not enough that the UN or the OECD, they publish all these guidelines. And that, you know, it would be there and you just start implementing them, because the discussions show that you really have to study them and reach the common understanding on the points and what do they mean. I mean, the guiding principles, there were many issues there that they were not that clear, and we saw that our interpretation was a little bit different than what the civil society wanted, and the companies were thinking something in different way. So we saw that this kind of stakeholder discussions were really necessary to try to find a common understanding on these some of the things. And we also saw many differences in some of the very basic ideas. The first discussions were that we were not on the same page at all. And so that's, I think that here again, the process on the different components of any action plan and its implementation is important. And it's kind of this ongoing work. What was challenging was to find these kind of more concrete action points, especially further than, let's say, 2 or 3 years. So it was kind of, we kind of took this kind of pragmatic approach, and we then adopted a little bit on the way. Probably if we would have all the guidelines and guidances that are now out there done by different actors, well, the plan would look different. But at that time, they were not available, and they were perhaps some of them now kind of perhaps too state of the art. And I would also here say that, okay, it doesn't have to be the finest in the world. You know, just be pragmatic and try to find at least some of the key important points that you want to do in your country. And then, you know, put there what you can, because if you aim for this very perfect plan, it may just be too ambitious. And I think that, in fact, we ran out from all the operative action points already in 2017. So basically, we have kind of implemented the action plan. And at some point, it doesn't really guide our current activities anymore. The plan was there. Now we have done all the action points that we included. So, but as I said, I think it still kind of laid the foundation, and we just have continued some of the action streams, so to speak. And we have not gone back to revising the plan. And one reason for this is that discussion on possible due diligence legislation nationally or EU level or even the UN level through the binding treaty process. So much of the attention is now on these regulatory measures. So we thought that now that would kind of steal all the attention from other topics in the action plan, because it's not a national action plan. I don't think, and it was in our action plan as well, it's not the only thing. There's a number of things that you need in addition to regulatory measures in this field. So we have kind of waited, and we will have to assess at some point that what we want to do with that. And well, that's perhaps the due diligence process is that in our current government program, we had a commitment that we will do a judicial analysis on how this kind of law could be drafted in Finland. And this study was carried out. We published the Finnish version at the end of June, and the translation is already now also done now into English, and that's also now available. Well, the finding was, and I see this is a continuation from the roundtables on due diligence. At that time, you know, as I said, we needed more information. We had the roundtables, and there was another government in between. Now we have the current government, and they decided, okay, now it's time to do the study, and after that, to make some political decision if we want to go through the regulatory route. And well, the main findings are there that, okay, yes, it is possible to do this kind of legislation in Finland. We have kind of the study shows different components. What's the content of this due diligence obligation, and so on. There's kind of choices that you would have to think if you want to go this route. And then last year, I think also kind of continuation of our action plan was when we had the EU Council presidency, and we had our event in Brussels. Some of you were perhaps attending the event in last December. And I think the agenda for action, what we published at the end of the conference, kind of kind of crystallizes our thinking on business and human rights. In a way, we do all those things nationally in a smaller scale. So now there is a regulatory measure that's under consideration. We try to do something in development cooperation in third countries where the actual problem is. Well, we do have EU problems as well, but I think still the biggest risk countries are perhaps somewhere else in so-called developing countries. So we tried to do something there. We had the roundtables, we had multi-stakeholder discussions. So there are much more things than just the due diligence regulation. So there's a public procurement, other public finances. How do we integrate the guiding principles on let's say export credits? So that's I think the Agenda for Action kind of crystallizes our national thinking, and our point was, okay, we try to take this forward to EU level. So kind of summarizing perhaps is that for other countries that are thinking of it, there are now a lot more examples, and you just have to kind of try to see a little bit on the experiences of others that what would fit your country. There's not one template that fits all, and but as I also said that you can adapt along the way and get the process and the dialogue going. That's perhaps the most important thing. Okay, thank you.
Dear Ken, thank you for your presentation. And if anyone has questions now, okay, so let's continue with Andrew's presentation. Thank you for your patience, Andrews. It took a while. So Kent, if you'll be still connected afterwards, we'll have a discussion, and I hope that we'll try to somehow summarize the first two sessions. It will be easier if you still have some time, please stay. So, Andrews, floor is yours.
Thank you very much. Thank you for the refreshments on the microphone. So I'm Andrius Bambalas. I'm the chair of Lithuanian National Contact Point. And from the very beginning, I would like to thank for the organizers of the conference, for the Professor Ira Jakulevičienė, for Arnas Liauksminas, for the Ministry of Foreign Affairs. And from the very beginning also, I would like to bring everyone a bit back when we were younger, when we felt fresher. I mean, to the topic of the morning conference, in particular regarding, as the topic was of the morning session, tendencies in business and human rights area. And my presentation is in fact, about the importance of responsible business conduct in protection of human rights. And indeed, in the morning section, we heard the quite in-depth presentation by Professor Karen Boomen about proposals on the mandatory due diligence, what are the pitfalls, what are the difficulties, challenges regarding this. Also was a presentation on a discussion why mandatory due diligence maybe would be required, as the current regime does not provide sufficient protection for the victims. There was indication that there is maybe lack of protection, for the lack of compensation for the victims. It was by Christopher Putz indicated. But my presentation goes back to the basics. What is responsible business conduct, and what is this difference between, on the one hand, legal regime, which is international law of human rights, so known as hard law, and responsible business conduct. So indeed, international law on human rights, which for the lawyers is very easy to understand. You have conventions, you have international agreements that states entered into, which one with another or others, and states undertake obligations to respect, to protect, or to fulfill human rights. And when we have some violations of international law of human rights, based on the international human rights law, we have usually the actions against states. Maybe state violated human rights, or the proceedings, maybe some international, supranational bodies which deals with these disputes.
And business then comes into scene when the business itself violates human rights, then particular human rights that are applicable in that territory. So if a company in Lithuania violates human rights, Lithuanian court then will accordingly punish the company for such violations. But international human rights have limitations, and usually, as it happens with the law, the various formalities, including such things as territory. What is prohibited in one country not necessarily is prohibited in another country. What is considered as a violation of human rights in one country not necessarily is considered to be a violation in another country. And that's why, and that was one of the reasons why this concept of responsible business conduct as such evolved. Because there was either expectation from the companies, usually these companies that operate in several countries known as multinational enterprises, international corporations, or it was the promise by the company itself saying we are better, we protect human rights, our products are good, not tainted by any violations of human rights, that companies will behave not only legally, meaning what is required by the law, but they will behave in a manner where they present we're giving something back to society, or we address adverse effects of our activities, we are better, we're different, we're special. So indeed, in such case, when you have this responsible business conduct, which is like a soft law instrument, it's either the promise or expectation of the company, it's not the law. Because if requirement on how the state or company has to behave is enshrined in law, it becomes a matter of legality, not of responsible business conduct. Some use this term of corporate social responsibility. There is a bit of disagreement or interlapping between the concepts, but in this presentation, I'll use the concept of responsible business conduct. What are the actions then in this case? Then you either have the campaigns. So most well-known, these campaigns can be by various non-governmental organizations, NGOs, usually in regarding to the protection of the environment, sometimes workers' rights, various then violations that happen which try to affect the company to change its behavior. Or it can be complaints against the companies in the framework of responsible business conduct. The result of such is either the boycott of products or damage to reputation. Because again, responsible business conduct involves a lot of, let's say, requirements for the company. Human rights is some of them. So again, the damage to reputation is that there is announcement, or then there is a fact finding or a conclusion that company did not act in a manner that was expected from responsible business conduct. And of course, the conclusion that company violated human rights, even if indirectly, affects the reputation of the company. So the examples would be, what are the limitations of international human rights law, where the law ends when there are violations? So just several examples I'm using. For example, or this collection of cotton in Uzbekistan. So it's quite well-known issue for a long time, even starting 1920s. In Uzbekistan, the statewide program was initiated that every year when it's time to pick up cotton, pretty much everyone goes to pick up cotton. You're a doctor, you're a teacher, you're a school child, everyone is mobilized to go pick up cotton. Usually it's unpaid. In Soviet Union, with different notions about this, but after the Soviet Union collapsed and then independent Uzbekistan emerged, even in such times, when the notions about what is state property and that individual rights changed, still state mobilized population to collect cotton. There were complaints that it's forced labor, or during this period even slave labor, because nobody asks for the individual whether he wants to participate in program or not, the violations of human rights. What international instrument helps? It doesn't. So the situation is where the law ends, because the state says, well, we need its essential export of our, essential element of our exports, 16% of GDP. We need hard currency, US dollars, temporarily. It's a rich cultural experience. it just happens. Another example would be minerals in Democratic Republic of Congo, DRC, it's conflict minerals. No. Their problem is it's a failed state. It's not a state that failed state in a sense that state does not have effective control over its territory. Rich in minerals, challenges, let's say, in administration or in control. Plenty of rebel groups, when there are riches such as minerals, rebel groups, or factions with guns, force local population to work in illegal mines to extract minerals. Such minerals are sold, and that fuels local conflict. How, again, it would be looking from legal point of view to ensure human rights, meaning that there's no forced labor, killings, when even the state does not have control. So that's the end of law, you could say. Otherwise, would be other countries would have to come, but then you have the problems with sovereignty, maybe through United Nations to go, very cumbersome process. Third example, the most modern could be, plenty of such, is Xinjiang re-education camps in China. So I hope you are aware of the situation. It was documented for several years now. China built plenty of camps where it detains Uyghur minority people, different numbers. Some say it's more than 1 million, others more than 2 million. Nobody knows true numbers. People are forcibly sent into camps. China says there's no violation. It doesn't exist any violation. They're extremists. We're fighting with extremism. It's re-education. They're backward. We are teaching them language. They can live whenever they want. We're teaching them skills that they need in labor market. And okay. Also, it seems like the limit of the law, even though in the last months, some countries started to raise objections. EU, United States, others, usually due to size of China on the one hand and size of the other countries, the majority of countries are individually silent against this. So those are limitations when you could say allegedly or probably there are hard violations of human rights. It seems the law stops there. Alternative approach then is responsible business conduct, again, which might help to solve or at least to mitigate negative impacts of human rights violations. So with cotton in Uzbekistan, again, some companies, there was initiative, of course, by the NGOs and then by the consumer groups, consumers forced multinational enterprises, companies such as H&M, Tesco, IKEA, Adidas, Marks and Spencer's, they publicly announced, we will not use cotton from Uzbekistan in our products. So the approach from responsible business conduct is not to go after the state or these violators, but to make it, not to allow for to benefit from violations of human rights. So if the purpose of collecting cotton and using forced labor in Uzbekistan was to collect cheaply cotton, which is then given to state sells the cotton and earns hard currency, is to either make such cotton obsolete, meaning no buyers, but currently Uzbekistan sells its cotton to China, Russia, and this union of former Soviet republics, which is now this Belarus, maybe to these countries. They still manage to sell it, but they understand the problem. They feel the pain. There are changes. The pain is the price is much lower from what they could get if they were selling to, let's say, to companies which need cotton, which buy cotton, but decided to boycott. Again, there was also, it should be noted that EU also pressed Uzbekistan a lot. There was political pressure. It doesn't mean that business solves all violations of international human rights law, but it helps. Another example, minerals in Democratic Republic of Congo. So how to deal with this situation? There was this urge that indeed the situation is bad, that armed groups are getting finances from such operations, from these conflict minerals. So in the beginning was OECD adopted due diligence guidance for responsible supply chain of minerals from conflict affected and high risk areas. And based on this, again, we're including EU, including governments, various consultations, including businesses, and what was agreed is to have industry-based programs which are based under this guidance, and it's like company-led initiatives to check where these minerals come from, meaning to how to ensure that these minerals would not come from Congo, Democratic Republic of Congo, or even if it comes from Democratic Republic of Congo, that it's not extracting used forced labor on the controlled armed groups. So again, business, in a sense, you can say self-regulation of resistance, gathered together, how to try to address negative impacts. Again, I'm not saying it solved it. The Democratic Republic of Congo suddenly did not become one of the best governed countries in the world, but at least in this particular issue, it indicates that, again, it's business which helps to solve human rights violations. Situation on Xinjiang re-education camps, again, it's not that the business solved it, the business will solve situation in China, where China has a quite strong position on this. It has also invokes non-interference into local matters principle as a principle of international law, but again, currently there are calls from campaigners for multinational enterprises that operate in China not to participate in supply chains which use the forced labor from such re-education camps. So for example, there is this Australian Strategic Policy Institute study, Uyghurs for Sale, which indicate even how in supply chains well-known brands participate, meaning that they indicate that re-education camps does not mean that Uyghur minority people are locked only in Xinjiang. Some of them deemed to be re-educated enough are sent in other provinces of China, and they are locked in factories without access to outside world, and these factories then provide various goods or parts that in supply chain are further used for various companies, including Apple, Microsoft, various companies in semiconductor industry, in electronics, in all these instances. Now, regarding responsible business conduct, what constitutes and what is expected from responsible business conduct? Because again, business is not expected to save the world. We expect governments to do that. So what is responsible business conduct? There are several instruments or standards that deal with it, which define what is the meaning, what is the contents of such conduct. So among them are United Nations Guiding Principles for Business and Human Rights, OECD Guidelines for Multinational Enterprises, ISO Standard 26000, ILO Tripartite Declaration. There are other also various international standards. But the main expectation from business and what is expected from responsible business conduct. So on the one hand, even though business can make positive contribution to economic, environmental, social progress, but also it's recognized that business activities may result in adverse impacts related to corporate governance, workers, human rights, the environment, bribery, and consumers. And that's where we get back what is responsible business conduct and due diligence. And due diligence was continuously referred during today's presentations. So due diligence is the process that enterprises should carry out to identify, prevent, mitigate, and account for how they address these actual potential adverse impacts in their own operations, their supply chain, and other business relationships. So that is the essence, how responsible business conduct, or what responsible business conduct includes, or what is expected from responsible business. So it involves not only activities of the company, but which says according to the law, company is responsible only for its own actions. And then we have extraterritoriality problems. What if the laws of another country or company also operates, does not prohibit such activities? It also involves the supply chain, meaning if the responsible business should not shield itself under the corporate wheel, it should also check its supply chain, meaning from whom do you buy materials, parts, products, so that the company wouldn't say that I did not know that these materials that I use and is the main ingredient for my products were made by children. Who could have known? What a pity. Next, I'll try to do better. So again, legally company might be okay, there's no violation, but there will be problems with responsibility of such company. Also, how to do due diligence. A long time it was, as its soft law instrument left for the companies. It's based a lot of, depending on the size of the company, industry that operates, but there was no single standard saying, and even now, there's no single standard saying due diligence is this way and not other. But there are recommendations or guidance, and so OECD also recently adopted due diligence guidance for responsible business conduct, where it helps companies, for the companies themselves to answer to the major questions they have, how they should make their due diligence. And during the presentation, it was also indicated how to make, if it becomes law, there will be also problems, how to define what is due diligence. Because from my perspective, the biggest problem might be if there's a requirement regarding mandatory due diligence. I'm looking at Lithuania. My worry is that it should not become the same as it was under labor law. There was a requirement to have internal regulations under the labor code. And companies, they had such regulations. It was a standard document. They used to buy such from various firms. They present this document, they sign. If labor inspectorate comes, they say, yeah, we have these regulations, they're there. So the same might be if you make it mandatory with due diligence, they'll say, give us instructions, what we have to do. We don't care what to do. If it's a must, we must comply, but we will not look at the essence of it. And responsible business conduct is not about formality, it's about the essence. So what is the process then of responsible business conduct if it's an ideal process? Because the idea and functionality, when it actually works, responsible business conduct, all this process is beautiful. That's why even governments like it, they say maybe it's a good idea to make it mandatory because it helps to address various human rights violations, even they happen in other countries. So on the one hand, we have this responsible business conduct towards companies' internal activities. It all starts, of course, from the due diligence that the company has to make itself. Nobody knows better than the company where it operates, what are the risks, and that's why due diligence requires the company to do this due diligence report. As Professor Bowman indicated, it's not the same due diligence as in corporate. When you buy or sell companies, there's difference. Due diligence of activities of the company. Company has to identify, say how I'm going to rectify. So the company, as responsible business conduct, is a promise for society where it operates, promise for consumers that I'm responsible business. There's no obligation for the company to be responsible. Company can say, my only virtue, it's cheap. Price is my edge. How I get it, doesn't matter. And that's a viable strategy for some companies. But there are companies, even you know from practice, would say, they don't say we're cheap. Because on being cheap, yes, you have to go into a very huge volume to make profit. Usually you go and say, I'm not only cheap, I'm maybe new, I'm different, but also part of it is that we like environment, or we protect environment, that we look for the future. Companies want to be better. So in the beginning, company has to make a commitment and make it public or announce that it will be responsible business conduct. Because usually companies do not tell that, so they usually make some claims that we like environment. If you remember, before the coronavirus in Lithuania, there was a big scandal regarding the paper manufacturer in Lithuania. Who is from Lithuania? So what was the company involved in an environmental scandal in Lithuania in the beginning of the year? Grigeo paper manufacturer. In the advertisements, and even they have the product line where they refer that it's like ecological, that they are better, that they love environment. So in essence, they made this promise to the society, to consumers, that they don't make the cheap products, but that they are better, that they love environment. And of course, when consumer selects between different products, and in paper industry, there's not such a big difference regarding the products. It's not that one is so much better. There might be various, how many layers the paper has, maybe the color, and then it's the price. So when you make the selection which product to buy, you also look what the product says. If the product says I'm the cheaper, it might be important for you that I'm the cheapest. But maybe it says that I'm something better. But we love environment. We care for environment, they say. And when there is such scandal where there was environmental damage done and indicated the company in fact did not care at all about environment, it indicates for the society and consumers, it lets down consumers a lot. So there was a huge decrease in sales for Grigeo after the scandal broke. So it indicates that consumers, then they expect something from the company, especially if the company was not basing its strategy on the lowest price ever. And a lot of companies nowadays, they don't say I'm the cheapest. They always say I'm slightly different in reference to what is expected from responsible business. So in ideal world, companies should do due diligence. It should say, I'm committed to responsible business conduct, even if it's in different words. They can say for UN guiding principles, we love environment, we're different, and then it should report or publish its due diligence. Because if company indicates that I'm serious about responsible business conduct, it should indicate what were its findings regarding investigation on its activities, on what adverse effects it has. Because in due diligence, you also indicate you do the prioritization. The company cannot suddenly be without any risks, but the company can indicate. We have 3 risks. This year we are focusing on one of them. Next year we'll move on others. And how it becomes engaged with the customers or stakeholders, because there are 3 types of stakeholders. It's NGOs, employees, and consumers. It's that stakeholders, when they see that the company even publishes its due diligence, they can participate and comment on due diligence. They can help the company even to identify risks that the company probably they will hire some consultants, or internally they try to do this due diligence. Better, of course, that internally, because company knows best internally what its activities include. So then stakeholders can participate during drafting or during due diligence and indicate the company what might be the risks. Another might be that if stakeholders know that company cares, it might inform company about discrepancies from what it publicly announces, what is this promise for the stakeholders, and what is reality. Because, world is full of surprises. Even if company has the best policies and the best intentions, there always might be a bad apple, what is in a barrel. So it's better that the company has a channel of information, how to inform the company about the problems, rather than to learn it afterwards when something bad happens. So as an example would be slightly different than banks and money laundering. Not this year, last year. A lot of was information, various banks, Denmark, from Sweden, the branches in Estonia, in Latvia, money laundering happened, what's not mistaken, it's Swedbank, SEB even, not to mispronounce, but Scandinavian banks and problems. They were positioning themselves that they are better, they're responsible business, and you learn about that such things happen. Maybe it was a bad apple, but the question then is, did it indicate that not only responsible business were to inform if somebody, of course such somebody you probably will be somebody from within the bank, to inform the bank that bad operations happen. Because internally, it would have saved the banks not only reputation, but also cost for the fines they have to pay or the criminal charges that separately might be launched against them. So that's responsible business. In the ideal world, how it works, if companies announce not only that they care, but also what they have internally done, what are the risks. And third also is then what stakeholders do, they pressure or request an action from the company. If consumers identify that the company says, we love environment or something in these lines, but they identify that in supply chains, the company buys, for instance, soya from Brazil, from farms that last year was still Amazon jungle, they might pressure the company that it would change its practices regarding supply chain, or it might launch action or complaints, or they might campaigns do. They might go in shops, products that contain soya, they may put pictures of burnt out Amazon jungle and saying if you buy this product, that's you supporting these actions. So the various things what the consumers might do. Another responsible business conduct, what it includes, it's responsible business conduct towards companies' external activities. So again, it's not only a requirement that company has what is expected from responsible business is regarding the company's actions itself, but also it includes the supply chains and the links to where it participates. So it's relations with suppliers or investments, meaning the company might be investor in other companies. So again, what company is expected to do or can do, so requests, it might request the suppliers to commit to responsible business conduct, at least to indicate that they know about responsible business conduct, that they will not violate human rights, at least to send such confirmation at the very least, because that still raises awareness of the suppliers that it's important for their customer such issues. And also request to provide due diligence, at least some questionnaire or something about what is done within the company, that there are no violations of human rights. If it's not successful, either supplier is not respondent or the company then finds internally or through stakeholders that their supplier participates in human rights violations. Again, it's not the company itself that participates in human rights violations or alleged human rights violations, either can terminate relation with supplier, and if it continues, the company again might face the challenge from the stakeholders, because the companies are responsible for their supply chains. Again, responsible business conduct usually is not regarding the companies that violate human rights directly. It's about what if it indirectly participates in such activities through supply chains. So again, that's the difference and that's importance of responsible business conduct for the human rights. And as the topic was indicated from the beginning, what are the tendencies in responsible business conduct? And some of them were even addressed in this, in business and human rights area. So there is this increased importance of responsible business conduct among companies. It's not only by the consumers or stakeholders that it was pressed, also was encouraged by the governments themselves. There was the interest from governments, and this legislation or proposals for legislation indicate interest from the governments themselves that if it works, it's a very powerful instrument. And there is an increased use of national contact point network on the OECD guidelines. You've heard several times, and I think Professor Buman indicated that NCPs is one of these grievance mechanisms when violations happen. So again, national contact points. What is the difference of OECD guidelines for multinational enterprises from other instruments that deal with responsible business conduct? Only OECD guidelines have the grievance mechanism, meaning if stakeholder considers that there is a violation of this promise that the company made, it can go to the national contact point with a complaint against the company. The company violated OECD guidelines. OECD guidelines presents a list of what is expected from the business, what constitutes responsible business conduct. And every member of OECD has national contact point. And also the states that are adhering to the OECD guidelines for multinational enterprises, they also have national contact points. So there you can go. There was indication that national contact points, they do not provide compensation, and that is indication was as if it's a bad thing. So again, the system does not work that national contact point is adjudicator. It's not a court. National contact point, the interest is to help for the business to be responsible. If business is responsible and wants to be responsible business, then national contact point helps to mediate between the stakeholder and multinational enterprise, so that they would agree how to change. But if situation is that business doesn't care, never wanted to be responsible, even though maybe it made public commitments, national contact point will not force company to change its behavior. Because again, it's a soft law instrument, it's not a court, it cannot force somebody to do. And that is, on the one hand, is the strength of responsible business conduct. The tendency is that even though it works quite nice, there is a tendency for the governments to legislate and try to include parts of what is responsible business conduct into law. But if you make it part of the law regarding the substantive matters, then it becomes, let's say, not about the expectations of the business and about the legal ethics, business ethics, but it becomes about rights and obligations of the company. If it's rights and obligations of the company, you go to court. You go to court, you go to law. Law cannot regulate what is the contents of ethics. It can regulate what are rights and obligations. But if you go to the court, then it will go back to the same argument that I indicated in the very beginning, what laws were violated. International human rights law, they have this limitation set, including territory. Of course, it is possible for the government to adopt national legislation that has extraterritorial effect. Lithuanian parliament adopts regulations saying Lithuanian companies will pay penalties if they violate law. International human rights obligations, even abroad, can do that, but again, we'll have additional problem that usually it's not the companies directly that engage into activities, but in supply chains, we have problems, meaning that they buy from somebody who is involved or participates in violations of human rights. Then you have purely commercial relations, and then again, the law is stuck there. So one of the tendencies is that there is increased use of national contact points. There are more than 450 specific instances in all the network NCPs since 2000. Another tendency also, what I see, is that there is alignment of different RBC instruments. Because I mentioned there are various instruments, and that is confusing for the businesses also. They say, but various instruments, we use UN guiding principles, another say we use ISO 26000, another ILO Tripartite Declaration. I don't know, there's so many, I cannot follow them. We're good. So there is alignment, ILO, United Nations, OECD work together, and in essence, regarding contents, they're not different. All UN guiding principles can be explained or analyzed through OECD guidelines, and the same is with the other instruments. I mentioned that governments also, the tendency, are considering or putting at least part of RBC into national legislation, and also EU through directives or even regulations are putting part of what was RBC into mandatory laws. So thank you very much for opportunity. Now to give presentation, and if you have any questions, feel free to ask them. Thank you.
So thank you, Andres, for your excellent presentation. And once again, coming back to questions related to responsible business conduct and what National Contact Point is doing. So we still have a few minutes before our coffee break. It would be very nice if the audience could engage with questions, remarks to our conference speakers, because there are a few of them who are following from early morning. So floor is yours. Yes, Professor Liva Jakulevičienė.
Maybe I will start, because it's difficult after lunch to mobilize the questions and to think reasonably. But thank you very much for making the presentations. I have a question to Andrew Barnabas concerning the mandatory due diligence requirements.
almost all speakers have touched upon the mandatory due diligence requirements that are probably upcoming at the European Union level, and almost everybody said that it's going to be problematic. Now, in the context of Lithuania, my question to Andrus is, do you see any possibilities how to, let's say, if it becomes, or when it becomes mandatory, how to address those possible problems in the Lithuanian business? Is it a step-by-step approach that has been suggested by some of the speakers? Is it application to certain sectors, expansion by sectors, awareness raising, competence building up? What would you see as, let's say, few steps, maybe preparatory steps for what is upcoming? Yeah, that would be the question.
Thank you very much for challenging question. How to deal if such situation comes to Lithuania? So, again, being from national contact point, Lithuania national contact point is of opinion how to deal with due diligence as such, because we had also discussions previously when the directive, implementation of directive on disclosure of non-financial information became effective in Lithuania. It concerns big public interest companies. There are not so many in Lithuania, but they have to do due diligence. And there was also the question, which is also relevant today, what this due diligence should include, contents and how to make. So the position of Lithuania National Contact Point was that OECD guidelines indicate that if the law requires due diligence, it has to be comprehensive, and the position of the National Contact Point is it should be based on the guidelines and then on the guidance of OECD as instructive instrument, helping for the companies what it should include, but it's regarding the contents. How to deal if it becomes mandatory in Lithuania? Indeed, the biggest, let's say, to call it a problem is maybe not obstacle, that I think it's not relevant on Lithuania, but in other countries as well, is the awareness of the companies, how to do it. Analogical situation would be, when was it, 2 years ago now, it was suddenly became mandatory to have the GDPR, all the documents. When everyone knew about the deadline, but even a month before the deadline, everyone was like, we'll have it. And suddenly, all newspapers, then there was this, if you don't have, you'll get the fines up to, isn't it 3 or 4% from your turnover. Suddenly, everyone needed it. Prices were ridiculous. Everyone was rushing how to have it. We need such documents. The same might be with mandatory due diligence. How to deal with this in advance? One needs to prepare the companies for whom it might be, for whom the requirement for mandatory due diligence will be applicable in advance. Of course, it's better to have with them, as was indicated from the experience from Finland in round table discussions before maybe even passing the legislation with the companies. Because for the companies, at least the experience of National Contact Point is they come and say, tell us what to do. Whereas the due diligence of the company, it involves thinking by the company itself. It's not the set of instructions that it's 10 questions or 10 points that you have to go through and you are safe. Because each company has different activities. They know best the risks. They just need to sit and think. So what is required is awareness raising and then training. What is this due diligence? That it's not enough just to fill some papers. And also I think what is required, what companies usually maybe are afraid a bit, that they might think that it has to be perfect, that it has to be correct, and there is correcting and incorrect. Whereas in due diligence, it's rather not correct and incorrect. It's either, let's say, comprehensive or complete, and non-comprehensive and incomplete, but it's not so much you're wrong. So awareness and training in a sense.
If you have a remark, it can be 3 minutes. Yeah, okay, 3 minutes. It would be very nice. And could you switch on your microphone because other speakers couldn't hear you?
I would like to emphasize the thing that a lot of companies, a lot of presenters mentioned transparency on the one hand, and we all know about the data protection required from the EU on the other hand. And it's maybe quite difficult to combine those things, transparency and data protection. Maybe I think maybe this is one point which I would like to emphasize. The second thing I want to tell you is that in spite of the fact that Denmark is the least corrupted country in the world, this year it was involved, actually its bank, Danish bank, was involved in the money laundering scandal. And not only that, and I would like to ask you, for example, if a person wants to report about money laundering, and other things, how is people, so-called whistleblowers, are protected in Denmark and in Lithuania? Could you mention the laws that you Thank you very much.
Okay, thank you for your questions, and switch on the microphone. So it's a bunch of questions, and Kent, maybe you would be able to reply to the question related to the Denmark and the scandal on the money laundering, or maybe Karin, you have any knowledge what's happening out there and how you still are the country which is the least corrupted, but still even the very modern countries have faced these challenges related to the money laundering, etc.
Anas, this is the sound didn't go through properly, so I didn't hear the question properly. Could you please repeat it?
Yes, Karen, can we hear you very well?
Yeah. Do you hear me now?
Yes, we can hear you.
I'm saying that the question that was raised on issues in Denmark the microphone didn't go through well, so I didn't hear very well what the question was. Could you please repeat it?
Okay, the question is that Denmark is considered as the least modern country with a low corruption level. However, even Denmark banks was involved into the few corruption scandals related to money laundering. Maybe you are aware about the results, what Denmark did, how solve these issues, that maybe it would be an example, let's say, for Lithuania.
Okay, well, I'm afraid I have to say that this issue is a major issue in Denmark, and you're absolutely right that there is a connection to the Baltic states. I'm not an expert at all. I think, as far as I know, it's under investigation with the authorities. And I'm afraid I have to say that I don't think the Danish model is a model for anyone else to follow, and at least in terms of what this major bank did. So I'm afraid that's as much as I can say about that issue. Okay. And but maybe at a more general level, I think there's some very interesting things to think about when we see these annual reports by Transparency International that put countries like Denmark at the top of the list, because I think there is a tendency these Transparency International overviews to focus mainly on monetary corruption. And I think they overlook other issues like favoritism, which can be really serious as well, especially also if we look from a human rights perspective, that if somebody is awarded a favorable position or access to something, it essentially distorts the rights, the equal rights of others. And this is something that I think is also an issue for business and human rights, because companies are used to working, to negotiating without necessarily thinking about the fact that once they go into human rights issues, then they might end up distort equal access, especially when governments are also outsourcing the delivery of public goods to private companies. So I think maybe these stories that we heard about banks is a very good reminder, and I have to say that unfortunately this issue that you just raised is not the only one involving a large bank in Denmark at the moment. There are a number of other issues, and I think this is a very good reminder that we should not necessarily just trust in these very big, very powerful organizations, even though if they're charged with administrating the money of a lot of smallholders and savers as well as big companies, that if their internal governance is not okay, then there may be all sorts of responsible business conduct related problems that may arise.
Okay, thank you, Karen. So it seems that we're running out of the time. So for all those English speakers who are connected to the conference via Zoom, we just want to inform that from 1:45 we have a session where Lithuanian National Action Plan will be presented. However, the session will be conducted in Lithuanian. But afterwards, the last session, when we're talking about how to encourage business and how to align business with human rights, the final session will be again in English. So feel free to join to the last session. And now there is coffee served outside this meeting room. So until 1:45, we have a small break to fresh up and to come back to the conference room. So thank you for all the participants and questions for those who raised questions now. Čia, jo, man atrodo, dar pasitartų. Taip. Jiem ne anglų kalba. Gal čia bent esam, taip galima. Anglišką? Jo, tai galim paprašyti ir išsiųsiu aš tada. Tik aš nežinau, jo, tai pažiūrėsim. Jo, aš pasižiūrėsiu, kieno kontaktus turiu.
Aha, gerai. Aš tau atsiųsiu kitą versiją, nes paskui pas mane pirmas senas, bet šito komentaruose. Jeigu man sveikėlė yra tas komentarai, kur... Aš žiūrėjau, reikėjo. Labai geras vaikas, nes labai yra kviesti. I haven't said sorry for not meeting you when I got here. I'm so sorry. Someone like, you already passed you. It's like, something happens. So nice to meet you guys. Thank you. So I'll be watching. I guess in the last session, you would like me to speak with community experience a lot. And how are we going to set that up?
Still thinking how to do that, but actually 3 speakers will be online. So I think we will be able to move out there with the with the next seat, just to have distance. Yeah. And the moderator will come soon, and we will discuss questions for us. It will be quite interesting. What I think can probably and how then Marcus will come. We will ask questions. Yes, we will start talking topics of what how to and then we will have sometimes do a briefing about what to say. I do believe I will be starting helpful. But you see, I believe that there will be some issues because the three speakers are joining online. Two of three speakers will be here, so not a great time. It's going to be fantastic. Somehow we did it. So,
yeah, I'm going to I just wanted to waylay you. Oh, yes, and again, apologize for the confusion.
Sąjungos, ačiū darysiu čia, kadangi čia klausimų tai nebus tiek labai daug. Šią diskusiją matyt perkelsim šitą vietą, tą panelinę paskutinę, kur Lina dalyvauja, kur visi kiti, tai žodžiu, 3 kalbėtojai jungiasi online ir kiti ateina čia gyvai. Problema yra truputėlį su tais prisijungimais, nes...
Čia dabar, kurie čia kalbėtojai nuotoliniu būdu jungiasi?
Eimantas Martūnas, Sandra Adler ir Marta. Jie bus. sakau, gali būti, kad Eimantas po vakar pamiršęs, tai aš nežinau, ar ten tikrai nepamirš, tai nieko baisaus ir jisai prisijungs. Jo, tai dabar...
Taip, ištabdės tikrai angliškai vyksta, o šita pirma dalis yra lietuviškai. Kas yra pristato planą?
Aš manau, kol kas yra tai, o mes tada perkėsime į priekį, tada diskusija. Taip.
Kas yra pristato planą, tada yra be jos 3 žmonės, kurie turėtų atliekų, nes ten buvo parašyta prierašas, kad galbūt bus daugiau.
Jo, tai čia kaip patys yra, tai Andrius Lambolas yra, Aistė Ječkienė yra, jiems tiesiog šitai žodė. Tai pažiūrėk pagal situaciją. Padovanuot visose renginiuose, tai čia nebus problema.
O Andrius Lambolas yra teisininkas, ar ne? O kas yra tas National Fund?
Tiesiog yra ONCD toks įdėtis lietuviškai, tai yra nacionalinis koordinacinis centras. Nacionalinis koordinacinis centras, tai yra to centro vadovas. Ne su vyra, bet su Lina iš Kanados, kad jie dabar žinotų, kokius klausimus klausim. Nes paindikavo Linas, aš man panašu,
Ir taip pat jau man tokia, žinai, tokia gera dvasia. Paskaičiau 26 metų, kai mokymus. Ir 26 metus. Bijaučiu darbos žuvo, aš jisai planą žygiau. Ir paskui žiūrėjau pačiu šitą, 3 vietose save. Geras. Aš gyvoju, tokia save. Pačiausiai, kad akademinis gyvenimas buvo ne taip praplaukiamas. O jo, aš buvo moksliniai kodai ir remontuotas, kad jau pasižiūrėjau, kas su pokyčiais 96 metais. Tai dar mokslo konferencija, kaip turėjau atrodo tvari, tenai, kur tom aukšte tai pradžios. Viena teisės ir 2 teisės nuomonės. Kažkokia įbrukami kažkokia, kiek 14 metų. Jie sugebėjo su jais aiškiai su teisės muitas ar su teisės. Jie sakė, vos, skaičiuką, teisės sakė. Šis ir lašė kažkas. Aš mačiau vyresnėlį. Tai jau yra šitas skirtas. Tai yra žiūri galvoju. Tai čia iššakas. Aš jau pirmas skaičiu 86 metais. Šiaip žinau, tam
klausimas yra, kaip yra geriausia daryti kažkokią. Na dabar taip, įsivaizduok, prisijungs tie žmonės per Zoom'ą, tai mes jiem, aš žinau, matyt, turbūt tau sėdėt patogiau, stovėt. Jeigu tau,
nežinau, pirmą dalį tikrai sėdėt, nes mes nebus daug.
Jo, bet aš nežinau, gal tenais įkalbins ir gal sėdėt, nu, taip aš galėčiau tada tuos kažkaip, nu, junginėt čia kažkaip tuos žmonės, nes kažkaip yra.
Taip, dėl skysčio, kad nepatektų į mikrofoną. Triuką padarysiu.
Mes viską čia dezinfekuojam.
Tai gal tada taip aš galėčiau kažkur iš krašto atsisėsti, kad mateičiau žmonės.
Vienas taip prasidėjo visą laiką.
Bet tai tavo visa buvo ta garbė. Taigi
Aš žinau, bet aš būtum sakęs, kad į mane taip įsižies, aš čia pasivežęs galbūt.
Ir be
Kur dabar
pasidažymo.
baigias vyrai irgi, tai mes čia būsim, ar čia? Ar čia?
Aš manau, kad taip, o aš čia kalbėsiu.
Tai gerai, tada aš Aistą pasodinsiu priekį.
Jo, kad aš...
Ok, tai dabar yra toksai dalykas, žiūrėk, ana sesija, kaip darom su filmavimu, nes vyras stovi čia.
Kažkaip kaip kalbėti, aš apsistengiu, nes čia mes vis tiek be kaukių neteiksim visi. Nes aš tai nelabai noriu su kaukė, nes...
Tai gerai, aš žinau.
Aš galiu ir iš tenai išnekėti, kaip žinai, diskusijoje, tai... Gerai,
Jeigu kas ant kėdė kažkas susijęs iškilus.
Tik tai, kad aišku, bet ar kamera, tai diskutantas čia?
Klausimas yra kaip su kamera, tai jeigu pasukom tada kamerą...
Kamerą tai galim sukioti, čia ne problema.
Tai jo, tai kažkaip...
Nes čia realiai 3 žmonės maksimum tik tai gali sudėti. Aha.
Šitoje diskusijoje tada aš pasuku kamerą, viskas yra tai. Anoje diskusija turbūt irgi, čia nieko mes to nieko čia stebuklingo neišsakysiu. Tai matyt turbūt vis. Sorry, kad šitą sugaišau. Tai žodžiu, aš nežinau, kokia ten ta vaizdo kokybė, nes ta kamera neapima visos panelės. Tai jeigu atsisėsiu iš krašto, tada pasisodinsim...
Aš manau, kad man ten mažiausiai reikia matyti, gal daugiau nebent diskusijų dalyvius ten dėmės.
Tai žinai, klausimas yra dėl garso. Čia yra dar problema su tais mikrofonais, kad truputėlį fonuot gali, visą kitą, tai... Nu, gali būti. Nu, bet matysim, tada, ta prasme, kai einasi, ten dažniausiai žmonės prašo, tai girdim, tai tada kažkas spręsim vietą.
Nes taip, toje panelėje vėliau bus 3 žmonės. 2 net tik tai gyvai.
Aha, o čia kaip kas ką? Kur čia dabar tos prezentacijos?
Gerai, aš galiu šitą gal pasidaryti. Aš sklandu nebereikės. Tai tikrai žinau, kad išsikėliau, va čia man.
O man čia...
Tiesiog šitame.
Šitame?
Tik tu man viskas veikia. Klausytoja, kažkas ar klauso, kažkas tai va užkąsim šaukščiau, kad netrūdyti.
Taip, ir man tada reikės mikrofoną čia, ne?
Jo, mikrofoną prijavo, kad nepatektų skysčio.
Ai, nes aš tai mačiau, taip yra daroma renginiuose, dėl to aš kažkaip net nebijau, bet matyt, kad gadinasi gal visgi.
Nu, matyt.
Žinau, tada dezinfekcija, mes apsipurškiam. O tada jūs tenai?
Aš per tą gal...
Per vidurį, ne? Nes, jeigu 3 žmonės, aš manau, tada gali be kaukių, jeigu tenai sėdėti. Nes, vis tiek jums geriausia būtų.
Aš tai manau, kad man tinka ir čia prisėti, ypač dabar, kai jūs darysite pristatymą ir čia bus daugiau...
Tai žiūrėkit, kaip, nes vis tiek tada kažką... Aha. O tada ką Arnai mes vadinam prie to stalo dar? Ir viskas, ne? Dviese jos, ne? Gerai. Nes aš va ten įsitaisiau, tai žodžiu...
Jo, bet aš manau, kad galite iš krašto atsisėsti, tada bus visi 3 žmonių panelė. Tai jokių problemų, jeigu būtų daugiau klausimų ir visi galėtų pasakoti.
Nu tai aš ten ar čia, tai... Aš tai noriu be kaukės, nes... Bet vis tiek, dėl kitų žmonių, kažkaip ne visi gal nori, kad tam šalia, tai dėl to nelabai mes ten tilpsim.
Nes dabar, po jūsų pristatymo bus Andrius, kuris dar irgi taip pat savo požiūrį.
Pirmiausia, tai reikėtų užsienio reikalų ministerijai, tai pirmiausia, jo, nes jie yra tokie kaip ir šeimininkai iš to plano.
Bet o Ričardas iš to pasakys, tai jau tolimesniai, kur mes apie verslą kalbėsime.
Jam pasisakė, pasiteiksim žodį.
Bet reikia ir socialinės apsaugos ir darbo ministerijos yra atstovė.
Aha, tai va.
Tai ją reikėtų po... Neringa Dulkinaitė, man atrodo, aš pasižiūriu kažkur. Tokia su žaliu. Galima ir dvies kažkas. Jo, nes 20 postai kažkaip gerbkim su lygo.
Jeigu šitą visą dalis lietuviškai, tai čia reikia dar net nebe kalbėti, o į kitą diskusiją mes
kas atėjo, kaip laimė, tik tai pažiūrėti galima. Aha, va čia, jeigu.
O tai gal ir šalia neringio gali papasakoti? Tai jūs žiūrėkit, mes čia matome 3 žmonės. Tai vienas.
Taip, sveiki gyvi. Šita sesija yra lietuvių kalba, tai galiu kreiptis jūs taip. Jau, kaip suprantu, dirbate pusę dienos įtemptai. Dabar pakviesiu jūs išgirsti apie Lietuvos nacionalinį veiksmų planą, jo iššūkius ir taip pat galimybės. Čia pristatys Mykolo Romerio universiteto profesorė Lyra Jakulevičienė. Vėliau taip pat turėsime dar progos išgirsti iš partnerių jų įspūdžius, jų įžvalgas ir kaip jie vertina išvardintas ir išvelgtas galimybės bei iššūkius. Tai ilgai nedelsdamas, manau, iš jūsų kviečiu profesorę pristatyti.
Sveiki dar kartą. Tikrai labai puikia proga pristatyti kol kas dar ne plano, tik tai plano projektą. Ir kaip kai kurie pranešėjai kalbėjo, kad apskritai turbūt visose valstybėse skirtingai nuo ankstesnių planų, pirmuosius planus, kurios valstybės parengė, kad jau antrųjų, trečiųjų planų parengimas Lietuvos atveju, tai yra antrasis planas, jau vyksta dialoge su suinteresuotomis grupėmis, su suinteresuotais asmenimis, o ne vien tik tai vienos institucijos ar kelių institucijų
kabinetuose, koridoriuose ar dar kažkur. Tai dar kartą dėkoju už galimybę Užsienio reikalų ministerijai, už galimybę prisidėti mūsų akademiniai bendruomeniai prie Lietuvos nacionalinio veiksmų plano rengimo, būtent projekto. Ir aš trumpai šį plano projektą pristatysiu tam, kad galėtumėm iš tiesų padiskutuoti, nes tikslas ir yra toksai, kad mes turėtumėm galimybę padiskutuoti apie tai, kas yra dar planuojama, nes kiek suprantu iš Užsienio reikalų ministerijos ir darbo grupės, kuri 19 metais sukurta šitam planui parengti, kad dar galimybės tobulinti yra prieš planui patenkant į tas rankas, kur jau jisai bus patvirtintas. O išties, turbūt galbūt kolegija iš Užsienio reikalų ministerijos daugiau apie tai pasakys, bet skirtingai negu 2014 metais patvirtintas planas, antrąjį planą yra visgi planuojama, tikimasi, kad jis bus patvirtintas kaip norminis teisės aktas. Ir atitinkamai tai irgi lėmė šito plano turinį. Jeigu mes lygintumėm šio plano projektą su daugelio kitų valstybių, kurios yra pasirinkusios visgi struktūrą pagal 3 jungtinių tautų principų ramsčius, tai šis planas irgi yra grindžiamas ir jungtinių tautų principais ir kitais svarbiais tarptautiniais dokumentais, tačiau jame tie 3 ramsčiai taip aiškiai neatsispindi kaip kituose planuose, kitų valstybių planuose. Bet tai vėlgi yra sąmoningai atitinkamai norminio akto kūrimo procesas, jisai sąlygoja ir tai, kad visgi yra tam tikri formalūs reikalavimai, kurie yra ir gerai, ir kažkiek tai apriboja tokį procesą. Tai pirmiausia, kalbant apie pačio plano rengimo kontekstą, noriu pratęsti mintį gerbiamo prieš tai kalbėjusio pranešėjo Andriaus Bambalo, kuris pasakė tokią tezę, kad gelbėti pasaulį tai nėra verslo funkcija, verslo reikalas, kad visgi tikimasi, kad valstybė tą pasaulį gelbės ir tas žmogaus teises užtikrins. Tai tikrai turbūt nesiginčysiu su kolega Andriumi, bet būtent ir norėčiau patį kontekstą nacionalinio plano rengimo pristatyti štai per šiuos 2 subjektus. Tai yra, koks yra kontekstas pačiam verslui, ir kokios yra naudos turėti tokį planą valstybei, būtent pačioms įmonėms, ir taip pat, ką toks planas duoda valstybei, kodėl valstybė, kodėl Lietuva tokį planą turėtų rengti, apart to, kad jau pirmas buvo parengtas ir lygtai, kaip gerbiamas viceministras minėjo įžanginiai kalboj, kad reikėtų jį atnaujinti, nes labai daug visko pasikeitė. Tai apart to, ar yra dar kažkokios tai naudos pačiai valstybei tokį planą turėti, ne vien tik tai dėl formalių paskatų, bet ir dėl kažkokių realių naudų. Tai pirmiausia, jeigu kalbėti apie kontekstą, kuriame veikia verslas, tai kartais girdim tokias nuomonės. Mes čia veikiam Lietuvoje ir kažkaip mums visos tos problemos žmogaus teisių, mes esam normalioj valstybei, visos tos problemos žmogaus teisių mums nelabai kaip ir rūpi, pas mus yra darbo kodeksas, yra visi teisės aktai, baudžiamasis kodeksas, jeigu jau verslas kažką blogai darytų, tai atitinkamai verslas susidurtų su įstatyminiais reikalavimais ir čia apie kažkokius lūkesčius nekalbam, tai yra teisė ir verslas irgi turi laikytis teisės. Ir kodėl dabar reikia štai kažkokio tai plano, kuris bandytų verslą įtraukti į žmogaus teisių klausimus, kurie lygtai ir nėra verslui tokie būdingi ir atsižvelgiant į tai, kad visgi turbūt pagrindinė funkcija yra vykdyti veiklą, kuri duoda pelną, ir po to ar ten dalinti su tuo pelnu, su visuomenė, dar su kažkur tik su akcininkais, jau turbūt yra pačios įmonės diskrecija. Tai iš ties, jeigu pasižiūrėti kontekstą, kodėl Lietuvos verslui visgi toks planas neturėtų būti visiškai svetimas ar nėra visiškai svetimas, yra tai, kad nepaisant to, kad Lietuvoje veikia tas vadinamasis lietuviškas verslas, visgi vis daugiau ir daugiau mūsų Lietuvos įmonių investuoja užsienyje.
Ir tose užsienio valstybėse tikrai situacija ne visada yra gera. Kitaip tariant, susiduriama ir su daug didesnėm korupcijos rizikomis, kurios irgi duoda savo pasekmę žmogaus teisų laikymuisi. Taip pat susiduriama su didesnėmis žmogaus teisų rizikomis. Ir štai dėl to yra svarbu Lietuvos verslui irgi turėti įrankius, galvoti apie tai, planuoti, vertintis tokią riziką, na ir imtis priemonių tokios rizikos išvengti. Be abejo, net ir tos įmonės, kurios, sakykime, neinvestuoja tiesiogiai užsienio valstybėse, visgi Lietuvos įmonės dalyvauja toj globalioj vertės ar tiekimo grandinėje, dabar irgi terminija keičiasi, ir yra kažkieno tiekėjais, iš kažko perka žaliavas, perka paslaugas ir panašiai, ir atitinkamai vėlgi tai, už ką įmonė atsako Lietuvoje, nebūtinai gali būti jau tos ribos. Tos ribos tikrai plečiasi atsižvelgiant į tai, kad Lietuvos įmonės dalyvauja globalioje rinkoje ar būtent per tiekimo grandinę. Tai vėlgi tas rizikas reikia įsivertinti, na ir kuo geriau mes jas mokėsim vertinti, tai tuo matyt verslui bus lygiai taip pat geriau. Na, vėlgi matom, kad globalių mastų, ES mastų, čia tikrai jau nemažai kalbėta, kad lūkesčiai verslui didėja. Tai yra lūkesčiai atsižvelgti į žmogaus teisų aspektus, vertinti savo poveikį, nes visa tema verslo ir žmogaus teisės yra būtent susijusi su to, kaip verslas vertina savo poveikį ir kaip tokį poveikį valdo. Ar tai būtų neigiamas, ar tai būtų teigiamas poveikis. Na ir matome taip pat, kad plėtojasi taip vadinamo atsakingo investavimo tendencijos ir atitinkamai verslas, kuris siekia pritraukti investicijas, kuris siekia gauti kapitalo, skolintis, vėlgi gali būti, kad susidurs su vis didėjančiais reikalavimais, vėlgi tam, kad ir bankams nebūtų rizikinga verslui skolinti. Tai iš tiesų pasakyti, kad Lietuvos įmonės, kurios veikia tik Lietuvoje, turėtų galvoti tik tai apie tai, kad yra darbo kodeksas, baudžiamasis kodeksas, čia jau verslas turbūt. Tai turbūt šiai dienai nelabai galim. Na ir kalbant apie naudas, tai toks planas, jis nėra tiesiogiai nukreiptas, sakykime, į konkrečios žmogaus teisų problemos sprendimą, kadangi tam, kad pradėtumėm spręsti problemas, turbūt pirmiausia, mes turim susitart, kad visgi verslui yra aktualu, reikia ir kad ne tik valstybei reikia, ir kad tikrai yra naudinga verslui tokias rizikas žmogaus teisų įsivertinti ir tą poveikį žmogaus teisėm valdyti. Tai tokiam planui, priėmus tokį planą, iš tiesų verslas turės daugiau įrankių, kaip tokią riziką vertinti, nes galima kalbėti apie tai, kad atskiros įmonės kažkokius tai įrankius, metodologijas ar kažkokius mokymus vykdys atskirai, na, o galima iš tiesų tai daryti kartu verslui, valstybei ir kitiems susijusiams šalims apsijungiant ir parengiant geresnės sąlygas realizuoti tiek rizikos valdymo mechanizmus, tiek ir poveikio vertinimą. Be abejo, jeigu būtų įgyvendintos plano priemonės, tai tokios, kokios dabar yra numatytos, tai tikrai būtų palankesnės sąlygos toms įmonėms, kurios diegia įvairias žmogaus teisų poveikio žmogaus teisėm valdymo priemonės, geresnės būtų sąlygos tiek gauti kapitalą, investicijas, tiek ir geresnė būtų, sakykime, pozicija viešuosiuose pirkimuose ir viešuosiuose pirkimuose ne tik Lietuvoje, bet ir dideliuose tarptautiniuose pirkimuose, kuriuose mūsų įmonės jau dalyvauja. Be abejo, gerėtų tarptautinis konkurencingumas, gerėtų pačio verslo, Lietuvos verslo reputacija. Na ir aišku, verslui taip pat tokie planai yra naudingi, nes jie labai aiškiai pasako, va štai ko valstybė tikisi. Tai šiai dienai, kaip matysim, kai kalbėsiu apie problematiką, kurią planas sprendžia, visgi šiai dienai nėra tokio vieno dokumento, kuriame aiškiai būtų pasakyta, kad štai yra tie tarptautiniai įsipareigojimai, jie yra mūsų įstatymuose, bet tie vis didėjantis lūkesčiai ES mastu ar pasaulio mastu, kokiegi jie yra, kogi yra tikimasi iš verslo. Na ir kalbant apie valstybės kontekstą, pačios Lietuvos kontekstą, tai be abejo yra daugybė politinių įsipareigojimų, čia neleis man ir užsienio reikalų ministerija su jūsų klaidinti, kad tiek ir stojant į ekonominio bendradarbiavimo ir prekybos organizaciją, netgi buvo keliama kaip viena iš sąlygų narystės, kad turėti tokį planą, įtraukti verslą į žmogaus teisių klausimų sprendimą. Na ir taip pat turbūt akivaizdu, kad valstybė turėdama pozityvius įsipareigojimus, tai yra ne tik tai savo įstatymais ar kažkokiom kitom priemonėm užtikrinti, kad žmogaus teisės nėra pažeidžiamos, bet taip pat turi pareigą užtikrinti, kad ir privatūs subjektai, ir tame tarpe ne tik tai fiziniai subjektai, bet ir juridiniai asmenys tų žmogaus teisų nepažeistų, arba jeigu jos yra pažeistos, kad būtų užtikrinta tų teisų gynyba. Tai žinoma, galima kelt klausimą, na, kaip valstybė gali tai užtikrinti, jeigu verslas nebūtų toks sąmoningas, nesilaikytų tų žmogaus teisių, na ir tokiu atveju be abejo valstybė savo įsipareigojimų pagal tarptautinius žmogaus teisų dokumentus negalėtų užtikrinti. O verslas tokių tiesiogiai įsipareigojimų, kaip jau ir ne vienas pranešėjas minėjo, šiuo metu kol kas nėra nei vieno tarptautinio privalomo dokumento, kuris įpareigotų verslą tiesiogiai vykdyti tiek žmogaus teisų verslo poveikio žmogaus teisėms vertinimą, tiek, na, sakykime, imtis konkretesnių veiksmų. Tai tokio bendro tarptautinio įsipareigojimo nėra ir visgi valstybė ir tiek Lietuva, tiek ir kitos valstybės ieško įvairių būdų, o kaipgi įtraukti verslą, kaip verslui parodyti, kad visgi yra naudinga šitam procese dalyvauti. Ir štai nacionalinis veiksmų planas, jisai būtent yra viena iš tų priemonių, kurią Lietuva, kaip ir kitos valstybės, pasirinko tam, kad, na, pagerinti tą situaciją, verslo įtraukimą ir, aišku, atitinkamai netiesiogiai turėtų gerėti ir tų įsipareigojimų vykdymas. Na ir naudos, aišku, valstybė yra, turint tokį planą, ne tik tai politiniam kontekste, kad iš tiesų Lietuva, kaip ir kitos valstybės, visgi skiria didelį dėmesį tokiam svarbiam klausimui kaip žmogaus teisės, kurios neatsiejamos ir nuo demokratijos, ir nuo gero valstybės valdymo, bet taip pat tyrimai rodo, kad šalis, kurios skiria dėmesį šiems klausimams, verslo įtraukimui, turi tokius nacionalinius veiksmų planus, kad tokiose šalyse investicinis klimatas yra vertinamas geriau, tai vėlgi tai valstybei yra pridėtinė vertė, pritraukiant investicijas. Na ir be abejo, kuo verslas sąmoningesnis, kuo jis labiau įsitraukęs, kuo labiau supranta tas galimas problemas ar galimybės šitoj srity, tuo gerėja matyti ir pati žmogaus teisų situacija tiek toj valstybei, tiek ir mažėja rizikos, kad tarptautiniu mastu mūsų verslas įsitrauks į netinkamas, tiesiogiai ir netiesiogiai netinkamas praktikas. Tai kažkodėl man nepasikeičia skaidrė, nežinau, ar pagelbėsit man. O, tiesiog labai daug, viskas tvarkoja. Taip, tai tiesiog keletą žodžių irgi apie tai, kokiasgi problemas sprendžia planas ir kokių rezultatų yra siekiama, nes, kaip minėjau, pats planas jis nėra nukreipęs į kažkokios konkrečios žmogaus teisų problemos sprendimą, kadangi pirmiausia būtina sudaryti sąlygas, kurioms esant verslas įsitrauktų, verslas diegtų metodikas, kaip gyvertinti savo poveikį, na ir imtųsi tam tikrų priemonių. Tai iš tiesų mes esam turbūt toj stadijoje ir galbūt tik po to galima kalbėti apie tai, kad spręstų kažkokias konkrečias problemas. Nors, kaip minėjau, netiesioginis rezultatas, kokio siekiama planu, tai yra būtent geresnės žmogaus teisų padėties tiek Lietuvoje, tiek ir už Lietuvos ribų. Tai tiek pačiam plane yra identifikuota tiek ir aš norėčiau keletą žodžių tarti, kokios yra tos pagrindinės problemos, kurias šiuo planu yra planuojama ar siekiama spręsti. Tai pirmiausia, jeigu pradėti nuo tokio gan plataus ir gan abstraktaus dalyko, bet be jo matyti neįmanoma apskritai, ką nors būtų daryti ir tikrai būtent dėl to buvo labai sunku patį planą ruošti. Tai yra Lietuvoje apskritai nėra vykdomas nei vertinimas, nei kažkokia stebėsena, o kokiagi yra apskritai žmogaus teisų padėtis versle Lietuvoje. Tokie tyrimai nėra atliekami, nei toks bazinis tyrimas, nei kažkokie pažangos vertinimai nėra atliekami. Tai iš tiesų tada galima kelt klausimą, na, o kaip galima kažką planuoti ir kaip, na, ir galbūt ir su verslu diskutuoti, kai mes nežinom iš tiesų, kokiu mastu tos žmogaus teisės Lietuvos versle yra susijusios su tam tikrų neigiamų poveikių ar kokios kitos galimybės verslui. Tai jau buvo minėti tie keli lietuviški pavyzdžiai, kai 30% nukrinta lietuviškos įmonės Grigėjo akcijos po situacijos susijusios su neleistinais išleidimais į užteršimų vandens, būtent per aplinkosauginę prizmę, bet mes irgi net ir šiuo atveju matėm, kad mažai buvo keliamas klausimas dėl žmogaus teisų, buvo daugiau keliamas klausimas dėl aplinkos, nors jeigu šiaip pagalvojus, tai tikrai galima būtų kalbėti ir apie tą teisę į švarią aplinką, tai yra kaip, sakykime, ta situacija paveikia bendruomenę, kuri gyvena prie tų telkinių ir panašiai. Tai vėlgi, neturint duomenų, nesekant, neanalizuojant padėties, tikrai yra sudėtinga kažką planuoti. Tai dėl to pats planas, turbūt priemonės ir prasideda nuo to, kad mes turėtumėm įsivertinti, kokia yra situacija, nusistatyti kažkokius kriterijus, kaipgi mes matuosim pokyčius, kokių mes pokyčių norim. Ir štai tikimasi, kad įgyvendinus šį planą, kad vėlgi atsiras tokia, na, visiems prieinama aiški informacija apie tą būklę, esamą būklę Lietuvoje. Na ir tokia informacija bus nuolatos atnaujinama tam, kad galėtumėm iš tiesų vykdyti, tuomet ir diskutuoti ir žiūrėti, kaip tas problemas, jeigu tokios problemos yra identifikuojamos, kaip jas spręsti. Taip pat yra akivaizdu, kad trūksta tiek informacijos, tiek aiškumo apskritai ir tokio susisteminimo vienoj vietoj tų vadinamųjų naujųjų lūkesčių. Nes, kaip minėjau, tikrai planų nesiekiama teikti informaciją ar informuoti verslą apie tai, kas yra mūsų įstatymuose. Tikrai plano tikslas toks nėra. Plano tikslas visgi yra būtent vienoj vietoj pateikti tos lūkesčius, kurie jau virsta teisės aktų reikalavimais, bet vėlgi, kaip minėjo kiti pranešėjai, tie teisės aktų reikalavimai vėlgi jie nebus taip tiesiogiai Lietuvos teisės aktuose įtvirtinti, jie bus perkelti per kažkurį laiką ir panašiai. O verslui reikia ruoštis jau dabar, tai iš tiesų žinoti apie tuos reikalavimus. Tai yra tikimasi, kad iš ties vienoje vietoje tokius reikalavimus ar tokius lūkesčius pateikus, na ir numačius priemonės, kaipgi pasiruošti tokių lūkesčių įgyvendinimui, ypatingai dėl išsamios žmogaus teisų poveikio patikros, to vadinamo due diligence reikalavimo, kad iš ties įgyvendinus planą daugiau įmonių savo politikoje, savo praktikoje, savo strategijose atsižvelgs į tuos reikalavimus, na ir tiek vykdys tą išsamų patikrinimą, tiek turės mechanizmus ar įdiegs mechanizmus, kaipgi valdyti poveikį, kokį verslo įmonė daro žmogaus teisę. Na ir vėlgi su tuo susijusi problema, kurią planas sprendžia, tai kad dažnai, kai mes kalbam apie verslo ir žmogaus teisų tematiką, na, kalbam apie tai, kad valstybei reikia ir o kur čia verslui ta nauda, tai tikrai neretai nėra pabrėžiama, kokia yra ta nauda. Nėra pakankamai identifikuota tos praktikos nėra labai daug. Tų įmonių, kurios diegia žmogaus teisų principus, vertina savo poveikį, imasi tam tikrų priemonių. Tai vėlgi tikimasi, kad plane numatytos priemonės, tokių gerųjų praktikų identifikavimo, sklaidos, kad vėlgi tai prisidės prie tokio įrodymais pagristų argumentų, kodėl verslui yra naudinga visgi diegti šias priemonės. Na ir be abejo, jeigu kalbam vienas iš tų jungtinių tautų ramsčių ir tikrai nemažai kiti pranešėjai, užsienio pranešėjai kalbėjo
apie veiksmingas teisinės gynybos priemonės, kad tikrai daugeliu atveju yra nemažai problemų ir aišku, čia nediskutuosim apie tai, kaip Afrikos gyventojams Europos teismuose ginti savo teises. Tikrai aš tų klausimų neliesiu, jie yra labai probleminiai, bet nėra mūsų plano turbūt tikslas. Bet vėlgi plane yra bandoma pasižiūrėti, o kaip suefektyvinti tiek prevenciją, nes faktiškai dabar tokios kaip ir prevencijos, konsultavimo verslui kaip ir nėra. Man pačiai labai patiko praktika lygių galimybių kontrolieriaus tarnybos, kuri liktai ir visada dirbdavo tik tai su kokiais tai nukentėjusiais asmenimis ar valstybinėmis institucijomis ir pastaraisiais metais labai nemažai išvystė, labai neblogai išvystė konsultavimą verslo, tai yra darbas su verslu, kuomet yra tam tikri atvejai, kurie yra ant ribos, sakykime, ir tai vėlgi padėjo tikrai išvengti ir pačiam verslui išvengti tam tikrų rizikų ir kaip kai kurie pranešėjai minėjo, kad viena iš problemų, kodėl, sakykime, ir tie privalomi instrumentai, tokie kaip išsamios patikros, ne visada veikia, yra tai, kad, versle juk nėra ir tos ekspertizės, versle yra kitos ekspertizės, tos, kurių reikia vykdyti verslą. O tos žmogaus teisų tokios ekspertizės, kad pasakyti, kad štai vienokia ar kitokia veikla, kad mūsų pateiktas skelbimas ar sakykime, kažkoks projektas, kad jis gali padaryti neigiamą poveikį ar pagaliau identifikuoti kažkokius tai pozityves galimybės verslui. Tos ekspertizės ar kompetencijos tikrai nėra. Tai štai toksai konsultavimas, jisai tikrai suteiktų galimybės vykdyti tokią prevencinę veiklą. Tai plane vėlgi yra numatomas priemonės, kas galėtų konsultuoti verslą, kas galėtų tokį dialogą su verslu vykdyti, ir tai pasitarnautų iš tiesų geresniai prevencijai žmogaus teisų pažeidimų ar kokio tai neigiamo poveikio, ir taip pat būtų veiksmingesnis teisių gynimas, jeigu tos institucijos, kurios šiai dienai gina žmogaus teises, tai yra užtikrina teisinę gynybą, kad vėlgi jos šios tematikos specifiką išmanytų ir atitinkamai tokia gynyba būtų veiksmingesnė. Ir paskutinis aspektas, kurį aš norėčiau paminėti, kuris tikrai plane yra ne paskutiniai vietoj, eiliškumas čia nėra sudėliotas toje skaidrėje, tai yra tarp institucinio koordinavimo trūkumas, nes žmogaus teisės ir verslas tai yra tikrai labai plati tema, kurioje dalyvauja jau vien ministerijų kompetencijas pasižiūrėjus, ministerijų funkcijas, tai tikrai įvairios ministerijos. Ir štai nesant tokio bendro sutarimo, kokiosgi turėtų būti tos priemonės, kaip tas priemonės koordinuoti tarpusavyje, tikrai būtų matyti sudėtinga pasiekti kažkokių rezultatų. Tai tiesiog džiugu irgi pasakyti tai, kad, ką ir minėjo kai kurie pranešėjai, kad kai kurios valstybės pasirenka tokį lengvą kelią, kad įtvirtinam tas priemonės, kurias ministerijos ar kitos institucijos ir taip vykdo, ir tokiu būdu, žodžiu, viską sudedame vieną krūvą ir čia bus mūsų tas planas. Tai tikrai ir turbūt ir mūsų pirmasis planas Lietuvoje galbūt ir buvo tas kelias, bet tikrai džiugu tai, kad jau antrasis planas, jisai tikrai eina toliau, yra numatomos ir naujos priemonės, ir būtent numatomas tas tarp institucinis koordinavimas, stebėsino, priežiūros mechanizmas, ir būtent tas priežiūros mechanizmas ne tik tai toksai formalus, bet įtraukiantis taip pat ir profesinės sąjungos, ir darbdavių atstovus, ir akademinę bendruomenę, ir numatantis įvairius įrankius, kaipgi bus ta stebėsena vertinama, kaip jinai bus pažanga matuojama ir kaip bus ta pažanga, sakykime, kažkokie trūkumai, kaip jie bus toliau sprendžiami. Tai štai yra planas pagristas, sakykime, tokia problemų, kiek buvo įmanoma identifikuoti tas problemas, su kuriomis yra susiduriama šiandien, bet kaip minėjau, tikrai buvo labai sudėtinga planą ruošti, kadangi išsamios analizės, sakykime, kokia teisė ten, pavyzdžiui, teisė į privatumą, kiek jinai Lietuvos versle šiai dienai, ar yra kažkokios
rizikos ar kažkokios tai galimybės. Tai tokios analizės nėra ir tikimės, kad patvirtinus planą tokia galimybė, tokias analizės bus, tokia galimybė atsiras. Na ir taip pat apie paties plano turinį, vėlgi tai yra tikrai nemažas dokumentas, šiuo metu turbūt 16 net puslapių, tai tikrai tą vienos skaidrės pristatymą, irgi vertinkite atlaidžiai, nes neįmanoma visko sutraukti 16 puslapių į tą vieną skaidrę, bet norisi pagarsinti tai, kad paties plano tikslas yra toksai dvejopas. Viena vertus, ir jisai atspindi būtent tą valstybės poreikį tokiam planui, ir paties verslo dalyvavimą, verslo įtraukimą į žmogaus teisių klausimus. Tai plano tikslas ir yra užtikrinti būtent tų dokumentų, kurie, sakykime, šiai dienai, jie pilnai neatsispindi mūsų teisės aktuose, jie ateina iš tos minkštosios vadinamosios teisės, tiek jungtinių tautų principai, tiek rengiama jungtinių tautų konvencija dėl verslo žmogaus teisių, tiek tarptautinės darbo organizacijos gairės, rekomendacijos, EBPO gairės, ir ES dokumentai, kurie taip pat turėtų būti įgyvendinami. Tai vėlgi plano tikslas ir yra užtikrinti geresnį šių Lietuvos įsipareigojimų įgyvendinimą ir taip pat užtikrinti verslo įtraukimą ar paskatinti verslo įtraukimą, suteikiant tiek skatinamasias priemonės, tiek galbūt tam tikrais atvejais, kaip ir kitose valstybėse, turbūt numatant ir tam tikras priemonės, kurios, neskatintų verslo elgtis neatsakingai. Ir vėlgi mes neretai norim kalbėti tik tai apie tą pozityvą, bet vis labiau aš matau, kad mes ir apie tą, ne tik tai apie tas morkas skaniasias turėtumėm kalbėti, bet taip pat ir apie tą bizūnėlį, nes užsienio tyrimai pastebi, kad tos įmonės, kurios įgyvendina žmogaus teisų reikalavimus, kad jos taip pat būtų labai, jeigu valstybė to neįvertina, tai tokiu atveju tai irgi yra blogai. Tai dėl to, sakykime, turi būti tos ir priemonės, kurios, išskirtų tokias įmonės iš kitų įmonių tarpo, pavyzdžiui, viešuosiuose pirkimuose, ar suteikiant tam tikras eksporto garantijas, ar kitose srityse, kur valstybė turi savo įtaką verslui. Tai, nes jeigu tokių skatinamųjų priemonių nebūtų taikoma, tai iš ties tos įmonės, kurios nieko nesilaiko ar papildomai nedegė tų reikalavimų, tikrai, jos nebūtų paskatintos kažkaip tai keistis. Tai tas bizūnėlio elementas, jisai tikrai matyt turi būti. Ir tas plane irgi atsispindi tiek tos skatinamosios priemonės, tiek ir tos priemonės, kuomet yra neverta verslui kažkaip tai negerai elgtis. Tai plane yra numatyti 4 uždaviniai, ir taip pat gausybė priemonių. Tai pirmasis uždavinys yra būtent, kaip jau minėjau, toks analitinis, analizuoti padėtį dėl jungtinių tautų principų, TDO deklaracijos, EBPO gairių ir ES dokumentų dėl verslo ir žmogaus teisų, būtent jų įgyvendinimo būklę Lietuvoje, sekti tą būklę, matuoti pažangą, ir pagal tai didinti informatumą apie tą problematiką, apie šios dokumentus ir apie jų realų įgyvendinimą šalyje. Antras uždavinys, kaipgi pasiekti tokį tikslą, kad verslas būtų įsitraukęs į žmogaus teisų principų gyvendinimą, tai būtent ir yra susijęs su išplėtimu verslo įsitraukimo, būtent į šių dokumentų įgyvendinimą. Ir vėlgi aš kalbėsiu apie priemonės, kokiamis priemonėmis siekiama tai padaryti, bet rezultate vėlgi norima matyti vis daugiau įmonių, yra konkretus rodikliai nustatyti, bet apibendrinant galima sakyti, kad vis daugiau įmonių vykdytų savo poveikio vertinimą, išsame patikrą dėl žmogaus teisių ir diegtų šios principus ne tik tai ataskaitose, nes vėlgi viena iš problemų dėl nefinansinės atskaitomybės, kurią užsienio tyrimai pastebi, kad įmonės dažniausiai supranta kaip tik tai
atsiskaityti, pranešti ataskaitoj, kad štai mes diegiam, o kaip diegiam, ar tikrai diegiam, kad apie tai įmonės ne visada į tai atkreipia dėmesį. Trečiasis uždavinys yra susijęs su apskritai Lietuvos tarptautinio vaidmens šitoje srityje didinimu, tai yra dalyvavimu, pasisakymu, Lietuvos pozicijos, Lietuvos įtakos didinimu, Lietuvos pozicijos išreiškimo šiais klausimais, tiek pasauliniuose forumuose, tiek europiniuose forumuose, na ir be abejo institucijų, kurios tame dalyvauja veiksmų koordinavimą. Tai, kaip minėjau, viena iš problemų yra tarpžinybinis koordinavimas, ne tik tai šioje srityje, bet konkretus uždavinys yra į tai nukreiptas. Na ir ketvirtasis uždavinys yra susijęs su išplėtimu galimybių veiksmingai ginti pažeistas teises. Tai vėlgi bandysiu apibendrinti, kokiosgi yra tos priemonės, sakykime, priemonių grupės, nes tikrai pačių priemonių yra labai nemažai. Tai viena priemonių grupė yra būtent tyriminės, analitinės priemonės, stebėsenos priemonės, kurios ir leistų turėti atnaujintą aktualią informaciją, pagal kurią galima būtų vykdyti dialogus, vykdyti mokymus ir spręsti konkrečias žmogaus teisų problemas ar atverti konkrečias galimybės verslui. Taip pat gerosios praktikos pavyzdžių, identifikavimas, sklaida, visa tai tikrai yra labai svarbu tam, kad vis daugiau įmonių matytų, kad tai nėra vien tik tai kažkoks bizūnas, kažkokia atitiktis lūkesčiams, teisės aktų reikalavimams, bet kad tikrai tokios veiklos vykdymas šiai dienai yra jau nebeišvengiamas ir jisai prisideda prie pačios įmonės reputacijos. Na ir šiai dienai turbūt jau yra nemažai įrodymų, kad pirmiausia, kad žmogaus teisų padėtis tikrai pablogėjo dėl ryšium su verslo priemonėmis, ypatingai tiekimo grandinėje, ryšium su COVID situacija, kadangi tikrai buvo labai daug atleidimų vykdoma. Ir kita vertus, tos įmonės, kurios sugebėjo išlaikyti darbuotojus, kurios geriau integravo tos žmogaus teisų aspektus, jau yra teigiama apie tai, kad tos įmonės geriau prisitaikė prie šios pandemijos situacijos ir tokios įmonės turi galimybės geriau valdyti visas kitas krizes, kurios mūsų laukia, ne tik ekonominės krizės, bet ir kitas krizės. O galbūt nukrypsiu, jeigu man leisi dar vienai minutiai, visai neseniai, tarp kitko, kasmet Deloitte tarptautinė kompanija vykdo tokį tyrimą darbuotojų, ir ne tik darbuotojų, bet apskritai jaunimo tarpe, tai yra kasgi motyvuoja darbuotojus ir ypatingai tos milenimo žmonės, tos gimusius nuo 2000 metų, kur visi sakom, kad neaišku, kas juos motyvuoja, tai visiškai kitos kartos. Ir iš tiesų tose tyrimuose labai aiškiai rodoma, kad jaunimui yra labai svarbu, kad darbdavys būtent tas žmogaus teises, darbuotojų teises, visuomeninį dalyvavimą rodytų, realizuotų. Tai vėlgi kalbam apie tai, kad geresnės žmogaus teisų suvokimas, diegimas verslo praktikui, kad jisai taip pat atsigrėžia ir teigiamais rezultatais darbuotojų lojalumo, darbuotojų motyvacijos, darbuotojų produktyvumo prasme. Tai vėlgi nenoriu kartoti ten visko, ką tas tyrimas sako, bet tokios išvados yra matomos. Tai todėl yra tikrai labai svarbu skleisti, identifikuoti tokias gerasias praktikas Lietuvoje, ir jas skleisti. Ir planas tai numato. Taip pat planas numato, nemažai čia buvo kalbėta ir aš ne veltui Andriui uždaviau tą klausimą, ką mums daryti, kai Lietuvoje atsiras išsamios patikros reikalavimas, ateinantis iš ES dokumentų. Tai iš tiesų plane irgi tai bandoma atsižvelgti, tas visas naujoves stengiamas integruoti ir numatomos priemonės, kurių pagalba galima būtų sukurti tam tikrus įrankius, metodikas, daryti bendrus mokymus, galbūt tam tikrą konsultavimą verslui tose srityse, kur verslas tikrai kasdieną nesidomi ir tos ekspertizės neturi. Tai planas tokias priemonės tiek konsultavimo, tiek mokymo, tiek įvairių įrankių parengimą kad palengvinti tuos procesus versle, juos numato. Na, taip pat yra numatytos įvairios skatinamosios priemonės, tom, sakykime, taip pažangioms įmonėms, tiek viešųjų pirkimų kontekste, tiek, sakykime, atsakingų įmonių sąrašų skelbimo kontekste, lengvesnių prieimų prie įvairių eksporto garantijų. Tai vėlgi tos skatinamosios priemonės jos yra labai svarbios ir jos plane irgi yra įtrauktos. Na ir plane yra tikrai nemažai priemonių, būtent trečiajam uždavinį gyvendinti, tai yra kaip skatinti tą aktyvesnį Lietuvos dalyvavimą, kaip užtikrinti, kad visa tai, ką mes gaunam užsienyje tuose forumuose, kad vėlgi, kad Lietuvoje ta informacija mus pasiektų. Na ir čia vėlgi yra numatytos įvairios informavimas, sklaidos priemonės, tam, kad vėlgi parodyti ir gerasias praktikas, užsienio gerasias praktikas ir diegti tai Lietuvoje. Na ir numatytos taip pat prevencijos priemonės, kaip minėjau, verslo konsultavimo, vėlgi neaišku, dar kol kas yra numatytos kelios institucijos, ar tai bus nacionalinė žmogaus teisų institucija Seimo kontrolierių įstaigoje, ar tai bus lygių galimybių kontrolieriaus tarnyba, o galbūt dar kokia nors institucija, vėlgi tai bus nuspręsta jau matyti galutinai tvirtinant planą, bet tos prevencinės priemonės yra būtinos, vėlgi padėti verslui įsidentifikuoti tas rizikas, galimas rizikas, kad išvengti pažeidimų, na ir be abejo galbūt didinti kompetenciją tiek mūsų teisminių institucijų, tiek ir neteisminių institucijų, kuriuose asmenys, kurių teisės yra galimai pažeidžiamos, galėtų veiksmingiau jas ginti. Tai tikrai tai yra labai santraukoje, kas yra numatyta tarp tų priemonių ir, kaip minėjau, pats planas yra tikrai grindžiamas jungtinių tautų principų 3 ramsčiais, tai yra tiek valstybės pareigomis, tiek verslo pareigomis, tiek ir veiksminga teisų gynyba. Bet privalomų įstatyminių reikalavimų, naujų reikalavimų planas verslui tikrai nenumato. Na ir plane yra integruotos turbūt svarbiausios naujienos susijusios su tarptautiniais pokyčiais, ES pokyčiais dėl išsamios patikros, dėl due diligence, dėl nefinansinės atskaitomybės, kuri vėlgi išgyvena reformą ES, atsakingo investavimo, kuris ypatingai praėjusių metų pabaigoje suaktyvėjo ir jau buvo minėta, kad net ir Lietuvoje veikiantis bankai prisijungia prie iniciatyvos atsakingo investavimo principų. Tai iš tiesų visa tai, kaip pavyko, tai vėlgi bus turbūt spręs tas, kas tvirtins planą, na, o šiandien turim galimybę apie tai dar padiskutuoti ir tas plano priemonės, tikslus, plano uždavinius dar pakoreguoti. Na ir paskutinis aspektas, ką norėtųsi paminėti, kad iš tiesų plane dalyvauja, planuojama, kad dalyvaus tikrai labai nemažai valstybės institucijų jo įgyvendinime, priemonėse ir taip pat kitų organizacijų. Tai tiek Užsienio reikalų ministerija, tiek Ekonomikos inovacijų ministerija, Socialinės apsaugos ir darbo ministerija, specialiųjų tyrimų tarnyba, kadangi vėlgi korupcijos aspektai yra, antikorupcijos aspektai traukti, Nacionalinė žmogaus teisų institucija, lygių galimybių kontrolieriaus tarnyba ir daugelis kitų, kurių visų nebūtų įmanoma suminėti. Bet kas turbūt yra svarbu, kad į plano priemonių įgyvendinimą yra siūloma įtraukti taip pat ir kitas labai svarbias organizacijas, tai yra profesinės sąjungas, darbdavių verslo organizacijas, nevyriausybinės organizacijas, akademinę bendruomenę, Lietuvos atsakingo verslo asociacija, nacionalinį koordinacinį centrą, tai iš tiesų visus tuos subjektus, kurie susiję su šita tematika ir tose priemonėse dalyvautų. Plane taip pat yra numatyta priežiūros grupė, kuri vykdytų stebėseną tiek oficialių ataskaitų, valstybės institucijų ataskaitų pagrindų, tiek vykdant išsamų nepriklausomą tyrimą padėties ir pažangos atitinkamais metais. Na ir toje priežiūros grupėje tikrai yra numatytas platus visų susijusių šalių atstovų dalyvavimas, koordinuojant Užsienio reikalų ministerijai. Ir tikrai yra tikimasi, kad toks mechanizmas, jisai nebus vien tik tai formalus, taip kaip yra tikrai nemažai turbūt planų ir strategijų, kur mechanizmai yra formalūs, bet buvo siekta surasti tokį modelį stebėsenos priežiūros įgyvendinimo, kuris leistų reaguoti į poreikius, leistų peržiūrėti tokį planą, na ir koreguoti atitinkamai tas priemonės bei vertinti jų įgyvendinimo rezultatus, konkrečius rezultatus. Tai tiek būtų, gal ir nelabai trumpai, bet kaip matot, skaidrių buvau pasiruošus mažai, bet tikrai yra daug ką galima pasakyti apie patį planą. Ir aš be abejo dalyvausiu diskusijai, jeigu bus klausimų ar komentarų, tai tikrai toks čia ir yra mūsų tikslas visą tai išsidiskutuoti ir dar galimai planą patobulinti.
Taigi, ačiū profesoriai Julijai Laišnievai pristatytą plano projektą. O dabar spręsime į diskusiją. Turime dviejų ministerijų atstovės čia. Ir norėčiau pradėti nuo užsienio reikalų ministerijos, Aistė Kekštienė. Pačioje pradžioje atkreipiau dėmesį, kai profesorė pasakojo, kad dar galima šį planą tobulinti, jis nėra galutinis. Jūs taip pritariamai linktelėjot. Ar jau žinot, kur bus tie iššūkiai, ką reikės itin akylai stebėti?
Ačiū labai už klausimą, tikrai taip sutinku, tobulinti jį dar galima ir tikriausiai reikėtų. Mūsų didžiausias iššūkis ir problema, kad nesulaukiam pakankamos suinteresuotumo tiek iš verslo, tiek iš profsąjungų, kadangi norim, kad tas planas, kaip profesorė ir minėjo, nebūtų tai tik tai valstybės institucijų paruoštas toks rinkinys taisyklių nurodymas, kad tai būtų bendras jungtinis darbas projektas. Todėl kviečiam tuos, kurie negalėjo šiandien dalyvauti, teikti tuos pasiūlymus, į kuriuos norėtumėm atsižvelgti, nes su antru planu siekiam, kad nebūtų taip, kaip buvo su pirmuoju, kad tai būtų, kaip sakant, gyvas mechanizmas, kad tai būtų pritaikomas dokumentas, o nebūtų tik tai taisyklių rinkinys. Ačiū.
O ko gali reikėti tam, kad tas verslas aktyviau įsitrauktų? Kaip iki jo prisibelsti? Nežinau, gal jūs žinote atsakymą, Neringa? Nes žinau, kad ministerija jūsų bendradarbiauja su verslo organizacijomis, kitais klausimais tiesa, ir ten kažkaip nepavyksta tą verslą įtraukti, tai gal turite tokį receptą, kuris čia pagelbėtų?
Ačiū klausimą, turbūt jeigu žinotume, kaip pritraukti, tai čia matytume pilną salę verslo atstovų ir profesinių sąjungų atstovų. Bet iš tiesų turbūt pagrindinė mūsų ir užduotis, kuri aš labai tikiuosi jau priėmus šitą planą bus įgyvendinta, tai yra parodyti, kad būtent tas verslo žmogaus teisų planas yra sukurtas ne institucijom reguliuoti savo veiklą, bet būtent verslui parodyti ir sumotyvuoti jį, kad savanoriškai, negrasinant kažkokiam sankcijom, jis norėtų laikytis iš tikrųjų tų žmogaus teisų standartų. Tai iš tikrųjų labai gaila dėl to, kad šiandien salėje nėra tų verslo atstovų, bet mes bent vienas yra. Tai labai džiugu, tikimės išgirsti ir jūsų nuomonę, iš tikrųjų visgi ko reikėtų, kad tai pasidarytų patrauklu ir pačiam verslui. Tai iš tikrųjų mes kaip valstybės institucijos matom užduotį ir savo didinti tą švietimą ir parodyti, kad ne vien tik tai kažkokiom bausmėm, sankcijom mes priversim tą verslą laikytis tų nuostatų, bet iš tikrųjų, kad tai tam tikrą apimtim duos ir grįžtamąją naudą pačiam verslui. Iš tikrųjų, čia šiandien buvo ne vienas pavyzdys pateiktas, kaip iš tikrųjų visuomeniai ir vartotojams darosi kuo toliau, tuo svarbiau, kiek socialiai atsakingas, kiek tvarus yra tas verslas ir kiek iš tikrųjų šiuolaikinis vartotojas yra orientuotas ne vien į tą pigiausios kainos produktą, bet ir kiek įtakoja jo sprendimams pirkti iš vieno ar kito verslo būtent tai, kokiomis sąlygomis tas verslas veikia. Tai mes labai tikimės, kad iš tikrųjų mūsų šitas planas eis prie to tokio skatinimo ir geranoriško būtent valstybės ir privataus sektoriaus bendradarbiavimo einant šitą linkmę.
Taip, dar Andriau, įtraukime jūsų diskusiją. Ar gali tai būti, kad verslas nėra labai, bent jau čia aktyvus prisijungti, ne todėl, kad nepritartų tiem principam, kur yra dėstomi, arba ne dėl to, kad nesuprastų, kokios naudos yra, bet dėl to, kad jeigu jau bijo, kad prisilies, tai tada labai bus po padidinamuoju stiklu. Ir čia dar atsiranda baimė.
Dėkuoju už klausimą. Aišku, pasakyti, ar taip galvoja verslas, ar kažkaip kitaip yra sudėtinga, tai reikėtų klausti paties verslo, ar jis taip galvoja. Aš tai matau problemą, ir čia aš ne vienas matau, ir kiti šiandien konferencijos metu pranešėjai nurodė, kad rengiant nacionalinį veiksmų planą visuomet yra sudėtinga pritraukti suinteresuotus asmenis, dėl įvairių priežasčių gali būti tiek ir verslą, tiek ir profesinės sąjungas, nevyriausybinės organizacijas. Ta pati žmogaus teisių ir verslo sritis kaip tokia, viena vertus mes kalbam, kad jie yra svarbi, ir čia sakom, kaip svarbu, kad būtų gerai ir įmonės, jeigu atsakingos, ir vartotojai informuoti, ir nevyriausybinės prižiūrėtų organizacijos tas įmonės, kad nebūtų užsienį ar kažkur žmogaus teisių pažeidimų, bet ir iš nacionalinis koordinacinis centras, atlikdamas vieną iš savo funkcijų, tai yra informacijos sklaidos ir šviečiamoji funkcija apie EBPO gaires daugiašalėms įmonėms ir kas atsakingas verslas, tai pastebėjimas yra iš nacionalinio koordinacinio centro, atskirai kalbant apie atskirus tos visus suinteresuotus asmenis, tai nevyriausybinių organizacijų, kalbant apie nevyriausybinės organizacijas, yra menkas ar nedidelis supratimas, kaip tos žmogaus teisės ir verslas kartu kaip veikia ir ko gali nevyriausybinės organizacijos reikalauti. Tai nėra tokių stiprių Lietuvoje nevyriausybinių organizacijų, kurios tuo užsiimtų. Ne visose užsienio valstybėse irgi yra tokių organizacijų, nes dažnai būna, kad nevyriausybinės organizacijos tą supranta kaip kaip nevyriausybinė organizacija gaus iš to pinigų. Tas paprastesnis yra modelis, kai kurios, aišku, tyrimus atlieka, kitokius tada gal tą supranta, bet nėra tokio, kad jau suprastų pakankamai sudėtingą tą sritį netgi žmogaus ir teisių ir verslo kaip tokių, kad įsijungtų. Mano nuomonė, tai yra viena iš tų priežasčių, kodėl nėra daug, bent viena nevyriausybinė organizacija atvykusi, nėra Lietuvoje tokios specializuotos. Yra Lava, ji truputį per kitą žiūri, ji padeda, pavadinkim, verslui būti atsakinga, bet ji nėra ta organizacija, kuri prižiūrėtų, ar verslas yra atsakingas. Nes čia tokios reikėtų organizacijos, kuri įsijungtų ir pakomentuoti galėtų. Dėl profesinių sąjungų irgi nacionalinis koordinacinis centras kaip su mumis bendravo, iš atsakingo verslo srities, šviečiamąja veikla, iš jų labiau eina nusivylimas, kad ne visai tie minkštieji instrumentai, tie neteisės aktai, kad padeda apginti narių teisės. Profesinėms sąjungom yra daugelio atveju darbo teisės aktai, kurie saugo profesinės sąjungas, netgi turint privalomus teisės instrumentus, sunkiai jiems sekasi apsaugoti narius. Žino kažkiek, bet jie abejoja efektyvumu, įskaitant dėl tokio instrumento, kaip žmogaus teisės ir verslas, nes tarp profesinių sąjungų ir verslo natūralu, kad yra tam tikra priešprieša. Galiausiai kalbant apie verslą, kaip trečias sritį, tai mūsų pastebėjimas yra, mano labiau pastebėjimas, kad Lietuvoje verslas yra tas, kuris mėgsta teikti, kad yra atsakingas verslas. Bet ar tikrai yra atsakingas verslas? Pagal tai, kur yra reikalavimas atsakingo verslo. Aš nesimsiu vertinti, nes viena iš funkcijų yra individualus atvejai, tai yra skundų nagrinėjimas, jeigu kas nors kreipsis. Tai įmonės turi supratimas apie atsakingą verslą yra bendrai toks supaprastintas, pavadinkim. Tai yra, aš iškabinau inkilą arba leidau darbuotojams dalyvauti akcijoje, nešluojam, ką darom, vadinasi, aš atsakingas verslas. Aš jums leidau po darbo, nes darbo metu negalima dirbti reikia ir aš esu atsakingas verslas. Būna ir tokį supratimą. Vėl tai viskas susideda į šviečiamą veiklą, iš dalies iškviečiamąją, kitas yra dalykas įmonės supratingumą ir trečias yra, kiek įmoniai tai rūpi. Įmoniai tai rūpi tiek, kiek rūpi vartotojams. Tai yra įmonėms, kurių gali būti savaime įmonei rūpi tie dalykai ir jie domėsis tokiam temam ir atvyks. Yra įmonėm, kurių galbūt akcininkai yra iš užsienio, mes tą kaip pavyzdį rodom, paprastai didesnis interesuotumas yra ir Skandinavijos valstybių akcininkai, kurie atneša tą kultūrą tokį, kad tai rūpi ir mes taip irgi darysim. Ir štai tada ir įmonėm taip rūpi ir bent jau yra daugiau to tikėjimo, kad tai yra svarbu. Tai tokios įmonės, tai paprastai tada ir labiau yra suinteresuotos tokiais dalykais. Ir tas realybėj būna, ir Lietuvoje kalbant, užsienio kapitalo vis tiek tai didesnė. Nors ne visada kartais gali būti ir pakankamai didelė bendrovė, bet užsienio kapitalo bent jau bus girdėjus, kas tas atsakingas verslas, arba kitais žodžiais įmonių socialinė atsakomybė, aš kaip minėjau, gal sąvoka yra truputėlį, gali būti nesutarimas. Apie tai girdėję, tai rūpi ir tokiom įmonėm jos daugiau supranta, kas yra žmogaus teisės ir verslas, kur čia gali būti kartu tas santykis toks, nors, kaip Lyra minėjo, buvo ir diskusijų metu rengiant planą, tai pagrindinė problema rengiant planą, nacionalinį veiksmų planą, ta strategija valstybės yra, kad taip šiai dienai neturime dokumento, kuriame būtų įtvirtinta arba nustatyta šiandieninė kokia yra situacija Lietuvoje. Įprastai tai turėtų būti bazinis dokumentas, nuo kurio galėtume pradėti dirbti ir toliau, ir projekcijas daryti, ir skaičiavimus, ir kaip turėtų pats nacionalinis veiksmų planas toliau dėliotis. Neturim, siekiama planų tą situaciją ištaisyti kartu, kviečiami yra suinteresuoti asmenys, bet bendrai Lietuvoje ta situacija yra, bet čia ne tik Lietuvoje, kitose aplinkui valstybėse, irgi taip šviečiama veikla, verslo, nevyriausybinių organizacijų, profesinių sąjungų, tų suinteresuotų asmenų dalyvavimas yra pakankamai mažas, nes tas supratimas apie patį dalyką nėra labai gilus. Ir aš tai manau, kad vis tiek bus dedamas pastangos, matyti dar ne kartą, kad gauti kažkokias, eiti pas pačius asmenys, gauti iš jų nuomonę, poziciją, juos bandyti traukti. Vis tiek galiausiai planas bus patvirtintas, nes negali tęsti situaciją, kad nėra patvirtinta, bus patvirtintas, praeis kiek laiko, paprastai tas būna, praeina laikas, kažkas įvyksta, o tada atsiranda tas interesas, nes tada pamato, kad planas yra patvirtintas ar kažkokios ir priemonės, ir tada jau klausimas, o kodėl manęs neklausė anksčiau, kodėl aš nebuvau įtrauktas. Tai čia toks, ne tai, kad pelės katės žaidimas, bet informavimas taip, viena vertus yra sudėtinga ir ten dedamas pastangos, aišku, pagal nacionalinių veiksmų planų rengimo taisyklės, ką buvo pranešėjas Dirk Hoffman, man atrodo, nurodys, kur yra tas, čia yra ir valstybės tas įsipareigojimas, kad rengiant netgi nacionalinį veiksmų planą ir valstybė turi skirti pakankamus resursus, kad tinkamai informuoti, nes atsakingas verslas ir apskritai žmogaus teisės ir verslas, to plano rengimas yra neprivers visų atvykti ir dalyvauti. Bet neatitempsi, nepriversi, turi būti savanoriškas, kaip tą savanorišką padaryti, tu lygiai informuoti, tada kaip pasiekti asmenį, kurį nežinai, ar jį domina ir ar jis pateiks. Čia yra ta visų nacionalinių veiksmų planų rengėjų problema, siekiama tai padaryti. Šiandien tikėjosi visi, kad bus daugiau. Gal pažiūrės vis tiek vykdoma internetų transliacija, ar bus nuorodas, gal pažiūrės, kad vyksta kažkas tokį, atsilieps, informuos, nes atgalinio ryšio tikrai reikia, norisi ir tas pageidauja.
Čia daug aspektų paminėjot, profesorė, gal į kelis sureaguokim. Vienas buvo niuansas dėl to, kad plane mes matėm daug kas yra paremta ir nevyriausybinėm organizacijom, ir akademinė bendruomenė, ir profesiniam sąjungom. Ir štai girdim, kad nėra jų stiprių Lietuvoje pakankamai, tai ar tai reiškia, kad čia bus tas silpnoji grandis ir nevyks nei tas priežiūras sklandžiai ir pats planas tas pakankamai nestabilus, ar ne, nes nebus tos labai stiprios dedamosios. Ir kitas aspektas, tai kaip ir dėl to bendradarbiavimo, ar buvo pakankamai dėta tų pastangų, ar ne, kad išgirsti ir įtraukti diskusiją.
Tai aš norėčiau sureaguoti dėl dviejų aspektų, tai yra būtent dėl to visuomeninio spaudimo, nes turbūt net ir verslas, kuris labai viską gražiai norėtų daryti, bet jeigu tam tikro spaudimo nėra, tai
čia verslo atstovė dalyvaujantį tikrai turbūt patvirtins, kad verslas visada žiūrės, kiek tai kainuoja, ar tai tikrai yra prioritetas, ar yra kažkokie kiti prioritetai. Verslas galbūt daug efektyviau negu ar akademinė bendruomenė, ar kita bendruomenė tos klausimus sprendžia. Tai kalbant apie tą visuomeninį spaudimą, aš gal nenorėčiau visiškai sutikti, kad nėra stiprių nevyriausybinių organizacijų, kurios kalbėtųsi su verslu, rodytų problematiką ir turėtų pakankamo balso, kad būtų išgirsti verslo bendruomenėje, valstybėje, visuomenėje. Manau, tokių organizacijų yra ir tikrai tos organizacijos, ypatingai neįgaliųjų teises ginančios organizacijos, galbūt lygių galimybių, lygių galimybių srityje dirbančios organizacijos, jos tikrai labai nemažai bendradarbiauja su verslu ir tokios praktikos yra ir nemažai įmonių pavyzdžių, būtent žmogaus teisių poveikio vertinimo atskirom visuomenės grupėm, galbūt labiau pažeidžiamom visuomenės grupėm. Tai tikrai yra tų gerųjų pavyzdžių ir man atrodo, čia visai neseniai galbūt Rimi pavyzdys vėl buvo analizuojamas. Turbūt berods 10 metų jau jie neįgaliųjų integracijos programą vykdo ir vykdo tikrai turinio prasme, ne tik tai rodo, kad vykdo. Tai tokių organizacijų yra, bet galbūt problema labiau yra, kad tos organizacijos yra fragmentuotos. Kitaip tariant, mes neturim stiprių, galbūt tokių bendresnių organizacijų, kurios atstovautų ne tiesiog vienos visuomenės grupės ar pažeidžiamos visuomenės grupės interesus, bet apskritai mūsų nacionalinė žmogaus teisių institucija, turbūt akis mūsų daugelio krypsta, kad tikrai tikimasi, kad ši institucija ar kažkuri kita nevyriausybinė organizacija atstovautų ne tik tai siaurus vienos organizacijos interesus. Tai toks visuomeninis spaudimas, ar tai būtų vartotojų organizacijos, tikrai jisai matyt tuos procesus paskubintų. Antras aspektas, apie ką buvo klausima ir buvo reflektuojama, kągi galvoja verslas. Tai aš irgi lygiai taip pat kaip Andrius nespėliočiau, bet galiu pasakyti su tomis nuomonėmis ar tų minčių išraiška, kuri buvo pasakyta per kai kurias diskusijas, kuriuose teko dalyvauti dėl šio plano. Tai kai kurie verslo atstovai tiesiog pasakė, kad pas musgi viskas gerai, ko jūs norit? Kokie čia dar planai? Taigi viskas gerai pas mus. Žmogaus teisų padėtis gera, mes esame demokratinė valstybė, mūsų įstatymuose ne taip kaip kokioje ten Indijoje, taigi viskas yra sureguliuota. Tai ko jūs dar norite? Tai man atrodo, čia tiesiog aš klausimų į klausimą, galbūt tam, kad paprovokuot mūsų diskusiją, tai ko tada reikia? Ar tada reikia parodyti blogosius pavyzdžius, kaip kad Grigėjo atveju, taip turbūt jau niekam nekilo klausimų, kad ir Lietuvoje pasirodo gali taip atsitikti ir netgi su įmonė, kuri tikrai pozicionavo save kaip stipresnė aplinkosaugos srity negu kitos. Ar reikia būtent kažkokių blogų pavyzdžių ieškoti ir juos bandyti traukti dienos šviesą, ar reikia kaip tik kažkokių labai stiprių skatinamųjų priemonių. Ir rengiant planą, mes darbo grupėje irgi su tuo klausimu susidūrėm ir aš jį irgi mūsų auditorijai noriu užduoti. Ko iš tiesų reikia? Kad tai kompleksas veiksmų turėtų būti taip, bet ar tai turėtų būti labiau skatinančios priemonės, ar kažkoks tai vėzdas, su kuriuo mes mosikuotumėm ir verslas nori, nenori, tada turėtų paklausti. Tai aš aišku ir verslo atstovai lygiai tą patį klausimą norėčiau užduoti, nes tai buvo tikrai didelė dilema. Kad susijusi su tuo, kad verslas neretai galvoja, kad viskas yra labai gerai Lietuvoje.
Taip, mes dar prie verslo irgi pereisim, čia dar mačiau, tai kylančią ranką ir repliką.
Aš norėjau paklausti, ar bandė kas nors pritraukti verslo lengvatomis? Čia pirmas pasiūlymas, antras vadinasi žmogaus teisės. Gal verta pradėti nuo žmogaus, kad pasirašinėdamas darbo sutartį, ypač tas, kurį mėgdžioja headhunters, perspektyvus darbuotojas, galbūt minkštai, softly reikalautų, kad tas punktas būtų įvestas į darbo sutartį. ir galbūt nuo žmogaus ir irgi pradėti. Ir čia akademiniai visuomeniai būtų tokia užduotis kelti sąmoningumo šitų žmogaus teisų. Ačiū.
Nežinau, gal turite kas nors repliką, Andriu? Ar toks veiksmingas variantas?
Aš pasitikslinti truputį norėčiau. Ką į darbo sutartį nurodyti reikėtų? Kad laikysis įmonė atsakingo verslo? Tai žinoma siūlymas.
Ir būtent tie darbuotojai, kurie yra perspektyvūs.
Tai supratau, tai aš dviem aspektais atsakysiu. Tai kaip buvo ir nurodyta, taip dėl besikeičiančių kartų truputėlį yra skirtingi tie kriterijai ir dėl ko apskritai atsakingų verslui yra interesas būti atsakingų yra, kad, kaip čia vardinta, jaunąją, nors nesijaučiu pats dar labai toks jau nebejaunas. Tas millennials, kaip čia vardinta, ta karta po millennials kitiems jau nebėra tiek svarbu vien darbo užmokestis arba darbo sąlygos, yra ir kiti kriterijai svarbus, įskaitant, kaip buvo nurodyta, yra darbo vieta, kurioje dirbama, ar darbdavys, kurios srity veikia, ar prisideda, sakyti, vien atsakingo verslo gali būti per siaurą, bet ar apskritai kokį pats darbuotojas ne tik tais atlyginimą uždirba, kaip jis prie visuomenės gerovės prisideda, įvardykim taip, kaip pavyzdžiai, nebūtinai Lietuvos, tai užsienio buvo, kur tie praktiniai, kad sukilo Google darbuotojai, kai sužinojo, kad Google dalyvauja Pentagono viešajam pirkime, valstybės, JAV vyriausybės viešajam pirkime, ten buvo ar dėl dronų, ar dėl kažkokių datų apskaitų, kur sako, mes atsisakom programuoti, nenorim, kad darbdavys taip darytų, čia ne vieno asmens buvo daugelio, kad net nedalyvautų įmonė tam tikroje veikloje. Tai čia buvo, yra tas spaudimas toksai, kaip pavyzdį mes, Lietuvos nacionalinis koordinacijos savo mokymuose teigia, kad žinoma yra čia toks tamprus dalykas ir tyrimai buvo daryti, yra tas nustatyta, kad ypač tie labiausiai išsilavinę asmenys, jiems tas yra labiausiai svarbu aukštos kvalifikacijos darbuotojai. Lietuvoje čia būtų, tarkim, programuotojai kokie, ar kiti aukštos kvalifikacijos, gal teisininkai, dar kiti kokie tie darbuotojai. Jeigu jie dirba bendrovai ir, tarkim, bendrovė laimi geriausias metų darbdavys, tai tokiam darbuotojui jis renkasi iš kelių darbo vietų. Ir darbdavys renkasi darbovietę tarp kelių, negu tiek darbovietį jį. Tai jam gali būti svarbu korporatyvinė strategija bendrovės pačios. Tai jeigu paaiškėja, kad bendrovė pažeidė, čia vėl kaip tą pažeidimą nustatyti yra tas klausimas. Nacionalinis koordinacijos centras nustatė, žiniasklaida paskelbė kaip bankai. Plovė pinigus, sako tie. Tai čia vėl priklauso, ar man darbuotojui bus tas svarbu, aš nedirbsiu tokį bankį. Nes sutinku draugus, sako, tai kaip ten tos skalbimo mašinos, neūžia, kaip jūs ten plaunat, kur džiovinat, gal vien dėl tokių pašaipų jis nedirbs, kitiems nebus tas svarbu. Tai yra tas, kad tai veikia darbuotojus, kiek tas masiškai, čia jau priklauso nuo kiekvieno individo. Atskiras kaip siūlymas, kaip jūs nurodėte, antras punktas, kad įtraukti darbo sutartis, čia būtų toks labiau, matyt, mechanizmas darbo teisės, ar čia specifinis, kad leisti darbuotojui nutraukti darbo sutartį, jeigu toks atvejis bus kaip speciali darbo santykio, darbo sutarties nutraukimo priežastis. Svarstytinas tas variantas, bet ar tokį įtvirtinus nebus tiesiog šiaip galimybė asmenims, kurie norėjo nutraukti darbo santykius, nors ir taip nėra labai sudėtinga dabar darbuotojų nutraukti, yra įspėjimas, ir išeina iš darbo. Tai čia nelaiko tų darbuotojų tiek. Svarstytinas tik, ar jis duos tą naudą, nes tiem, kurie rūpi darbuotojams, jie tokie bendrovė taip neliks. Jeigu paaiškės, sunkiausia paprastai būna nustatyti, ar taip vyksta, ar taip vyko ir ar tai vyko, pavadinkim taip, nepaisant to, kad įmonė dėjo geriausias pastangas, ar, pavadinkim, aplaidumo, arba net su įmonės žinia. Nes, kaip minėjau, reikia atskirti situacijas, kad gali būti įmonė dėjo geriausias pastangas, dėjo geriausias politikas, galėjo visi pranešti, atsirado vienas ar keli asmenys, kurie susitarė, nepaisant geriausių pastangų, padarė pažeidimą, padarė, įskaitant ir žmogaus teisų pažeidimus, užsiėmė korupciją ir viskas, įvyko toks atvejis. Tai dabar, ar labiausiai kenčia, ne, tas ir padeda atsakyti išsamus patikrinimas ir tas due diligence apskritai toks vertinamasis kriterijus, ko tikimasi iš įmonės, ar įmonė padarė viską. Nes įmonės visą laiką sakys, mes viską padarėm, pirmą mes labai geri, mums nėra pažeidimų, žmogaus teisės kaip yra nurodė labai gerą lygmenį Lietuvoje, o jeigu įvyksta, viską padarėm, ką galėjom, mes tikrai nežinojom, kas galėjo žinoti. Nu, tai tokie viskas būna pasiaiškinti.
Taip, mes turime tą reakciją, ne?
Ne, aš atsiprašau, aš tik norėčiau pasiūlyti galbūt ir pasidžiaugti, kad turim vieną verslo atstovę ir pakviesti ją replikuoti.
Mes, kadangi tu netrukus turėsim diskusiją, kuri bus būtent orientuota į verslą, dėl to aš kol kas nelabai noriu to aspektų įtraukti.
Jeigu galima, aš dar sureaguosiu tuos du pasiūlymus klausimus dėl verslo lengvatų, tai tikrai šitas klausimas visuomet, kiek aš atsimenu, nuo turbūt 2000 kažkelintųjų metų pradžios, visada verslas keldavo tą klausimą, na štai duokit valstybę, duokit mums tas lengvatas ir mes tada viską darysim kaip reikia. Tai iš principo turbūt reikėtų svarstyti, ar toks požiūris, ar jisai garantuos, kad to žmogaus teisės realiai bus įgyvendinamas, ar tiesiog verslas, išsikreips konkurenciją, kai kuriems tas lengvatas duosim ir mes susidursim su tam tikrom monetarinėm ar konkurencijos problemomis, o realaus rezultato žmogaus teisių pagerėjimui galbūt neduos. Nors pastaruoju metu aš kažkaip irgi pradėjau šiek tiek tikėti lengvatų klausimų, nes COVID situacijoje tikrai verslas susidūrė su to, kad turėjo tikrai papildomų daug labai priemonių, kurios kainavo, sakykime, darbuotojams užtikrinti jų tą saugą, gerovę, kad jie neužsikrėstų ir panašiai. Na ir buvo toks, nereto verslininko klausimas, ar valstybė čia negalėtų kažkokias lengvatas duoti, nes net ir, pavyzdžiui, kaukių įsigijimas ir kiti dalykai, kurie yra skirti tiesiogiai darbuotojų sveikatai apsaugoti, darbuotojų gerovai apsaugoti, jie yra ir apmokestinami ir panašiai, kad, žodžiu, tam mokestinė bazė, jinai tikrai nėra labai sąžininga šiuo atveju. Tai dėl to aš visai neatmesčiau, kad tai kažkokia neefektyvi priemonė, bet vėlgi tai turėtų jau vertinti ir ekonomistai, kiek, sakykime, tai realiai valstybei kainuotų ir kokią naudą tai galėtų duoti. Plane yra numatytos skatinamosios priemonės, bet jos yra, sakykime, švelniosios netiesiogiai finansinės, kad būtų teikiama kažkokia finansinė parama. Bet vėlgi, jeigu verslas gauna eksporto licenciją, eksporto garantiją, valstybė garantuoja savo lėšomis, tai vėlgi galima sakyti, kad netiesioginis toksai, piniginės paramos ar kažkoks mechanizmas jis tai galbūt ir galėtų būti. O trumpai apie priedą prie darbo sutartys, tai vėlgi aš manau, kad jeigu tik deklaratyviai mes tą numatytumėm, tai vėlgi tai rezultato matyti neduotų, ką mes ir matom dabar iš rezultatų nefinansinės atskaitomybės, kuomet jau yra aišku, kad nefinansinės atskaitomybės reikalavimas realiai labai didelių pokyčių žmogaus teisų srityje nepadarė, nepaisant to, kad įmonės yra priverstos, kai kurios didesnės įmonės priverstos raportuoti ar atsiskaityti už tai, ką jos daro žmogaus teisų srityje, aplinkosaugos srityje ir panašiai. Tai vėlgi tokio priedo buvimas, svarbu, ar jisai situaciją pakeistų, visgi reikėtų kalbėti apie giluminius procesus ir aš galbūt irgi pritarčiau tam, kad galbūt ir pats verslas, jeigu susiduria su didelė darbuotojų kaita, kad pradėtų žiūrėti, o kodėl tie žmonės keičiasi. Gal tiem darbuotojams tikrai yra svarbu, kokią politiką ta įmonė vykdo ir kiek jų pačių teises gerbia arba negerbia.
Taip, čia gal sustokim, mes dar tos visus aspektus, manau, kad bus galima ir neformaliai aptarti, nes jau matau, kad žmonės laukia ir kitos diskusijos pradžios, tai dėkoju Jums, šios diskusijos dalyviam ir dėkoju profesoriui už pristatymą. Anglų kalbą mes turime šitą antrąją dalį, so now we switch to English because we have this follow discussion in English, and it's about how can we better align business interests with human rights. And I would like to ask everybody who is taking part in this discussion just to pick a chair. Okay. And first of all, I would like to start our discussion by asking Sandra Adler. She's director of INAC Human Rights and Business Practice Group, to say a first word. Sandra, do you hear us?
Yes, I do. Do you hear me?
Yes.
Fantastic. Thank you. Okay, so I can jump in?
Yes.
All right, thank you. Well, first of all, thank you so much for inviting me to speak at this panel and for a really exciting day full of relevant insights and wisdom. Maybe first, let me briefly introduce Enact. Enact is a Nordic consultancy firm specializing in sustainability. We are 21 consultants based in Sweden, but also have representation in Amsterdam, Helsinki, and Shanghai. And one of the areas that we specialize in is business and human rights. We established the Business and Human Rights Practice Group about 5 years ago now. And within our practice group, we work closely with companies, foremost on integrating human rights into the company way of doing business. So everything ranging from policy, human rights due diligence to remedy. We also work with state actors and quite extensively with civil society and support them on capacity building, for example, around human rights due diligence and how to engage with companies, trying to bridge the gap that often exists in terms of understanding each other's perspectives. Now, to answer the panel question, I would like to raise 4 brief points. How can we better align business interests with human rights? First, I think we need understanding. If CEOs, investors, legislators, and all people working in business would understand the short and long-term impact on people that business actually have, many of the infringements and violations and negative impacts on human rights that we do see in the world today would not happen. Secondly, companies need to turn this understanding into integration and internalize all human rights risks. Or in other words, define human rights risks linked to the business as a risk to the business in itself, without qualifying it as another risk like reputational risk, financial risk, or legal risk. And then, of course, capacitate staff internally. Thirdly, stakeholders must continue to put pressure. Civil society is absolutely crucial to scrutinize and raise critical voices. Journalists have to write critical stories. Investors have to ask questions. Consumers push for information. We all have at least one role to play. Now, this is not enough. Without a level playing field, we will continue to see irresponsible business behavior masked as ignorance, races to the bottom, leading to harmful impacts on people. Therefore, and fourthly, I argue that we need legislation that forces companies to manage human rights in just as structured way as companies diligently manage other risks. A legislation that makes it mandatory to conduct human rights due diligence. This, of course, has been a topic earlier in the day, but I would like to emphasize in this context that this must not only be a reporting requirement, but focus on the normative changes needed. In other words, to change the mindset of societies, and not least the mindset of those who control and steer companies. One of the most important elements, therefore, I would argue, is board responsibility, a clear collective and individual duty of care for board members for human rights. Another aspect of that is to define the purpose of a limited liability company to be extended not only to focus on maximizing profit, but explicitly state that a purpose of a company is also to respect human rights. A further element of legislation, of course, is that victims of corporate-related human rights harm must be able to go to court and hold companies accountable and access remedy. Thank you.
Thank you very much. I would like to continue because we heard in previous discussion about the business a lot and why business is not involved or might not be interested in human rights topic. I would like to ask Lina Žemaitytė, because Swedbank is one of few companies, I guess, in Lithuania, which have basically a separate division for human rights. So there's very big focus in this field. Why so?
Okay, thank you for the question. And I feel quite special today because I feel like I'm the only representative from the business, and I have a feeling I'll get a lot of attention. So thank you for your question. We have actually just tried to reflect on a lot of discussion and the questions that have been happening here today. We have the policy on human rights since 2013. So we've been working on that topic for 7 years, and why to do so and what would make other companies to do so. So there was quite a bit of discussion here about actually having the right frame of mind and understanding the benefits of the business. So if you think, I think one of the biggest benefits of the business and why a business should do, not because it's the right thing to do, but from a very practical point of view, if you want to be a sustainable business and exist in 10 years, 20 years, 50 years, 100 years still, you do have to pay attention to that, because you cannot be successful business in a society that is not successful. If society is not successful, you as a business will fail. So one of the key things for the successful society is actually keeping to the human rights, making sure that there is equal opportunities and diversity and inclusion and all those things. So to briefly, there's lots of many benefits. I don't know whether it's the time and place for me to go into the detail now, but the big picture is that you cannot be successful if society is not.
At the beginning, 7 years ago, was it because Swedbank comes from Sweden and it was like a kind of, well, already known information in Sweden that you need to be successful, you have to be successful only in a successful society, that's how it works. So you got that know-how from Sweden that you should pursue the same in order to be a company, the people desire to work there in order to be successful, or it was made the choice, but made here locally in Lithuania.
Certainly, it does help that we are a Scandinavian company, and there's lots of legacy that comes from Scandinavian with, you know, the attitudes. That certainly helps. So this has been done group wide, so across all the markets that Swedbank is operating in. But it is not a document that was written in Sweden and it is now in the digital drawers of the organization. And once a year we write a report here. We have it. We actually. The biggest focus in all market countries is to actually do something and work on the areas which are most painful at that time. So our motto as a company and the values that we always say is that we help businesses and society to grow. So to grow financially, but also to grow as the society to make it successful. So you were rightly mentioned, we have people who actually work on it. So we work not actually internally to make sure that all the human rights objectives are alive and there is some action, but we do a lot. The social initiatives that we try to be opinion leader and talk about it and actualize the topics that are painful. So as an example, it would be like our CEO is very vocal on gender equality, which is a big thing, I guess, in Lithuania as well. So as a company, we have sort of zero tolerance on non-equal pay. And also, you asked the question before, and I'm kind of reflected it, like the question was, I think, does the business, maybe businesses don't want to declare the human rights because then they'll be sort of under magnifying glass, and then everyone will be pointing, here, you're not doing it right. So there is that, because one of another reasons why we have the human rights policy, and we declare it actually openly, you can find it on our websites as well, is that it gives you accountability. Then you become accountable. You made this promise as a company that this is how you're going to do your business. And with accountability comes responsibility, and of course comes criticism. So not only you have to watch yourself whether you really are walking the talk, you have to be ready that there will be criticism coming your way, and be ready to take responsibility and say, hands up, okay, we'll fix it.
Thank you. Richard, previously, very briefly, we spoke, and I heard that there is no such thing as national plan in Canada, and you also said that you think it's not a bad thing. Yes. So please tell us how companies are getting aligned with human rights in Canada. Why they're doing that? Do they see the successful path?
So thank you. So I start almost always with the disclaimer that I'm not an expert. I'm a simple bilateral diplomat. But I've actually learned a lot from today's conference. I really want to congratulate the organizers. I've been trying to take notes, but I'm terrified of the questions I'm going to ask, possibly even more terrified than you are. As you said, Canada doesn't have a national action plan. When Dirk had his map up, we're orange, and orange is the, well, civil society is trying, but the government isn't there yet. And so it's been interesting listening to the discussion from Nordic models, and then following about 15% of the conversation on the new Lithuanian model. And what struck me was the way I think Kent, the Finn, spoke about they were one of the first to go, and if they were to do it again today, it would probably be different. They'd follow different models. And so I think there's a lot of path dependency in how countries get to where they are and what they're doing on responsible business conduct. And I'm going to steal a bit of time and talk about how Canada does it a bit, and then that'll help feed into a lot of it. We have an NCP, a national contact point, because we're an OECD member. And so the best person to ask about Canada's national contact point is actually the head of the Lithuanian national contact point, because he probably knows better what the Canadian one does than I do. But last year we established a new position, and this is where there's a sort of a different approach point that I want to pitch out. I'm not saying that this is how Lithuania should do it. I'm not saying it's better. I'm just saying it's different. So we have now a Canadian ombudsperson on responsible enterprise. So I'm with the Nordics. I can talk about ombudspeople. And this is an individual with a government-granted mandate and a 5-year, very strategic mandate. Like her assignment is 2 A4 pieces of paper. And the appointment of this individual followed on an earlier thing. And I'll tell you the name of the previous one. That was the Office of the Extractive Sector Councillor. And so from that, you can tell just how narrow that old mandate used to be. It was a councillor, not an ombudsperson. So now we have the Canadian Ombudsperson on Responsible Enterprise, who call themselves CORE. Great name, great name. And their key for objectives over the next 5 years are: 1, to promote awareness; 2, to advise Canadian companies on how to carry out responsible business; 3, to review cases where there are accusations that there has not been responsible enterprise; and 4, to recommend policy changes to the Minister of International Trade. And there's bits of overlap. So when I was looking at the Lithuanian slide earlier, those first 2 objectives, promoting awareness and advising Canadian companies, that sounds like it's number 2 in the objectives of the new Lithuanian plan. But I'd also note that that's something that my ministry, Global Affairs Canada, does to Canadian industry. We have an international economy, international trade promotion mandate, and we make responsible business conduct part of our promotion and part of our advocacy to Canadian companies, because we're basically making the argument you just made about why businesses exist in a society. You cannot be a successful, sustainable company if you're running the society into the ground. And then the recommendations to international trade on policy, that's actually something that the department likes to think that it does too sometimes, but that overlaps a bit with the Lithuanian model on items 1 and 4. The one thing that is a bit of a difference is this review of cases. So the CORE can self-initiate investigations of human rights breaches, may offer mediation, and is in the process of setting up the process for how to take in complaints, including multilingually, so we can accept complaints in Spanish Canada is officially bilingual. Normally you can address the Canadian government in English or French and in indigenous languages in some places. But making it open, we know that there are lots of Canadian firms, going back to the extractive industries, who are operating in Spanish-speaking countries. And to the question of quality of arms or accessibility to the mechanisms, we need to make sure that our mechanisms are at least open to stakeholders in other countries who may want to raise things. So, appointed in 2019, has already changed her mandate in September 2019, working on consultation. And I want to talk a little of the path dependency. How and why did we get here? The predecessor was extractive sector. So Canada started on some of these questions with the Kimberley process 20 years ago. We started dealing with questions of the Extractive Industries Transparency Index and those larger, higher level impacts, because Canada and the Toronto Stock Exchange are hugely significant in mining and oil and gas. Canada is a place where people go to raise money to do mining elsewhere. And this means that there are a number of places that are registered in Canada and then are operating all over the world, including a number of places where the government of Canada would probably say, don't go there. Or at least, please don't take our citizens there, because we then have to get them out. So that was what it was, the focus up until maybe 10 years ago. And then there was an extremely tragic fire in a garment factory in Bangladesh. And it turned out that nearly everybody in Canada was wearing clothes that had been made in this factory. And that brought another level of public awareness and stakeholders and consumers awareness to another aspect of responsible business conduct, because before we thought, well, it's diamonds and gas and so on. Public response led to government response, led to these measures and trying to provide the advice to businesses how to do this. It's not mandatory, it's not legal requirements, but our lever is we encourage responsible business conduct. And for my department in our trade promotion policy to be able to help people, we actually say to businesses, you need to be lining up with this, or if you're not, or if there are real problems, we'll start to pull back on the assistance, including trade facilitation funding. And if you can't get insurance to sell a multi-million-dollar widget, it starts to get hard. So here are the points where I'm going to try to draw fire away from you so I get more complaints. We don't have mandatory human rights due diligence. But I have a 6-page analysis from the core on the EU proposal to do mandatory human rights due diligence. And there's interest in Canada in this EU initiative because we see it as leveling the playing field. Because we see, or at least we can imagine, that for some Canadian firms, even where we only have soft tools, Canadian firms may feel that they are at a disadvantage operating under our extremely flexible levers compared to companies that may be based in EU member states, which will remain nameless, which have nothing. And so there is a very great interest for Canada, with EU being our #2 trading partner, a market with which we have a free trade agreement. We too would like to see a level playing field in the EU. Don't ask me now if we're then going to sync up with that, but there is some interest. And the other thing that I'll point out, I've been sitting in the back taking notes and trying to read up and learn. Earlier this year, there was a Supreme Court case in Canada, which called Nevson, which decided that, in fact, you could take a Canadian company to court in Canada for human rights abuses that had taken place in Eritrea. Now, so far, it hasn't been decided if they're guilty, if they're actually liable. The Supreme Court has opened up the question of applying a Canadian corporation possibly facing consequences under an aspect of public international humanitarian, human rights law, not humanitarian. Now, to get ahead of you, the things that stakeholders wish would be different. There are civil society organizations in Canada who would like mandatory human rights due diligence. There's also been complaints that the ombudsperson is not an investigative function. They are not judicial. They can't levy penalties. they can refer to the Royal Canadian Mounted Police. And so they can say, well, this looks like it's worth going to a criminal. And honestly, many other Canadian ombuds type roles have that duty, essentially. If you see a crime, if you see what you think might be a crime, you tell the police and you pass it to the police. We don't have a national action plan. Yours looks very nice. And we don't actually have a statutory basis for the ombudsperson. They were created on a regulatory basis by a decision by the government. And so the other thing which I've spent a week trying to get my head around, and I still don't have straight, is that complementarity. I found about 3 or 4 Government of Canada web pages that all say that the core and the NCP are complementary, but I couldn't draw you the line between the two, and that's an interesting challenge. Looping back, you've been very patient, thank you. But I actually wanted to sort of echo what you'd said, and those arguments about, well, how does business align with human rights? And the key parts of it are about the social contract. 15 or 20 years ago, we were thinking in terms, many times, of the social contract for our mining and oil industries to be operating in developing countries, or to be selling diamonds, or honestly, to be competing with conflict diamonds from our non-conflict diamonds. But from that, I think there's been a germ in public understanding and awareness of other impacts of responsible business conduct. And I think that's welcome. And some of this is a shift. 5 years ago, we would have, as Government of Canada, I would have been talking about corporate social responsibility, and we're broadening that out and working. One of my challenges in preparing to speak here was that most of the materials that my government provides me are actually designed to talk to Canadian companies. And we have sector-specific items for the extractive industries, for garment industries, and so on. Thank you very much. As I said, I've been long, but it's as I said, I found this a really useful conversation, and I hope I can sting some other points.
Thank you very much. We also have Marta Miswaiti with us. She's also prepared her speech. And Marta, she's an expert on social business. Marta, do you hear us?
Yes, hello. Can you hear me well?
Yes, perfect.
Okay, perfect. So first of all, thank you so much for the invitation to participate. And I do appreciate the opportunity to reach you virtually or remotely. So yes, just to introduce myself quickly, I'm a business sustainability consultant, or I was rather. Now, as of a couple months, I'm working as the sustainability manager at Ignitis Group. And Ignitis Group is one of the largest energy companies in the Baltics. So I'm very happy to be able to represent the business perspective as well as Lina in this panel. However, I have to say that this is probably not going to be a very controversial panel, because I completely agree with all the perspectives shared by all the panelists so far. I just want to maybe just reiterate some points that I couldn't agree more, that business cannot be successful if it's not in a successful society. And I just want to expand maybe to go more towards a conversation about challenges. So I think we all pretty much agree about what needs to be done to integrate human rights in business practices. But the question of how to do that is really something that keeps me up at night sometimes as a sustainability manager. So just to give you one example, I really liked what Lina said, that we can have human rights policies in our companies, but we don't want them to just be something that sits in some corner of the office. We want them to really come to life and achieve concrete results. However, in the area of human rights, how do you set KPIs? So for businesses, what gets measured gets done. And I think that it's really sometimes challenging to set the goal for a business that would be really focused on not just assuring human rights, making sure there are no violations of human rights, but actively promoting them. So really going from a reactive approach, a risk aversion approach, to a proactive diversity promoting, human rights promoting approach. When I worked as a business sustainability consultant, I noticed that sometimes companies have a KPI in the field of human rights that would be something like, we aim to have 0 reports of equal opportunities violations. But does achieving this number, does it mean that there were no violations? Does it mean that people didn't know about the opportunity to report? Or does it mean, even in the worst case scenario, that people were too afraid to report because the situation with human rights in that company is so bad? So this is just an example that it's really challenging, I think, to really set KPIs that measure real results in the field of human rights for business.
Thank you. And we are coming back to where we started, how to make sure that the plan, for example, is not just formal plan, how to make sure that the policy we agreed on is something we truly believe in and truly focus on every day, and make sure that it happens in that way. Sandra, I would like to ask you, because we had also this question before, what works better in a business case? I don't know, Hall of Fame or Wall of Shame? Do we need to shame those companies which do not align with human rights and find the examples, the bad examples, and make it public? Or maybe it's better and it works better when we just show good examples and say, well, look, this company does this very good. We should, I don't know, give a medal for it every year for the best companies in the human rights field. What works best? And does it help to make the policy not just formal?
Yeah, thanks, Anas. It's a really good question. And I think that the answer is that we need both the stick and the carrot. Because one thing is, if we want to be a little bit, if we want to be realistic, just by publishing good case stories doesn't make the majority of world's companies to follow. However, I do see with a lot of companies that we work with is that public criticism, reports from NGOs, stories of journalists, it really gets companies going. Now, I don't want to say that that should be our main vehicle to get things done, because we also know that reactive responses, and I do agree with what you said, Marta, we don't want just to be putting out fires, we want to be proactive. And you will not achieve being proactive if all you have is the stick, right? So I think what you need is a consorted kind of effort from different angles. And I think that's why I think we need both, what you suggested. We need the leaders to inspire others, and we need criticism to make sure, because also even companies that have the best policies and the best processes and the best reports and even the nicest KPIs, even they will have things that go wrong out in the field. And so we need that vibrant public civil society that is able to voice freely criticism and use freedom of expression, so that we know when something is going wrong. And to me, a very good practice is when companies are listening proactively to their most critical friends, because if you do that, you can actually save money. You will actually save money because it will be an early warning signal for you. So if you want to not spend money on people like me, consultants, but rather be ahead of the curve yourself, then of course, listening to civil society, not just when they have written a report, but having a frequent dialogue, I think is one of the keys to be in that successful company that the panel has talked about.
Thank you. Also, we have a quick question about the policy, and I would like to come back to you, Elena. How your company decided what policy it should be? Was it a really easy question for everybody to agree on? What is human rights are for us, how we see them, what are the most important parts of it for us, how you made the policy, and is it now also very easy to understand what policy wants government from the government?
Okay, thank you. Since the policy was written 7 years ago and I wasn't the part of the writing, I do not know how consensus was reached, whether it was fighting in the boardroom or everyone voted, yes, this is okay. I can mainly say how the policy is being kept alive today and how we sort of check in with ourselves whether we're keeping. So at the moment, from the human rights policy, there are possibly the 4 main points that we pay attention to. So diversity and inclusion and gender diversity is a very big one. And I can later we'll go into the examples how we do it and what we do it rather than just talk about it. Then the labor rights and the right of having the right environment and fair pay and things like that. Obviously with the GDPR came all the privacy rights. And we also want to pay attention to the vulnerable groups. So whether it would be national minorities or disability or any other thing that makes a group minority. So if to talk, there was a second part to your question which I wanted to.
Yeah, I will explain why I asked this question, because we also heard that it's very important to make a social contract between society and company, for example, in this case. So do you think that those things you highlighted, they are same important for your customers? And is this because you chose them? Do you make a research that our customers usually are focused on these things? That's why we are highlighting them and we're working towards reaching them. Or you thought that, well, this is important for you and our customers, well, they will just need to follow us in this case, because that's the company we would like to be. Like, in which, how it worked?
I think it's the company we want to be. And the policy itself is based obviously on the human rights declaration, but as well, we look at the 17 global goals as well. So, and I think if you are active in lots of different areas, you will find within your customers the target group that's important, right? When we talk about the gender, possibly those who like female, usually in Lithuania, that will echo with them. If we talk about the sustainable business, and as business, we have declared that we'll never make business or invest or loan or have any ties with a business that does their business unethical, for example, have any relations with gun making or I don't know, recently we actually included in that list people who invest into like coal mining because that is not sustainable long term and we don't want to support that. So that's the code of business. And then on the other hand, this was mentioned, the Deloitte report. So actually that theory we see in practice. When you are vocal about it and when you talk about the responsibility, because we want to be a responsible business. And the benefits are that when people come, I actually work in recruitment myself within the HR as well. So when people come and say, we choose to work for you because we like what we've seen you talk about. So we think it's important topics about talk. It's not enough talked about in Lithuania, for example. And when the national plan was represented, I was smiling to myself behind the mask because I thought, well, we have everything. There's nothing for us to do anymore. Like we've done, but honestly, I'm joking here. It's not to fall asleep on the laurels. So I think it's important for business to not to only say, oh, it's important for the society, that's why I'll do it, which could be one of the motivational factors. But our aim as a business is actually to educate society as well, because long term is beneficial for everyone.
Thank you. Marta, you told us that it's already 2 months, right? You are working at Ignitis Group. And what was the beginning of those 2 months, and what now are you focusing on? Well, was it Ignitis Group decision to try and be more sustainable in development case, and that's why they were looking for improvement for the policymaker, and what do you see in the company now?
I think it's the motivation behind our commitment to human rights or to sustainability and sustainable development goals more generally comes from two main drivers. So the first one is definitely just the value base of the leadership team. I think that's always kind of the first step. However, in order to get our very, very large company on board and to leave no one behind, we have to then at some point, the value arguments have been kind of exhausted and it's clear what we have to do. But in order to get the rest of the organization on board, we have to start pulling out business arguments. And there are plenty of those. So for us, it was really not a difficult decision to commit to the promotion of human rights and diversity. It was really, I think that this conference, so many speakers mentioned very good reasons of why businesses should care about human rights. So maybe I will not repeat those arguments, but just to say about what we are trying to do now. So we very recently updated our policy for equal opportunities and diversity. And we were very, very explicitly intent on including the word diversity in our policy. So really trying to move to this proactive approach that I was talking about. And our goal is, of course, as I mentioned, not to have something that's just a document, but to really help it come to life. And so right now we're in the process of developing very, very specific guidelines so that we have a uniform approach across the whole company, across our more than 3,800 employees to really not just promote human rights, but actually to engage stakeholders. I think it was Sandra who mentioned this point that you don't have to, as a business, decide kind of what human rights initiatives you should undertake. You can also ask the people directly, the people around your business, the people inside your business. You can ask them how your business affects them, and then integrate all those responses into your own initiatives and decision-making. So this is kind of where we are right now in developing a stakeholder consultation model, also involving not just our direct stakeholders, but also NGOs that have very specific competences in this area to really make sure that we have the result that we want to have when we commit to our policy.
Thank you. But is there an issue to understand human rights in the same way? And Richard, I would like to ask you, do you see difference how we interpret human rights here in Lithuania and in Canada? Do you think that we see it in the same way?
So actually, one of the things I like about working in Lithuania is that on a lot of things, we're extremely like-minded. In how Canadian approaches frame it, when we say human rights and business and human rights, we're taking a fairly expansive definition of human rights. It's not just civil, political, but also including environmental, social, labor. And so this is one of those places where going from CSR up to RBC and having that larger lens helps. We naturally, particularly if you have, I keep on going back to mining, but anyway, if you have companies which are operating in countries which may have more different understandings or approaches to human rights, then you end up with some level of conflict. And that's one of those things that actually shows up interestingly in this Supreme Court of Canada decision from February, where they sort of said, yeah, well, it may be okay in Eritrea, but it's not okay to our understanding of international human rights law. And so applying that. Extraterritoriality is something that Canada is not generally a big fan of. But in this case, we are asking Canadian companies to sort of take the floor between the Canadian standards and the locals, take the Canadian standards as being at least the floor. If they're operating in a place that has higher standards than Canada, we'd love to send us notes. But otherwise, just because you can get away with it somewhere else doesn't mean that you should necessarily be doing so. You should be holding yourself to a higher standard. We have 2 Canadians who've been in jail in China for 641 days because we are having a dispute with China about what they view as a commercial state-to-state dispute and what we view as an enforcement of our extradition treaty with the United States. So there are countries which may have very different understandings of the rule of law. And some of those countries may be extremely important economic partners. And an ongoing challenge for national governments is balancing that. And this is one aspect where maybe talking about the multiplicity of stakeholders is useful in Canada, and I think in Lithuania as well. The public as consumers, maybe to some extent as investors, definitely in Canada, there are elements of the investor activity as well, are another stakeholder that will hold Canadian companies to a higher standard than the baseline of what Canadian law requires at this time.
Thank you. And since we're going to the end of the discussion, I would like to also to make a conclusion and to come back to this national plan we heard about at the beginning, and to ask, maybe firstly, Julia, do you think that such plan will make life for business in Lithuania easier because you have a tool which you can implement, which you can follow, or maybe it's just harder because, well, everything that government makes usually makes businesses' life harder?
Great question, actually. I'm really happy I came here because I've never heard of this plan before and it being prepared. So I actually made notes. Thank you for inviting me. This is maybe to reflect, do we need this plan and how can we make businesses change? There were comments here made about building awareness and awareness of the businesses and the society, so it starts demanding, but I think that would be a very slow process. Usually education process is very slow. So I'm thinking the initiatives like this plan are really needed. For those businesses that want to change something, it's definitely a massive help. I understand that not every business is like our business that can have the whole department working on it. Not everyone can afford it. So actually the help from government that says, these are the guidelines and this is what you should check and this is the help you can receive, it's certainly. And for those who don't want, perhaps that would be a burden, but it's for the greater good, it's also an educational value with a stick and carrot.
Marta, is it a help?
Yeah, I completely agree. I think that any kind of additional guidance is appreciated, and businesses who are kind of already looking for ways to go in that direction will benefit greatly from the additional guidance. I think of particular value is kind of the role of the government as a facilitator. So also bringing businesses together with NGOs just to share best practices. I think what works really, really well for businesses is hearing from other businesses about how they do things. And that really kind of creates this almost peer pressure or social pressure to perform, or it becomes one of the performance indicators. And I think that always works. And I think it's also a very quick and effective way to raise awareness and reach results in businesses. I think I applaud the plan, although as Lina said, I hadn't heard of it before prior to this day. So I will also be looking forward to kind of going more in depth into the contents of the plan after the conference.
Sandra, also a question for you, mainly the same. I'm not sure if you knew about the plan or you saw it, but my question is, does having very strict guidelines helps for business to implement policies and to be more aligned with human rights than before? Or we should leave it for business to make its own?
Thank you for asking the question. Well, I think it's tricky because on the one side, companies are not equipped to manage human rights. Companies are not intuitive on how to manage human rights risks. And I think this is important to acknowledge, because just as companies need technical expertise on environmental standards or health and safety implementation, or even technical areas wherever they're operating in, somehow it often seems with companies that they have views on human rights and therefore they are self-appointed experts. I'm not saying everyone, but we sometimes meet that. And so to answer your question, I think that it is important to have guidance prepared by people who are informed and have expertise on human rights standards, specifically when it comes to interpretation of what different human rights in different situations mean. So I think that guidance I think that all guidance is welcome. I mean, because governments are the ones that are better equipped and capacitated to make interpretations of what international standards mean. Because remember, what we're doing is we're drawing out principles from conventions that were originally developed for states by states, and we're trying to apply them now to business, right? So I think it's absolutely suitable that governments do that, and then to the degree whether that is enough, I think it will vary with company to company whether they will actually look into it. Some companies will probably say that they need more guidance, they need more guidance, and they need more guidance, but they haven't looked into what's actually out there. And other companies actually diligently apply and look into what's out there because they're really into the process of doing it. So I think you'll find quite a big range of how useful guidance is. But absolutely, yes, governments should provide both plans. And I think they should also set demands of their own companies. That is completely in line with the guiding principles as well, to say, this is what we expect of companies, specifically, of course, that are state-owned and state-controlled, but of companies in our country. We expect you to do this and in this way. So I think it's good and needed.
And how to make that educational part to educate businesses that, well, these are the guidelines you need to follow.
Yeah, I think that's just building on the same. Absolutely, I agree with you that to provide and offer training. But again, there is a certain amount of companies that will be interested in the voluntary stuff, right? And then there will be others that will only react when there is legislation or when there is a disaster, a scandal, or something else. So I think you will get to some companies, but not all by using the voluntary field of tools, so to speak.
And if I may also just add something to this point, which I appreciated very much. I think the role of the government is also to make sure that even the businesses that are, let's say, the most advanced in promoting principles of human rights, that acting in the best intentions, that there are no unintended consequences. I was recently made aware of a study that showed that actually very big attention paid to child labor in the supply chains of several multinational companies led to those companies moving away from suppliers that use child labor which is a very big achievement for human rights. However, those child labor in those countries where those suppliers were based moved to more precarious sectors, actually resulting in even worse conditions for the children working in those sectors. So, and this is the type of unintended consequence of very, very good intentions of businesses. And I don't have an answer in my head as to how a business could prevent that. I think that at some point there has to be kind of additional help from the government to make sure that even when business is acting with the best interests of human rights promotion in mind, that we don't have these kind of very unacceptable results.
Thank you. So I had a different follow-on to Sandra's remark, but also sort of Melina's, that one thing that we are aware of, and the reason why I have a website full of handouts for companies, is that not everybody's sweat bank with a department who are going to think about this, and not everybody, sorry, is going to be able to hire Enact to tell them how to get the things straight. Sometimes we're dealing with a small exporter, a small and medium enterprise who really just think that they just need to sell something, and we need to spoon feed things to them. We need to sort of say, here are the 4 international obligations, but here are the things you need to think about, or here's the things that you need to think about before you go any further. And so you have to adjust, or you have to be aware of the diversity of the needs from your companies that are involved. I mean, I applaud Swedbank Limitis for participation and so on, but at least my government is desperately trying to encourage small and medium enterprises to participate in international markets. And another side of that is to say, great, we love that you're coming here. This isn't like going over the border to Quebec.
Well, it reminded me when you said that we need to, some companies, we need to spoon feed, with the information how to make it happen. And I remember when at European Union level, we had this GPR where every company had to make sure they understood correctly. So what we did a lot of consulting work with small businesses. So maybe it's something similar that we need to do with human rights as well. So thank you very much for the discussion. I had a lovely day with you, and I hope you too. And have a great day, and enjoy life.
Thank you.
Thank you. Thank you, Anas, for today.
So thank you for all of you who participated in the conference, and you've been very patient listeners. And I do believe that our conference became certain food for thought for everyone. I hope that many ideas which were discussed today will become an inspiration for our tomorrow's work. And I have to say a few thanks for the people who been there and helped to organize this conference. Firstly, I want to say thank you for all the panelists who participated in the last discussion, to Lina, Marta, Richard, and Sandra. All of you are very busy people, and somehow every one of you finds some time in your schedule to come, to reschedule other meetings, but come here and be with us, either virtually or online here. And thank you, Darius, for your kind support to prepare for the conference and prepare these 2 last discussions on National Action Plan and the discussion with the business, because for one person it's quite hard to manage everything, and you did a great job here. And definitely we also want to thank our partners. Firstly, to Ministry of Foreign Affairs, Aiste and your colleagues, you did a great job. You always supported us both intellectually, academically, and always strived us to go for the best result Thank you for Nordic Council of Ministers Office in Lithuania. With your sponsorship, we had a great conference. With all the discussions with Lina, we did a huge job before the conference starting from January of this year. And definitely thank you for our university, especially Professor Lyra Juklevičienė, who is the dean of this law school, who supports our craziest ideas. So we're coming and saying, let's do it. She says, okay, let's do it. And I hope that you enjoyed this time, and fingers crossed, let's do it next year again, but in a normal way, not virtual one. Okay, I see that Professor wants to say something more.
Okay, I think I need also to thank, because he will not thank himself, our main organizer, Arnas Liausminas, and also the co-organizer, the head of the Human Rights Laboratory, Katarzyna Mikša. So I think it deserves a big applause. And of course, thank you to everybody who...
Okay, so with these words, we are saying that the conference is closed, and see you next year. Bye. Labai ačiū, kad ačiū pavyko ateiti ir svarbiausia tą planą pasakyti, gerai, kad mes nepakalbėtume lengviau bendrauti. Yra daug klausimų, kad... Tai va, gerai, gerai, ačiū, labai įdomu. Aš intrigavau. Ačiū. Kaip čia geriau? Ačiū.
On both sides.